Good morning. Good morning. Good morning. Good morning. Welcome. Welcome. What's up, everybody? Gotta change the lighting. It's kind of looking a little yellowish. I don't like the yellow. But good morning. What's up, everybody? Thank you for stopping by. Today is a big day, I guess. Un día grande. The cross examination. And man, there were so many updates with the Kansas City 3. Los Tres. And it's Friday. It's Friday. Let me get this thing. I don't know what's going on right here. Okay. Boom. They're getting set up in the courtroom. If you guys can hit the like button when you walk in. Oh, for a second, bro, I thought this was the attorney. Wait, is that her? No, that's not her, right? Wait, that's not her, right? Oh, somebody. I'm about this. Oh, she's right there sitting down. Bro, I thought that was Jen for a second. I was like, what the heck happened to her? She's sitting on the side. Okay. Good morning. Morning. I wonder if they got it. What's going to be the other witness that they bring after Jen? The baby bird heads. They're arguing yesterday about opening the door and stuff. So we will see what today brings. By the way, did you get a notification? Let me see. Let me read this before I Bernice, thank you so much for the cash app. Early. Said happy Friday. Happy Friday. Let's tell Maddie this morning. I was like, baby, it's Friday. She's like, yay! She was like jumping and stuff. You know what? I should. Let me wait on that. Oh, okay. Astastic. Thank you for the 13 months. It's Happy Friday, Mel. Happy Friday. Happy Friday. How about a poll? Has prosecution proved egregious neglect? I watched a little bit this morning. Sorry, I'm still tripping. I watched a little bit this morning of Laura. I didn't get. The mornings are really tight because I get up, get the baby going, and rush back, and then there's like maybe 20 minutes, 30 minutes. But while I was kind of getting ready, I listened to a little bit of his stream from last night. I might play some snippets a little bit later about what his thoughts were. The whole thing with this chick says she's gonna off herself. I believe his comments to that is he never seen something like that before in the courtroom in front of jury. But he made some comments about the good things she's done and maybe some of the not so good things that she's done. You got a notification? Great. Fantastic. Excellent. Peter, yeah, he's a really nice. He's a good guy, man. I spoke to him one time on the phone, and he just as he's on stream, he's on the like offhand conversation, and his channel's doing great too. He does the highlights and stuff at like the end of the days. Is that what he said? I said it was powerful. Lawyer, agrees. All these lawyers are trash. I said it was powerful. He's a good guy. All right, give me 1 second. No, don't. Haven't started yet. Nice and oh, let me fix the light. Has like different shades. There's one that's like a little bit. Can't figure it out. All right. I think I'm good now. What's up? Good morning, Honeybee, Ali Nolani, Belinda, Hoax, BL, Purple, Passion, Mary, Ivan, Natalie, Gamer Love, Bonbon. What's up? Let's see, I posted videos on the second channel last night and over here on the main. I didn't have any notifications, but it worked out anyway. So the tox report came back finally for the Kansas City 3, which I don't think they've officially released it. Families were supposedly told by police. And so there was like THC, Coca-Cola, and Fent. Which, is anybody surprised, right? Really? And I watched this doctor last night talk about it. He gave his opinion, some doctor, and he believes that they froze. I disagree with him. I don't think he had the fentanyl knowledge yet, though, because when he was talking, they were theorizing if there was fent, but there was fent. I think with the amount of fent that was in there, I think that's what did it for them. The cold came after. I don't think that they were passed out but alive and then the cold got them. I think they passed away from the fent and then they just froze from being out there. That's just a theory, though. Some people think they passed out and then were alive but froze and died because of freezing. And then there's other theories too, I guess. The thing to me, though, regardless of how you think they, well, if they froze, then you could explain Jordan being alive. But I don't know. I think even if Jordan had a tolerance, I don't know, 3 times the amount of fent. I sometimes say I still don't think people sometimes understand how strong that is. Even the doctor that I disagree with his opinion on how they die, because we don't really know yet. We're still waiting on that. He had said that I think that was like the strongest one out of all of them was fent. How strong it is. I mean, you see that guy that in that one video, I think it was opioids or fent. He just sprayed a little bit under somebody's door and the household was getting sick. And I don't know if the baby died or the baby was getting sick just from spraying under the door. I mean, it could make sense how maybe this guy just passed out for 2 days because he was high out of his mind, allegedly, you know. Carly says, I shared a story on Discord, and it's literally the exact same story they did. Coke and Fent woke up. Wow. Can you send that to me, too, on DM? Where'd you put it on the links? I'll try to take a look at the links. There's so many things that I want to do, but the trial takes up the whole day, and by the time that we're at the end of the day, I'm just, like, tired. And then we're rushing to do Kansas City stories. There's not a news story, but there's a crazy old story that I want to do and edit, like the Frozen couple, but that's gonna take me some time to do. So I don't know, at some point I'd like to drop that video. I think it'd be really interesting for people for those that haven't heard of it. And the Frozen couple videos at 141,000, which is cool. That's nice. I'd like it to get even higher, 150, maybe 200. That'd be dope. Deb, thank you so much for the 10. Appreciate that. Much love and appreciation, Mel. Thank you, Deb. It's in the links. BLDM. Okay, let's see. Oh, thank you. Okay, Bill, send me the link you sent, Carly. Thank you. That's interesting. Yeah, we could check it out because sometimes I like to look at similar stories and kind of compare and contrast. That's how you say it. I mean, the thing that stood out to me a lot with the frozen couple, it was kind of vast, different, like a different situation, but in somewhat some similarities, somewhat. But even though they had the wherewithal to call police and all that, they weren't on fence. I think it was just, you know, the speedy stuff. I think that's what it was. And anyway, they had partied at some people's houses. It was a mother and a son that allegedly provided the substances, but they couldn't prove that. They just know that when they went to search the house, they found substance in the house. And so the mother and her son, all they were charged with was possession. And so the thing is, too, like I'm thinking, a lawyer could probably talk better about it than I could, but I'm thinking like they would have to tie that Jordan maliciously did this or like on purpose. I don't know if they could charge him for like just if they went to his house and found substances, which I don't even know if they really searched the house like that. Supposedly that he had let police in before he had an attorney, but I don't know if they were looking like that. Or honestly, with the 2 days, you have time to clean up and get rid of stuff. A lot of people that get caught with substances and then cops come knocking on the door, that stuff is flushed or tossed away or whatever. So can they even tie it back to him? Amy, thank you so much for the gifts, the 5 memberships. You're the top member gifter for this month. I want to jump on this weekend and do a little bit of something with the members. Gifting Queen. Demico made me want to block the front door with a rolled towel. All that beer. Yeah, 60 beers, I guess. Yeah. That's the other thing, too. With that kind of substance, Fent, and then mixing beer, alcohol, it's got to be bad, too, you know. And I think, I don't know if Hoax, I know one of my other friends said it as well, the theory of that, like, you know, they went outside to smoke. And they were out there smoking, and that's when they hit him and passed away, like laced with like a weed or whatever, hence the THC. But it doesn't mean that they did it together. They could have done this stuff separately and then smoked weed to try to negate the effects or anything they were feeling. One of my other friends said that maybe they were railing Coca-Cola and they were already messed up, and then they went and railed the wrong stuff, railed Fent. That could be another possibility that happens too. Look at Jeffrey Dahmer, drugged himself. He was already drinking and intoxicated, and then he was supposed to poison his lover.
Jennifer Crumbley, case
and he poisoned himself.
279-990-FH.
Good morning.
Good morning.
Karen McDonald on behalf of the people.
Thank you, Marquise, on behalf of the people.
Guard David Williams on behalf of the people.
And good morning, Shannon Smith on behalf of Jennifer Crumbley.
All right, you may be seated. As seems to be the theme, issues came up at the end of the day yesterday at the close of the defendant's direct examination, at which point I invited both sides to submit anything that needed to be dealt with in the morning or that you wanted me to consider for purposes of going forward with the cross-examination, correct?
Yes, sure.
Okay. And so in the early morning hours, as is our habit in this case, I received a filing by the people. So I want to let the people make a record of that.
Thank you, Your Honor.
You can move the podium if you like.
That's right, Judge. Thank you. Judge, as the court is aware, the issue of flight has been important from the start of this case. It was part of the bond motion. The allegation has always been by the prosecution that the defendant was fleeing from prosecution, that in contrast to the public statements by her attorney that she was not returning, that she was not turning herself in. We recognize that made her attorney possibly a witness in her defense regarding flight. We pointed that out. We pointed out repeatedly. We asked the court to include that as part of a waiver. She consistently waived her right to have her attorney act as a witness on her behalf. Yesterday, she testified that essentially her defense to flight is, I was in touch with my attorney. I was taking the advice that we were going to turn ourselves in, and I was just waiting on direction from you. speaking about Ms. Smith. Judge, under the case law in Michigan, and particularly I think how is helpful, she's waived the privilege. She cannot use that as a sword to present in her case as a defense to flight and then say, you can't see those messages. We're entitled to see if those messages are in fact consistent with her attorney's public statements and her testimony. What we've done is had the officer in charge have another member of his team pull out those messages, put them in a sealed envelope, and bring them to court today. And we'd like, they're short, Judge. I think there's a total of 23 messages. And what we'd like the court to do is review those and determine whether the court believes that they are relevant to the issue of flight and whether the defendants were turning themselves in.
Okay, well, there's been a number of phones with a number of extractions. I think I'd like Mr. Williams to go even further back because there was this people's notice about assertion of privilege, correct?
Yes, Your Honor.
Okay, so can you describe that for the record?
Judge, so what happened was we had a total of
This was before the trial.
Yes, Your Honor.
Okay.
I raised it with the court on January 12th, I believe. It might have been the evening of the 11th when, frankly, I personally was reviewing files in preparation for trial. What we have is 6 cell phones. They were all extracted, downloaded into a program called Cellbrite so that we could review the evidence on those phones.
Okay, 4 of those were in the possession of the defendants and 1 was the shooters. Is
Yes,
that correct?
Judge, what we have is we have their 2 phones that were seized from them right after the shooting.
Correct.
And they were found with 4 phones, that's 6, and there's also the shooter's phone.
Okay.
So the total of 7, 6 associated with the defendant. We were and so in reviewing those, when we determined that there were potentially communications between counsel and the defendant back at the beginning of the case, those were stripped out by the sheriff's office. So we would not see those, would not have access to them, would not come across them.
Okay.
When I was reviewing photos that day, I was looking for a particular photo. I came across what appeared to be a screenshot of a message. And even from the screenshot, there were a couple of words that stood out to me. It was clearly relevant. I could not see who it was to and from. I opened it. As soon as I did, I could see Shannon Marielle at the top, and I closed it.
Okay.
That was inadvertent. But because I saw the timestamp on that communication, it was clear to me it was potentially relevant. So I brought that to the court's attention, to the defense attention, and said, do they want to assert the privilege? And they said, yes, you can't see that. Okay. We did no further investigation.
Right.
And so now the defendant has testified and she has waived the privilege. She's now relying on her attorney's advice and testifying that that's the basis for her claim that she did not flee.
All right.
May I respond?
Yeah.
Your Honor, I have not seen what the prosecution has uncovered.
Well, they haven't seen it either.
The transcript.
I don't even remember, honestly, what texts there were. I have no memory of this. But what I will say is when I had my client on the stand and I was asking her what her intentions were, I was asking her what her plan was, and I thought her testimony was going to be, I planned to go to Novi on this day at this time. I didn't plan for her to say, my attorney told me to do this. That was the plan we had. That was what I was in touch with Miss McDonald about, but she wouldn't call me back.
Okay, I don't know why you keep telling us that.
Well, I'm just saying, I didn't mean to open the door. So I would ask, I didn't mean for my client to open the door. I would ask the jury just be instructed that whatever was discussed with the attorney be struck from the record and move forward.
Wait a minute, struck from the record what she already testified to?
Yeah.
That is not happening.
Okay, then I object, Your Honor. I don't think that my client opened the door to all privilege being waived. And to be honest, I don't even know what they're talking about. So until everybody sees it,
Okay, well, you want everybody to see it?
No, I don't. I'm objecting to anyone
Okay, what do you
opening
mean
it.
everybody's seeing it? Though he's specifically saying that there are potential texts between you and your client. So an investigator may have extracted this information, or presumably the prosecution has not seen it. But if it's a communication between you and your client, presumably you have seen it at one time.
I don't know that it's between me and my client. It says Shannon Marielle on there. I don't know which of the phone numbers they saved. I don't know.
Okay,
I have no text on my phone, so I don't know. I went through to look through my own phone. I don't have anything. I don't know what they're talking about. Even the screenshot he sent, I don't know where that came from.
Well, Judge, then
Do you know
obviously,
which phone it's from?
yes, it's from the defendant's burner phone. And we can tell that because of the context of the other messages on the phone.
Okay, so it's her phone.
Her phone, but I don't know who. At that time, Marielle and I were both in touch with Mrs. Crumbley, and that's
It doesn't matter who it is.
Yeah, I'm just saying, I don't know if Marielle sent texts. I don't know who the phone number is that's called Shannon Marielle.
Okay, but I guess the thing we're grappling with here is whether or not your client, obviously the privilege belongs to her. The privilege is like the theme of this trial, right? So the privilege belonged to her. So really the question is, whether or not she waived the privilege. I would have to say that this would be a dangerous precedent. To be honest, Mr. Williams, when we ended the day, as we do every day, with a upheaval, I assumed that your concerns were the fact that she testified that she went to bed at 11 o'clock, took 4 Xanax, and then was later asked when the police came into the room, were you, this is an exact quote, were you aware there was anything going on? No, we were not. And and that would have been at 1:30 in the morning per the body cam. So I thought that's what your concerns were directed at.
So, Judge, I think the testimony was there were a swarm of officers on scene by 11:16 a.m. And then, in fact, if the
Was there? Okay.
PM,
So,
I'm sorry, PM.
okay, we were, I'm put in a difficult position because some of these transcripts are not immediately available. But I had my staff, who's probably on the verge of resigning, based on my requests of them, pull testimony of David Shaw. Didn't David Shaw say he was there before midnight, got the call at 11:30, was on call, it was 25 minutes away, was at the building an hour and a half to 2 hours before entered where the defendant was at 1:33.
So, Judge, Mr. Kirtley testified that he called 911, that was at 10:43 p.m., that there were officers on the scene within 5 to 10 minutes, and then as soon as they found the license plate, there were swarms of officers. That is what happened. I'm not sure about the other testimony.
What time was the first officer on the scene?
It was before 11.
It was someone before Mr. Shaw.
Yes.
Oh, okay, so I told the wrong officer. What's his name? Kirkley?
May I just, so Corporal Shaw was a member of the Detroit SWAT team. So he was
he was a
recalled.
SWAT. Okay.
That's right, Judge. So he was recalled once officers were already on scene and set up a perimeter.
Okay.
The testimony that came in through Mr. Kirkley, the individual who called 911, was that he called 911 at 10:43. Then we watched the video where he walked into the building. At the end of the video, you see the 2 Detroit police officers pulling up on scene shortly before 11 o'clock. His testimony was that he met with them, and then there were swarms and swarms of officers.
Okay.
And so, Judge, it's relevant just in the fact that the defendant is texting anyone at 11:16 p.m., but it's especially relevant that she's commenting on her status and now saying, the reason I didn't give myself up is because my attorney told me not to.
Well, I already agreed with Mr. Keast last night that he would, I guess the theme is you can't use your shield as a sword.
Yes.
So I already agreed with Mr. Keast yesterday that he could ask the defendant, you said that you were asleep by 11 o'clock.
Yeah.
Isn't it true that you were texting your lawyer as of 11:16? So that's already a ruling of this court. The question now is whether or not I'm willing to go farther than that based on the privilege and the dangerous precedent.
Judge, I think the case law is clear. The defendant didn't have to testify and she did not have to rely on her attorney. I also think Ms. Smith's argument that she was just going to say she was going to Novi, well, she would not have known that on her own. That was clearly information she got from her attorney. So what she wants to say is, Judge, I didn't know what to do. I was relying on my attorney. I wasn't fleeing. And the question is that in fact what she had been told, or was she doing that on her own? We'll only know that if the court reviews these messages in camera. It doesn't mean they're admissible. What it means is the court will determine if they're possibly relevant, let us see them, and then of course we'd have a discussion or a ruling on whether or not they're actually admissible.
Okay, what did you say? You know, I've seen some of the extractions, piles of extractions from here, so I guess I don't know what you'd be referring to. I don't know that I'm willing to do that. That sets a dangerous precedent.
Judge, I don't think it does to do it in camera. Privileges can be waived. And
I know privileges can be waived, but it's a theme of the trial. But the problem is then I'm making a determination about what's in and what's out in the middle of the trial, right? And
No.
and potentially invading her privileged communication with her lawyer.
Judge, I'm not asking the court to make a call whether it's in or it's out. I'm asking the court to simply look at it and see if it goes to the issue of flight, then allow us to see it, and then there would obviously be an argument of whether it's relevant and admissible.
Okay, you're asking me to review it and see if it goes to the issue of flight.
Yes, Your Honor.
Okay, because that's another thing that I was thinking about. What if she makes some admissions to her lawyer about this case?
Those then, Judge, if they're just about the case, we would not be entitled to see those.
Okay. All right, what else, Ms. Smith? What else?
Judge is annoyed.
Your Honor, my client does not waive privilege. That's the position she's taking. So whatever the court says.
The question is whether she waived it on the stand. What were her exact words?
Judge, she said, the question was, Ms. Smith, all right, so what? Okay, so you know your charge, which, by the way, Judge, they knew they were charged. They suspected they were being charged on December 1st. There are text messages not to their attorney on December 3rd at 11:30 a.m. saying, we have been charged. So she knew she'd been charged. Ms. Smith said, so you know you're charged and you know they want you. What was your plan at that point? Well, I was in touch with my attorney, Ms. Smith, me, you, is the answer, Ms. Crumbley, you. And I was taking your advice that we're going to turn ourselves in. And then further on, Ms. Smith, okay, ultimately on the night of the 3rd, were you aware on Friday afternoon if you could go into court that afternoon? What was your awareness? Defendant, I was not aware that we could go into court that afternoon. I was just waiting on direction from you.
All right, I'm going to take a brief recess.
All rise.
All aboard. The judge doesn't seem happy, doesn't seem pleased.
You may be seated.
And she actually has to make a decision, which she seems to struggle with sometimes. She's very, very extremely lenient and kind of just, the whole time. So we'll see what she decides. I guess it is a big decision, but she's been like that the entire trial. Just very kind of like a lot of crazy shit going on in court, and she's just like, I like how they turn the mic out back for hot microphones. Judge, you know, so now she got to decide. At some point in life, you got to make a choice. That's why I don't even like giving you guys a third option sometimes. Do you think they're guilty or not, or unsure? Lately, I sometimes do it just because somebody's like, "Oh, you got to put unsure." No. You got to make a decision now. Where you're leaning, or what, you know, you don't have to say definitively, but you got to make a choice. You can't always have an out. BC, thank you so much for the 10. Says, good morning, Mel. Love spending the week with you. It's been a crazy one, but between this case and Miss Becky, no, even Judge Toll was saying that Miss Becky kind of sus, but it wasn't enough to say that she swayed the jury, because I think it was only like one juror that deliberated that felt like that, I guess. Becky slithering out like skeezing Murdoch, and her son got allegedly some news article about her son in wiretap or whatever. Skeezing city town. Lala Kawaii Crafter. Thank you for the 12 months. A whole year. Here's to many more. Thank you, Mel and Maz, for the dedication. Thank you. You gotta decide. You gotta pick a side of the fence, and then hop on the other side after the results come out. So yeah, it seems like they're arguing for this whole thing where she said something yesterday, Jen, I guess about the conversation that she had with her attorney, and they're trying to say that this could open the door to the attorney-client privilege, and I think the judge is worried about this. It's already been a mess, making it more of a mess. She's concerned, and I just really want to see the cross. I want to get to the cross already. Cavalcante this morning. There's something going on this morning. Nick the Hat is out there in person.
Yeah, the reason for being excluded was a very snarky remark. I'm not even going to entertain it because it'll make police officers look bad. When it was just one or two guys that I'm going to have to clear it up with. And obviously we're going to bring this to the attention of the judge that issued the order.
Oh, hell no.
Granting access to everybody in the media and public, regardless of size. So we'll take it up with them.
Grizzly is there. Grizzly.
Oh, hey, Grizzly. So we're going to see Danilo, according to what the police are saying. I'm going to go closer when he gets here, don't worry. So when he comes in, apparently he's going to come in right from these steps and go up. So we'll see if he has a new appearance. Maybe he'll come swinging from the trees. But they have police everywhere. You guys can see there's a car down there, straight ahead, parked. There are uniformed officers that were scattered out throughout that area. There's Hong gossiping. Mel, Grizzly, we got everybody in the house right now.
Everybody's tuning in, see what's going on.
So Danilo should be arriving soon. We heard 6 minutes, like an hour ago. I believe that's the guy that actually denied access right there. Yep. Him. That's interesting.
Sir, do you want to hold this? Yes, sir. I don't think it's...
They said they were bullying Nick. What happened? Wait, who said that? Tamara? Tamara.
Yeah.
What did they do? What did they do to Nick? Oh, snaky officer over here. So Cavalcante, man, this was the huge manhunt that a lot of people were covering. I think Nick and JLR were like the only ones that were out there in person. By the way, JLR is killing it right now on YouTube. He's covering the border stuff. There's a huge thing going on out there in the border. Well, Texas, I think they're kind of going neck to neck with the government about the borders, and they put up some wiring, and the government was upset or whatever. A bunch of drama over there. I stand with Texas, though. I fully support. Put some barbed wire, do whatever. I stand with them. So yeah, Cavalcante was a huge manhunt. It was really wild to see. We're here like every day, sometimes multiple times a day. Let's see if Tamara said what they did. What happened to Nick? Is it still on the video feed? Maybe I can rewind back and see what happened with Nick.
What's going on, Mel? Thank you, Grizzly. Oh, thank you, Rhino Girl.
Eagle Pass, right? Yeah. Denise says, what specific charges against Jennifer is for manslaughter charges? I'm sorry, involuntary manslaughter. I should clarify that. Involuntary manslaughter. But I think they said she could do up to 60 years, so it's big numbers. She could die in prison pretty much. It's like pretty much almost a life sentence if she gets convicted. Well, if they sentence her to all that time. Cavalcante. For the new people that joined, they're taking a little break. The judge has to decide on what they're going to do as far as attorney-client privilege, whether it's going to be waived. Yesterday when I heard the whole thing going on, in my head I was imagining, because they said something about Shannon testifying. I don't think she will. I don't think they can, right? Has that ever happened? I want to know, has an attorney that's representing a client during a trial been called to the stand? Can they even do that? That'd be dope. Now you're on the stand. I was imagining Shannon on the stand. That'd be wild. They're waiting for Cavalcante to come out. Cavalcante, besame. All right. Oops. Those news stations are out there, but they're not streaming. I feel like this mic, I don't know. Sometimes do I need to fix it, or does it sound good? Testing. I guess it's okay. Testing. Hey. I guess it's all right. I don't know if the lows are too low. Eric Carley, 23. Anything new about the missing teen that was found yesterday? Are you talking about the Ella girl that was chilling with some 30-year-old guy that has apparently charges against, he's an offender apparently? That girl? I tuned out. Once they said she was fine, she was hanging out with some dude, I tuned out. Just like the other chick, Alicia Navarro. People have been searching for her for years. She's over there scrubbing up and chilling with some guy.
Yeah, they said 6 minutes an hour ago, so let's hope that 5 minutes doesn't equate by that guy's math to another hour.
Anyway, I'll keep this here on a small little window, and we'll maximize it or whatever once he starts to come out, if he comes out. So Kelly says they denied Nick entry inside the courthouse. They don't want his coverage. Oh, really? Okay, Sherlock says your mic has been fine. Don't change anything. Okay, good. Because you know how I am, man. If I touch the buttons, I screw something up. I might end the stream. I might freeze the computer. I might cut the connection. And it's funny to me that I switched to the cheaper microphone, and it actually, for some reason, sounds better. I don't know. Hello? Good morning. I'm good. I'm streaming. Can I call you back? Okay. All right. That was Mama. Let me just make sure she's good. Let me text her real quick. Okay. All right. I liked hate lime green mic cover. Did you like it or hate it, or you liked hate it? You had a love hate with it. The other day you guys watched me. I ripped this by accident. There was a blue one, but it was too small. This is the green one that I had on there. Of course, I could have the black one. I could do the black one. I don't know. It might. I don't know if it's just too much going on in my background, but I do like the blue, I think. Be careful ripping now or whatever. But yeah, no, I switched to the cheaper mic, and I don't know. And I think I like it better. I don't know where I put the other one, but I also, it could be the settings too, because this guy that I get the settings from, I realized he did an updated video. The original one was a couple years old. He has a newer one, but I don't know. I've tried changing the sound so many times, and for some reason, it's the SMB7, which the SMB7, I've seen so many people love that microphone. I only got it because everybody else got it. And it's like a standard, I guess, like an industry standard. It has so many good reviews. It could just be my setup. I don't know. Maybe my setup. I mean, I think I have more than enough. I have the audio interface, the SSL2. I have the cloud lifter. More than enough to give headway. But for some reason with and probably honestly, when I'm in a room that's closed, it'll probably sound way better once I'm in an actual closed room. Right now, like this is like the living room, and then the kitchen's over there. It's like a large open space, and it's like high ceilings too, so it doesn't keep the sound together, kind of. Bro, you sound good. It just goes to show you don't always have to get like the most top of the line thing, you know. All right, well, they're back. Don't touch any buttons. Hot pink mic cover. Mo, how you doing? I only have a couple days off. So, well, tomorrow, I guess. It's already over, right? Go back tomorrow. I'm so happy you love your job. You got a subwoofer? Nice. I don't like the sound box on my TV. I need to get like some actual speakers for it because it just adds too much bass, but it doesn't sound clear enough. I think I need, but I don't want to get anything expensive either. So this room is just the floor here. It's just the fake wood floor. I don't know what material it is. It's called. And then there's tile, but yeah, there's no carpet in here. The bedrooms have a carpet. Hopefully the move is coming up like in April, the end of April. I'd like to have an actual just dedicated room to do YouTube instead of a living room, so I can close the door and stuff and all that. And I could probably do the sound things on the walls, right? You got 2 18-inch subs? No. In the house? That shit must be bumping in there. My mother says, call to see if you have a mouse for a computer. The one that I have is acting up. I do. I wonder if that connects to, it should be able to connect to Windows. Or I could just have Amazon deliver it straight to our house, right? Let me see.
All right.
Yeah, I could have them deliver it over there.
Your Honor, calling People v. Jennifer Crumbley, case number 22-279-990, FH.
Good morning again. I want to indicate that I've done some research on this matter. I think that the privilege that the defendant holds is her absolute privilege, and protects the constitutional rights. So I think this is a very serious issue, and reviewing these records could set a very dangerous precedent. However, I also note that the prosecution is requesting that the review be for a limited purpose on the issue of flight and not on the issue of anything else. How indicates that, and this is how indicates that a waiver is to be predicated not only when the conduct indicates a plain intention to abandon the privilege, but also when the conduct, though not evincing that intention, places the claimant in such a position with reference to the evidence that will be unfair and inconsistent to permit the retention of the privilege. It's not to be both a sword and a shield. And that's really what I'm grappling with. The claimant here would be the prosecutor. And I think if I didn't review these texts, that it could be potentially unfair to the claimant, that being the prosecutor on this limited issue. I can't tell you how reluctant and how much I do not want to do this, because I think that the privilege is so important. However, I've been told that this is going to be a limited review. The jury has been here since 8:30, and they've been here for 2 weeks, and I'm very conscious of that. So I am going to review the text for the purpose of determining whether or not there is reference in any way to flight.
Your Honor, the text, as you said, my client has the privilege over. I'm asking that my client and I be able to also review whatever's being submitted in camera.
Okay, well, here's the difficulty I have. If you go through my phone right now, you can find texts back to when the earth cooled. It's really hard to believe that you don't have texts from 2021 between you and your client.
Your Honor, I don't. After a year, all of my texts delete it automatically, and I have it set to that because otherwise I get so many. I use my phone for personal and business. So
okay, what's your position on her receiving an unredacted copy of these texts?
The other thing is, I don't know if those were even sent to my phone. It says Shannon Marielle. I don't know whose phone it went to.
Okay, here's the problem. Her testimony is, I was waiting for instructions from you.
Okay, but at the time, both of us were representing Mrs. Crumbley. So,
Judge, if I may, if they're not to counsel, then they're definitely not privileged. So that's one of the reasons I have a screenshot. One screenshot I saw. If that's a fake for some other person, a friend, boyfriend, whatever it is, then absolutely it's not privileged.
Well, at that time, I don't know
counsel,
I don't know.
It needs to be reviewed. One other issue, Judge. This is a very narrow time frame. This is after noon on December 3rd, up to the point when they're taken into custody at 1:30 a.m. on December 4th. I haven't seen these, but I know it's a total of 23 messages, and I know how thick this is. So this is a very, very limited number of messages.
What is your position on Ms. Smith receiving an unredacted copy?
I have no problem with that. I think, Judge, she probably got it in the Cellbrate reports before they were stripped out for us, yeah. But I don't know for sure. I have no problem with her getting a copy in the court.
That's a good point. Even though they extracted any privileged communication between the defendants and their counsel from these texts, you and Ms. Lehman did receive an extraction that included attorney-client communication. So I believe you are in receipt of these and have been for 2 years.
I don't believe that's true. I've never seen these, but I don't believe that's true. I believe I received the Cellbrate data that the prosecution has been using throughout this case. I don't believe I received a copy that included my communications. I believe they were stripped out before I got them.
Judge, it is possible that they were stripped out before they were provided. I want to be careful that I don't misrepresent. Okay. I do know that the screenshot would have been in there because that's what we saw in our version.
Okay, so at a minimum, the screenshot would have been provided. Okay, to me, the screenshot is now on the table for sure.
Yeah.
Because I guess I should say that because of what happened the week before the trial, they're aware that the prosecution is aware of that communication. So at a minimum, the 2-word text is coming in. Okay, so I'm gonna have a copy made from Ms. Smith of these texts. You don't have any objection to
I
that?
don't, Judge.
All right, and I'm gonna review them, and determine whether or not any of those texts are relevant on the issue of flight alone.
Thank you, Judge. May I approach your clerk?
Yes, all right. Okay, and if you're correct with their brief, I will be brief. The jury's waiting for us, okay?
All right.
So they're gonna look over the text messages now.
Okay, that's fine. I just wanted to say.
Can she stay?
Basically, she can't.
Captain's willing to take her down the stairs.
Okay.
You may be seated.
So they're looking over the text messages now. At least it's like a very limited amount of, I don't know, 20-something messages, I guess.
I have no mind again, and I do delete everything after a year. Well, it doesn't automatically.
That is a thing.
It started deleting like my photos after a year and it flipped out.
I don't know about photos though.
I'm going to fix it because I take photos of my kids on it.
I don't know. I don't think photos does.
All right, I'll
The
see
text
you.
messages, I think on iPhone, I think after a year, it deletes. Yeah, I think it deletes after a year. I'm pretty sure. I don't know where the options are at where you even check on the ooh. Go to settings, messages. I honestly don't even know how to check this shit, to be honest with you. I'm pretty sure I saw somewhere it's like after a year or something, like the iMessages. I don't know. Let me look it up. You have a text from 10 years ago? Is that iPhone? Okay, so maybe it doesn't then. It's a setting. So I wonder, do you have to manually set it? Or does it automatically do it? I think then it must be a manual setting. You have to manually go in there and set it, huh? Let's see. Choose message history setting you want to use. Forever messages. You can choose automatically to delete your iMessages from your device after 30 days or a year. Or keep them to your device forever. For your convenience, iMessages are backed up on the iCloud and encrypted. So what if you get a new phone, I wonder? It's a manual setting, okay. You got a text from 8 years ago? I got a lot of messages, and I have a lot of unread messages too. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 unread messages from like till last Sunday. There's even more, really. So for the people that joined, that are here now, thank you for coming. If you guys could hit the like button, I'd appreciate that. You haven't missed anything. They haven't started with the cross-examination yet. They've just been going back and forth about this whole, if they can waive the attorney-client privilege on some specific messages, because they're saying that Jennifer opened the door from being examined by, I think, her own attorney. Amy P, thank you for the 12 months. Going to be a long day. Happy to be here with y'all. Thank you. Michigan Madre, thank you for the membership. And Heaven Reigns, thank you for the 11 months. I love your channel. Thank you. Gracias. I saw her Facebook, but I didn't look deep in. I forgot what her Facebook name was. Is it just her name? Shannon Smith, attorney. I see her page. I see her professional page. Yeah, with the hubby. Shannon.
Hi there, my name is Shannon Smith and I'm a juvenile criminal defense lawyer. The reason I'm here today is because we have heard of so many students getting charged with copycat threats around the community. There were over 20 in Wayne County and at least 3 from my own kids' school district that I saw in the news last night. The reason I'm here to talk to you is to make sure parents understand that these threats are being taken very, very seriously, and they are a 1-year misdemeanor against children who make them. When they threaten that there's going to be a gun or an explosive or other weapon used against students in a school. If your child actually takes a step that makes it look like the threat may be true, the penalties raise it to a 10-year felony. This can have a devastating consequence, obviously, on your child's life, and it's
She limited the comments too, so you can't comment on there.
really important they know.
Let's see what else. I think she has a website too. With the hubby. Let's see. Defending. Is that what her website's called? Okay, defendingabuse.com. What? That's the name of her website? Defending abuse at the top. Okay. So yeah, she's like big time into covering or representing these kind of cases. Shannon Smith is a sexual misconduct lawyer known for her aggressive defense. If you have been accused of any crime like this, you know how serious the stakes are. You could be facing prison time, a lifetime on the offender registry, a permanent loss of reputation. That's why it's crucial to have an experienced, reputable lawyer on your side. You can't afford to have an inexperienced lawyer with cases like these, as this type of law requires very specific knowledge and experience to defend properly. And that experience is rare. So she's been practicing over 16 years, has been defending clients accused of all degrees of those types of crimes, and experience matters. She has fought her clients' rights in court and helped them navigate the complex legal system. She has also been recognized by her peers and legal institutions as an award-winning criminal conduct lawyer. Furthermore, she has been featured on most large media outlets such as CNN and Fox News. When you hire Shannon, you can be confident she will do everything in her power to get the best possible outcome in your case. Shannon today. Contact Shannon today. Schedule a free consultation. Award-winning. You got to scroll. Top 10 or 10. Top attorney criminal defense. Super lawyers. Super mom. Okay. Professionals. She does it all. Proven results. Client not charged of R-ing somebody. Our client was accused of child A for disciplining her children. After taking the client in to speak with the police, no charges were filed. All right, so that's what she does. So she's listing all her cases here, her successful cases. I wonder, does a defense attorney get paid more than a prosecution individually by a prosecution attorney? Since they're doing it like all on their own, or no? I mean, because the state is from the prosecution's from the state, right? They get paid by the state, I guess, but Do they make the same amount of money? Does it depend on experience, or do defense attorneys typically make more? They can. They do. Private practice is where the money is at. The cha-ching. So she's making a dough. Let's take a look at. See, I sent myself the clip. Take a peek at some of Lawyer You Know. Here we go. I'll put the link to his video and channel in the description as well. Let's see here. I put the link in the description. We'll just take a look at a snippet of it. I think I got the 20-minute mark.
His parents as well. Did she ever see that?
Yeah, I like the
things that he
right
drew and things that would.
At 6 o'clock tonight.
You're trying. I promise you, you're trying her best. Thank you.
Everything's taken care of. James got us here, right? And we're gonna call late. Have a conversation. How long do you think the next witnesses? I'm bringing lunch in.
Next witnesses can be back.
And then I'll run through some of the evidence. They presented school surveillance videos. That's some of the stuff that's difficult to watch. That included a moment-by-moment timeline of where the shooter went. They talk about how the parents came because there was a horrific drawing. Help me, blood everywhere. The meeting was only 12 minutes. Again, they definitely present the evidence in a way that the meeting was only 12 minutes because the parents didn't have the time to talk to the school about what was going on with Ethan, and they wanted to get out of there, and the school really wanted them to take Ethan.
Well, they're back
but
ready.
they didn't want, hold on a second. They begged the parents to take him. They wouldn't take it. They just left. And they abruptly ended the meeting and were kind of rude. That's how the state presented it. Okay. And then not 2 hours later, again, the rampage started. They talk about texts and call logs and photos and journals. Actually, not all the journal, but different things that he drew and things that would definitely let them know that Ethan's mental state was deteriorating. His only friend left a little while before this happened. They should have known. All the signs were in front of them, but instead they're buying him a gun, taking him to the shooting range, showing him where everything is, not protecting the gun appropriately, and therefore it's their fault. On cross, again, Ms. Smith, the defense attorney, I'm going to give her some props that she did a good job on cross-examination of a lot of these witnesses saying, do you know if Jennifer Crumbley ever saw this? Did she ever see that? Does she have any knowledge of this? Or is Ethan, who's at the age where he probably is hiding things from his parents, is he talking to people, making these drawings, hiding these things from his parents as well? And that they shouldn't have known or couldn't have known. And if they didn't know and they didn't see the signs, how were they supposed to know? To him, he was this great kid. That's how it's being presented to the jury. All right.
I like that. I didn't get to watch this whole thing, but he was reacting to also the comments.
A little unorganized. The defense attorney is, again, discombobulated, a little unorganized, a little frustrated, which, again, she has audibly said in front of the jury multiple times,
yeah.
This isn't how they gave it to me. They just gave this to me. I didn't have enough time to look at it. It's so confusing.
Yeah.
The way the state's presenting it is confusing on purpose. It's hard for me to keep up. It's hard for me to even make objections just because I don't know what he's showing in front of the jury. Again, I think partially to garner sympathy and showing that this big bad state is not giving her client a fair shot. And they're confusing things on purpose or hiding things on purpose. And she got so frustrated at some point that she really let it go when she did this.
Okay. I am so sorry that this is a mess. Okay. On March 19th, I've got it up on the screen. This is when Jennifer Crumbley and James Crumbley are talking about Ethan acting like or seeming like he was way hungover that day, correct?
Correct.
And it appears from the text, if he's okay, why is this doing this now? I am gonna kill myself.
You guys remember that?
Okay.
Literally, with victims sitting in the gallery, that's what she says. Because she is frustrated with how difficult the evidence is. The text messages are not coming up on the screen. When I tell you, listen, slip of the tongue is one thing, whatever, maybe dropping a curse word in front of the jury and apologizing or something like that, fine. But first off, to have that in your vocabulary is like wild to me, that people still in today's day and age have that in their vocabulary when something is frustrating them. Is appalling, horrible, insensitive, not something you should do, okay? But to say it in a professional environment like this, to me, again, I think she's trying to exert to the jury how difficult it is, how unfair this is, how the state has all the tools and it's so hard for them. And she just did slip of the tongue and say something that she probably says in her everyday life to try and explain to the jury how frustrated she is. But that is crossing the line in a way that I don't think I've ever seen or heard before.
Bro, and he's a lawyer and he does this all the time. He's never seen or heard it. When that whole thing happened, I was tweeting out too. I was like, I'd never seen no ish like this. And we just started watching trials, I think last year maybe, or the year before. Just started getting into it. And I'd never seen it. But then to hear an attorney say that, it's like, holy moly, So yeah, that's lawyer. I put the link to his video if you guys want to check that out after or whatever in the description. You can find it there. I think a lot of people know who he is. And yeah, so I thought that was interesting. I got to listen a little bit this morning. I might, maybe if I have time later, I'll try to finish. So yeah, that was wild, man. That was wild. Yeah, we could do a poll. We could do a poll now. The whole guilty thing, not guilty, whatever. I really wanted to see the cross. I wanted to see what the state was going to bring. Let's do a poll though. Where you're currently leaning. So you're not committing to it, just where you feel right now. Guilty. And this is how you feel the verdict's going to go. I mean, the jury. Not guilty. Good morning, Delana. What's up? Welcome back. Didi, what's up? B12. Speaking of B12, I took my B12 shot this morning. Took a little B12. Joy White. Yeah. I think it is a little too soon too. I ran the poll, but we're gonna have to do another poll after. We'll do another poll after the cross. I was thinking we should wait till the cross to see what the state does. They're gonna. To me, this is like an amazing opportunity for them. I think anytime the defendant takes a stand is probably like an opportunity to smash the case, probably, right? So they have to go in. Well, I don't know. I was going to say with fangs. They don't want to turn off the jury, I guess, but this is the chance to expose her, I honestly think that the jury is going to lean towards guilty. I think that's where they're going to lean. I don't think she's going to get 60 years, though. I'm going to send my mother this mouse, I think. Only thing is, I don't know if she's going to know how to turn the damn thing on. to sync the Bluetooth. Unless I send her a wired mouse. I think I should send her a wired mouse. Or I could just go drop mine off later and set it up. I don't know. But who knows how long we're going to be here today. She ignored all the signs. There were a lot of signs. I think the father was worse. But, I mean, just the whole on the run thing looks so bad, too, I think. And all the burner phones. And the thing that I guess the case they're trying to make is like maybe Ethan was kind of keeping it to himself. Or telling his friends. But, I don't know. I mean, she knew it was him, right? She knew as soon as they heard about the school shooting. I don't know how, I forgot how she got the news on the news or somebody told her. She knew it was Ethan. I think the school's liable too, though. And Debbie, I agree with you. Oh, this comment. I agree. I totally agree. I don't know about the caps lock. Yeah, I don't know about the caps lock thing. Some people have it. They stay. What they have to prove since it's a criminal trial, not civil. Oh, thank you. So Mo sent me a clip. Let's take a look on this one here. I haven't watched the full video from last night. Let's listen to this. This is again from Lorena.
Interesting set of circumstances here that we're dealing with. Oh, here it is. Kathy asked, what do the state have to prove to get a conviction? I wanted to say this before you guys voted on guilty or not guilty. They have to prove that a victim died, that the actions taken by the defendant were just egregiously negligent, recklessly negligent, or you intended to cause harm to somebody, which I don't think they're going to call that. And you did not have justification for ending somebody's life. So they just have to prove your egregious negligence caused somebody to lose their life.
You know, now they're going to start pulling in more parents to trials for what their kids did. Man, they didn't take him from school that day. They spoke of medicating him. The text between she and Ethan going on the run, hiding, and the gun access, Jules said. I mean, the carelessness of the way the gun was stored, I guess Ethan had the code, the default code. I mean, they must have told him, or I don't know. Aurora says, I haven't seen any real evidence yet to prove she was negligent. They got a father who brought his 19-year-old a gun now. Oh. She was very negligent, but was it egregious? That's a good question. What was the code to the thing? 000? 3 zeros and 4 zeros? I was like, man. Damn. Yeah, period. Yeah. Mel H says, what I don't get is he was on trial as an adult, but now they're blaming the parents. He did, yeah. Ethan did tell his parents that he was hearing voices. That part, yeah. I mean, I guess she's trying to argue that she would have never thought he was going to shoot up a school. I think the school is partially responsible. I do think that. That's why they're getting sued. Ooh, I didn't think about that. That's a good point. Chris Farrago said, if she's found not guilty, the civil cases will bury her. Sherlock says, do you think that the jury don't like Shannon so that they will be biased? The jury against Jennifer? I think that the jury probably doesn't like Shannon. I feel like, and I don't know, they're in person, maybe they're perceiving differently, but I feel like for the most part, like when you see the general consensus of people, like even here in the chat, and even we can feel like her anxiousness and craziness and all that stuff, and then it happened. I tend to think that probably most of those jurors are feeling the same, almost like Amber Heard. How most of us were perceiving her and how online was perceiving her, and then that jury there in person, how they perceived her. You know, so I think the jury's seeing right through it if that's what she's trying to do, like make him feel sympathy or whatever. They're back now. I mean, it's a really big deal what's happening if she gets found guilty. The first parent in America to get charged for their, what is it? First parent in America to be charged with manslaughter, I guess, for their kids. Forgot the exact title. What was it? Charged and tried for a school mass shooting. Yeah, a school mass shooting. First parent. Could be a thing. Maybe they start pulling in more parents for that. I wonder if they're going to bring in the messages because look what she's holding it. I can't read it, but they'll probably put it up on the screen and we'll be able to see it. To me, it almost looks like they're going to bring it in, though, because she's reading it over with Jen. Yeah, I think it is different, Carly, yeah, because they ignore the signs and they brought him a gun. Patty hands. Wow, Shauna, holy crap. I know over here in Florida,
Your Honor, calling people under Jennifer Crumbley, case number 22279-990F8.
Unexcused.
Morning. Good morning.
I have reviewed the extraction provided by the Oakland County Sheriff's Department and the sealed envelope to the prosecutor. I've reviewed all the text. I've made a copy for Ms. Smith. And Ms. Smith, do you have an objection to anything in the text chain?
No, I don't. I would ask that if the text chain is used, that it just be admitted as well.
Yeah, okay, so I am going to maintain a copy of the text chain in my own personal file. All right, and I'm handing a copy over to the prosecution.
Okay.
All right. So,
Thank you, Jessica.
can we continue the trial?
Absolutely.
Can we have just a minute to look at it?
Okay, yeah, it won't take you more than a minute, but yes.
Damn. Yeah, a little spicy now. She's tired of it. Chrissy, thank you so much for the super chat. Says thanks, Melon Mon's been with you all weekend. From JCK's to the Shady Becky and KC. Appreciate you guys. Thank you, Chrissy. Appreciate that. Thank you for the love. We're finally getting started. Yeah. Keanu says if she's found guilty, the sentencing will be multiplied 4 times. Yeah. Yeah. Yeah, I agree, Sean, at the school. They screwed up. Well, right now they're the cross. Oh,
Okay, so could I,
they're
have
really plotting.
Ms. Crumbley retake the stand?
We just need a few minutes. We haven't seen them yet.
A few minutes. Wow, what's going on with these people?
It sounds like you're going to. Just give me 1 second. I gave them time.
By the way, lawyer, was a little critical too of the prosecution. I think some of the remarks they've made too, as well. I heard a little something he said. I forgot what it was exactly, but so he was just pretty fair calling things out. Shannon's hands are shaking. Oh, I didn't see this. Virgo, thank you for the gifts. Virgo 22, thank you for gifting 5 memberships. Amazing. Make sure the new members go check out the front page of YouTube. There's a members playlist. Yeah, I gotta clean up the playlist because I think there was duplicates on there. I didn't fix this up. Yeah, there's duplicates. Damn, I don't know why everything duplicated on the playlist. It's so weird. There we go. Fixed. Please excuse us while we go rig the system. Brazilla Love says the school didn't buy him a gun and take him to the gun range and learn how to shoot. Would they have been able to keep him out if he showed back up later? True that. Maybe if he didn't do it that day, it would have been another day. Lutfig, good morning. with her top off. Yo, you tripping, La Chola. Sarah Boone's 7th floor just filed to be allowed to withdraw. Wow. Recovery posted this
All
on
rise for the jury.
Twitter. Wow, the 7th attorney is out too. Holy moly.
Good morning, you may be seated. All right, so I know you think that we all went out to breakfast this morning. We did not. As I described for you in the beginning of the trial, sometimes things come up. If you need to take care of legal issues, I usually try to do that when you're not waiting for us, but that's not always possible. So I appreciate your patience. And we are going to continue on cross-examination. All right, Ms. Crumbley, could you raise your hand? Do you swear or affirm the testimony about to give as a true self?
Here we go.
I do.
So you can put your hand down, and could you state your name again for the record and spell your first and last name?
My name is Jennifer Crumbley, Jennifer Crumbley.
Go ahead, prosecutor.
Thank you. Mrs. Crumbley, I'd like to talk to you about your vigilance as a parent. But before I do, I want to make sure that you understood the oath that you just took.
I do.
Okay, you understand that you took the stand under oath and you have to tell the truth?
I do.
You understand that was the rules yesterday as well?
Correct.
All right, we're going to come back to that.
Oh, we're going to come
Now,
back to that.
You have been described by your attorney as a hyper-vigilant parent.
Correct.
Okay, do you agree with that?
I do.
In fact, you called yourself a helicopter parent before.
Yes, I was.
Right. So you told us you spent a lot of family time together.
We did.
Now, I'd like to talk to you about what your digital footprint shows.
Okay.
What the evidence on your phone shows.
Okay.
Now, it's true, you agree with me, that having horses is quite a time-consuming hobby.
It can be.
Okay? It was for you.
It can be.
And that's what you said yesterday?
Yes.
Okay. And you were at the barn for between 3 and 5 times a week?
More like 3 times a week.
3 times a week for a couple hours a trip?
Correct.
Okay. It's also an expensive hobby.
It is.
So your banking records show that in the year of 2021, you spent over $20,000 on the horses. Is that correct?
Probably.
Okay. And that's not including cash. That's just from Capital One and Flagstar Bank.
Correct.
In fact, you told a coworker that half of your salary basically goes to the horses.
I might have, yes.
Now, except on a rare occasion, you didn't bring your son with you to the barn.
He was not into horses. I would ask every time I went to the barn, but he didn't want to go.
So the answer was no?
No.
Okay. And at least as far as your horses being boarded with Kira Pennock from June of 2021 to November of 2021, your son never went with you. Is that correct?
I think he went once when my in-laws were in town and we met them at the barn.
Okay. But there was nothing stopping you from taking him?
No, he just didn't want to go.
Okay. It's a family atmosphere.
It can be.
Okay. Like the Halloween party that she had. That was for families.
Yeah, most of the kids there are young.
Okay. In the winters, you were on ski patrol as well.
Correct.
Okay. And that can be a bit of a time-consuming hobby.
It can be.
All right. And you would be on ski patrol between 1 and 2 times a week?
It's a total of 10 hours a week.
10 hours a week. Okay. So how many days?
I did doubles on Saturdays, so 1 day a week for me.
Okay. So you told this jury yesterday, you depicted your affair with Mr. Malash as a one time a week meetup at a Costco parking lot. Is that your testimony?
Correct.
Okay. But it wasn't just that, was it?
Nope.
Okay. In fact, there are numerous photographs sent to Mr. Malash.
Okay.
Yes or no?
I'm sure there was.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday, was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included trips.
There were actual business trips that he met me on.
Okay. And included other individuals.
Yes.
What's Adult Friend Finder?
Where you can go on and meet people who meet certain tastes that you're looking for.
This is 429. And you had the app Adult Friend Finder on your phone.
I do not believe I had the app.
Okay, it was found on your phone.
Okay, well, I guess it was on my phone.
Okay, and there were messages from you to other individuals.
Correct.
Your Honor, I would object that this is going outside of the scope of the affair with Brian, but...
I don't think the court's ruling on opening the door was confined to just her extramarital affair with Brian Malash.
Well, I guess with regard to Mr. Malash, I determined that the defense opened the door. I don't know that I determined that the defense opened the door as to other relationships.
She depicted herself as having one extramarital affair for about a 6-month period of time, where she met with him 1 time a week. That was her testimony yesterday. We have evidence to the contrary, and I think it's important.
Ooh. Let's go, tear her up.
This is going to get exciting.
All right,
it is what it is.
All right, well.
Here's what it is.
Go ahead, but
I won't delve too far
okay, yeah,
into it, Judge.
Really, this jury has been here a long time, and
I respect their time, Judge. I'll be brief.
You might all blush.
So, Mrs. Crumbley.
You say you made her blush?
Sorry, this is not a laughing matter.
Oh.
Mrs. Crumbley, on Adult Friend Finder, we see messages from you.
Oh, sorry. What's that?
So, Mrs. Crumbley, I respect their time, Judge. I'll be brief.
You might all blush.
So, Mrs. Crumbley, I'm sorry, this is not a
show the judge's
matter.
face too?
Mrs. Crumbley, on Adult Friend Finder, we see messages from you in at least of August of 2021, August the 4th, 2021.
Okay.
Okay, and you don't dispute August the 10th of 2021?
No.
August the 11th of 2021?
No.
And more importantly, November 21st, 2021?
No.
Okay, and more important than that, November the 28th, 2021?
No.
Okay, you don't dispute that evidence was found on your phone?
I don't dispute it.
Okay, and you don't dispute that it wasn't just you and Mr. Malash meeting after work hours, it was with you and Mr. Malash arranging with other individuals to meet after work as well?
No, I only met with Brian during work hours. The times that we were at the hotel, I was on business. We did arrange for other people to meet us there.
So Sunday, November the 28th, you remember that day? It was the day after you took your son to the shooting range.
I don't remember it.
You don't remember that day?
No.
2 days before the high school attack?
No, I don't remember what I did that day.
Okay. Well, you were pretty specific in what you did on November the 27th with the firearm. You remember that?
Correct.
All right. Now, November the 28th, 2021, you spent your time arranging a meetup with somebody on Adult Friend Finder.
I never met anybody on Adult Friend Finder that day.
Arranging a meetup.
Oh, okay.
I'm not just talking about the time that you spent physically with somebody. I'm talking about the time that you spent and devoted your energy to setting that up.
Okay.
Oh, shoot,
And you'll
sorry.
agree with me, it's not just the time period at the Costco parking lot or the time period at the hotel or the time period on the trip, correct?
That's the only time I met with people.
Right. But that's not the only time that you devoted your own personal time and energy and focus to that, is it?
I guess I don't understand what you're asking.
Okay. Well, these meetups didn't just happen by themselves. You had to set them up.
Correct.
You weren't driven there. You weren't dropped off there. You set them up with somebody else.
Correct.
And that took your time and your energy and your focus to do so.
I don't believe it took too much time and energy, no.
Now, you told this jury that when your son texted you that he was seeing demons and bowls flying off the shelves, that was in the spring of 2021. You recall that evidence, right?
Correct.
You don't dispute that that was on your phone?
No.
You don't dispute that at some point you read those messages?
No.
And you don't dispute that your son said at least one time, "Can you please text me back?"
Correct.
Okay. You don't dispute that when you're at the barn, your other messages show that you can take pictures, send pictures, and receive pictures.
Usually I'm at the barn. If I take pictures and I try to send them, they don't go through right away, or I won't send them until I hit a spot where I actually have service.
So in Exhibit 423, the Facebook message chat between you and James, the chat that you deleted, there are a number of pictures that James sent to you from the barn of a horse in a conversation about that particular horse. Do you dispute that?
No.
Okay. And in fact, dozens and dozens of pictures of the like.
I'm sure, yes.
You're sure, okay. And those pictures were sent to you with a timestamp on that Facebook message chat.
Okay.
Do you dispute that?
No.
No. Okay. And then you responded in that same time frame. Do you dispute that?
No.
No. So that conversation with that picture that was taken at the barn was occurring while one of you were at the barn.
I'm sure it was.
Okay. Now, you don't deny that your son wrote in his journal that he asked his parents for help. You don't deny that evidence that was admitted?
No, I don't.
Okay. And you don't deny that he wrote in his journal that he now had access to the 6-hour 9mm handgun?
I do not deny that.
And you don't deny that the 6-hour 9mm handgun was in fact the murder weapon?
I don't deny that.
And you also don't deny that that gun was gifted by you and your husband to your son on November the 26th?
Describe gifted.
How about when you posted on Instagram his new Christmas gift?
Correct. And I explained yesterday that it was for him to use at the shooting range. We didn't just hand him a gun as a here you go, son. It was something he could use when we went to the range as a family together.
You don't deny that in April of 2021, you described your son as being depressed?
I didn't describe him as being depressed. I noticed that he was acting depressed.
You used the word depressed?
Yes, he was acting sad. He was acting depressed.
Okay. And you know what depressed means?
It means a lot of different things.
Well, to you, it meant depressed, and you wrote that.
Right.
You don't deny in April of 2021, the evidence shows, that your son told his only friend that he had asked you for help.
No, I don't deny that.
Okay. And you also don't deny that he told his only friend that you laughed at him.
I do not deny that.
Now, yesterday you told us that you took those messages in the spring of 2021, which, by the way, is at the same time you started your affair with Mr. Malash?
Around that time.
Okay. So in the spring of 2021, when you sent those messages, or when you received those messages, you indicated it was messing around.
It was.
It was messing around. In your mind, messing around. That's what your testimony was.
Yes.
Okay. Even when he said, "Can you please text me back?"
I didn't see his text message, so I didn't text him back.
Even when your phone logs show missed calls?
Can you ask that again?
Even when your phone logs show missed calls from your son in that time period?
No.
Now, you said yesterday about these messing around texts. You agree with me that there's no indication in any text message, either between you and your son, or any Facebook message between you and your husband, in any of those exhibits, in fact, anywhere on your phone, that indicated that any of those messages were a joke?
No, there weren't.
There weren't. And we're talking about hundreds of messages between you and your son, and thousands of messages between you and your husband.
Correct.
And you don't deny that you never once took him to see a therapist or counselor?
No, I did not.
You did not. Now, you testified that, actually, Mr. Malash testified that you would meet during work hours, and we've established that it wasn't just confined to work hours, but we're permitted to leave as you please.
Correct.
Okay. And your boss actually testified that no problem if we needed time off.
Correct.
If you had a family issue, no problem, you can go.
Correct.
If you were sick, no problem, stay home.
Correct.
Okay? In fact, you could work from home on an as-needed basis.
Correct.
In fact, on November the 30th, you didn't even ask your boss if you could leave. You just told him you were leaving.
Correct.
And you told him when you were coming back.
Correct.
And you told him when you were coming back after receiving a phone call from the school asking for an immediate meeting.
Correct.
Because that was at, what, 10:05 a.m.?
Around that.
Okay. Now, had you ever been called... Have the TV on, please, Mr. Blaine. Had you ever been called...
It takes some time for all three of them.
Sure, Judge. I have a few more questions I can ask before we get to these.
Okay, go ahead.
Have you ever been called to the school on an immediate basis before?
No.
Have you ever been told that your son had suicidal ideation before?
I was never told he had suicidal ideation before.
Okay, that's your testimony. But you've never been called to the school once for a meeting, I need to see you now.
No.
Correct? Okay. So even before you had made it to the school, you had told your boss when you were coming back.
Correct.
So you could already put a limit on that meeting.
Not necessarily.
Well, you said, I'll be back in about an hour.
Okay.
Right? That's your words.
About an hour.
Okay, those were your words.
Correct.
Man, you're going
This is
hard.
Exhibit 74. Do you see it?
No, she doesn't.
Oh.
It's not on here. That's... Yeah, it takes a minute.
He brought up that adult friend finder thing just to drag her.
You see it?
They really had.
This was sent to you. So Sean Hawkins called you at 9:24 in the morning, correct?
Correct.
Okay. You called him back at 9:27.
Correct.
You had a 5-minute phone call.
Correct.
And then in that phone call, he texted you the picture with it was drawn out, and he emailed you this original picture.
Yeah, he texted me the modified one, and then later emailed me this one.
Later is at 9:32.
Yeah, like after I asked him for it.
You looked at it.
I did.
Okay. You told us yesterday you found it, I think your quote was, a little concerning. What struck you about this?
Originally, when I saw the modified one, I was kind of angry at my son because we just talked about his missing assignments in geometry and his E the night before. Then when I got this one and opened it, it was concerning. I honestly thought the guy on there was a poor drawing of Batman, the way the thing in the cat. I thought it was a cape. I didn't know.
You thought that was a cape?
I did. I didn't look at that closely.
What did you think of the gun?
I thought it was a gun.
Yeah. What about the fact that it is identical to the gun that you got him for Christmas a couple days before?
I mean, honestly, it looks like a gun to me. I didn't even notice.
Well, you took a picture of the gun. You posted it on Instagram. You know what it looks like.
I do, but I didn't analyze it.
You saw Special Agent Brandon's testimony. He described how it's identical. And you told us yesterday how your son was a good drawer.
He's a very good drawer.
Okay. What about the thoughts won't stop, help me? Did that ring out to you?
Yes, that was what was concerning to me.
Blood everywhere, and there's a bullet. And actually, you were the one who bought the bullets on November the 27th.
Correct.
You later came to learn that those bullets were used in the shooting.
Oh.
I did.
Okay. So you said yesterday it was a little concerning, yet you told your husband emergency in all caps.
Correct. That's why I left to go to the school, and I texted him.
And he wrote back, my God, WTF.
Correct.
And then you told him he was distraught about last night.
Correct.
Distraught's an intentional word you chose.
Correct.
Not sad. It's not a little anxious about school or his future. It's not talking about a video game. Distraught has a meaning.
Correct.
And you chose that word to send to him.
Correct.
So you went to that meeting, and this was November the 30th of 2021. And at that point, you'll agree with me that you knew prior to that day, the November 26th purchase day, that your son was wanting to get a 9mm. That's what you said yesterday.
Yes, I knew that they were talking about getting one because they had rented it in the past.
And you knew that he had shot one in the past.
Yeah.
Okay, and you knew that a 9mm is significantly more powerful than a .22.
I did not know that until I actually shot it.
Okay, well, your dad took your son with James to the shooting range when they visited in July of 2021.
Correct.
And they talked about how powerful the 9mm was because they rented one then.
Okay. I don't know.
Yes or no?
I don't know if I was part of that conversation, but if it was, it didn't register to me.
It didn't register. Okay. You knew at the November 30, 2021 date that your son's friend had been taken without notice to your son.
Correct.
You say, I'm sorry, incorrect or
I said correct.
Correct. And you knew that when your son's friend was taken, your son was extremely upset.
He was upset, yes.
He didn't go to school for a few days.
I don't remember that.
Okay. Well, if the school records show that he was absent for a few days after that, would you deny that?
I wouldn't.
Okay. And would you deny that he missed school because he was so upset?
I don't know if he missed school because he was so upset or maybe he was sick. I don't know.
Okay. Now, you told us yesterday and you acknowledged that individual, that child, was like a second son to you.
Correct.
So he was the only one that your son hung out with?
Outside of school, correct.
Okay. Well, who did he hang out with inside of school?
He named some names to me. I've never met them before, but he told me some group of kids that he sits and eats lunch with and he talks to in class.
Did he ever visit their houses?
No.
Did they ever visit your house?
No.
The only other peer to visit your house was this student who left the state around Halloween 2021.
At that time, correct.
We're talking about that time in October, in September, in at least August, July, June, May, all of
2021, correct.
2021, thank you. Now, he left on Halloween, and you knew that your son was planning to hang out with him on Halloween.
Yes.
Okay? But his friend didn't show. I had texted his friend's mom the day before trying to confirm if he was still coming over, and that's when we found out that he was driven to Wisconsin and taken to that school. Okay, so you're telling us you found out the day before Halloween?
Yeah.
Okay. But that didn't stop you and James from going to a Halloween party at the barn.
I don't believe it was on Halloween.
Oh, that's what Kira testified
to. It was the Friday before Halloween.
If there was a picture with a date stamp on it, would you deny it?
No.
Okay. And it didn't stop you from after you left that party without your son, you went to another Halloween party.
We did.
And your son was home alone at that point?
Yes.
Mm-hmm. So you talked to us a little bit about your son's hobbies in 2021. But in November of 2021, so we'll start with November the 1st, 2021. You know that those hobbies were non-existent. And I'll go one by one.
Okay.
So you told us about bowling.
Correct.
Bowling the team wasn't in session at that point in time, was it?
No, I think actually at that time he decided he didn't want to do bowling that year.
Okay, so he stopped bowling the sophomore year.
He did.
And it wouldn't have been bowling season anyway.
I guess not, no.
So one hobby you talked about yesterday, that was not in existence in November 2021.
Correct, but we did still go to the bowling alley with him.
Okay. And you said that he worked, but would you be surprised to learn that he only worked a few shifts post-COVID?
No, I'm not surprised at all.
Okay. So he wasn't at work every day?
No, he worked Tuesdays and Thursdays and sometimes Saturday mornings.
Okay. But not very often?
No, not very often.
A handful of shifts post-COVID, which of course, March 2020 is when things shut down.
He was working on a weekly basis.
And you knew that he didn't have any friends?
That's not the right way to put it. I knew he had friends, but no, he did not have many friends.
You had never met another peer his age who he refers to as a friend.
He actually had friends that used to come over prior to 2021 that he was still in contact with.
We went through defense exhibits yesterday from 2019 to 2020. I'm talking about 2021, at least from the time period where he sent you a message that he saw demons in the house.
Right. In 2021, the only friend that came to our house was the one that was on the thing.
So you knew to be true in November of 2021 that he had no peer support.
I don't know what he had in school. He told me he had friends in school that he talks to.
Okay. You never met him though?
No.
Okay. And he didn't have any clubs at school he was a part of?
No, not that year.
So you told us yesterday that your son wanted to design video games.
Correct.
Okay. He wasn't in a robotics club or a coding club at the high school.
He did take a coding class prior to 2021, and he was in a robotics after-school activity in middle school.
Talking about in 2021?
I'm just telling you, he's been in that before.
Yeah. Now, despite what you have called yourself as a vigilant parent and a helicopter mom, you never decided in at least November of 2021 to look at his phone?
No.
No. Okay. That's despite what happened in the spring of 2021, right?
What happened in the spring of 2021 did not concern me.
Okay. Now, the one thing that seemed consistent with your son, to you at least, is his desire to obtain a weapon. Is that right?
I wouldn't say that, no.
He had a consistent desire to obtain a weapon.
Not to me, he did not.
Okay. You didn't know about the 9mm?
Oh, I knew about it.
Okay. You didn't know about the 22s?
I knew about them.
And in fact, you posted on Instagram that he got himself a 22
Correct.
in June of 2021.
Correct.
And from that time up until the November 26, 21 purchase, he was wanting to get a 9mm.
I know him and my husband had discussed getting a 9mm. I'm not part of those conversations.
But you knew about it.
I knew, but not that he was so, however you described it.
I said he consistently had a desire to obtain a weapon.
I know they consistently talked about it, correct.
Okay. They didn't just talk about this is a gun, he talked about how he wanted the gun. You don't deny that.
Oh, no.
In November 26, you said you weren't there for the gun purchase.
No, it's not.
Okay. But are you telling us you didn't know it was going to happen?
I did not know they were going to the gun store that day, no.
Okay. But you knew that you were going to eventually get him a 9mm.
No, I did not know that.
Okay, so you're telling us that that was a surprise purchase to you?
It was a surprise to me that they went to the gun store that day.
Okay.
It was not surprising to me that they purchased a gun that day.
And it didn't upset you that they bought a gun?
No, it did not.
It upset you that it cut into your Christmas tree shopping time, but it didn't upset you that they bought a gun?
Correct.
Okay. And you told us that it was, in your words, James's responsibility to take care of that gun.
Correct.
Okay. Now, you don't deny that, at least according to the cell phone evidence, the photographic and video evidence, you're the last adult to have possession of that gun.
Correct.
Okay. You were with him at the range on November the 27th.
Correct.
You saw your son shoot the weapon.
Correct.
You saw him shoot the last practice round before the shooting on November 30th.
At the range?
Yeah.
Yes, correct.
You saw how he stood.
Honestly, that didn't mean anything to me at that time until this whole case came about, and I've learned what a shooter's stance is. So.
Oh, Lord.
He knew how to use the gun.
Yes, he did.
Okay.
He's used one before.
In fact, he showed you how to use the gun.
Correct.
Okay. And the stance he took, you saw from the Oxford High School video, was the same. You saw that, right?
I don't know. I can't compare it. I don't know.
But you entrusted this responsibility. Will you agree with me that owning a firearm involves a great deal of responsibility and trust?
I do.
Okay. And you entrusted this responsibility to your husband, James.
I did.
If you look at Exhibit 423, that's the Facebook chat thread between you and your husband. It's pretty clear you didn't trust James with much. Would you agree or disagree?
Depends on what you're talking about.
Okay. Well, you didn't trust him to get out of bed on time.
Correct.
You didn't trust him to cut the grass when it was time to cut the grass.
He would cut the grass when it got to a length I didn't like. I didn't trust him.
You didn't trust him to update you on his whereabouts.
There's a reason behind that.
You didn't trust him to not turn off or turn on the Ring camera in your home.
Correct.
You didn't trust him to keep track of your son.
Oh, I trusted him to track my son.
In those messages that we'll see in Exhibit 423, asking him, where is your son, over and over and over again, does that signify trust or distrust to you?
That was when my son was walking home from school. Not that I did not trust my husband with my son.
Okay. And you didn't really trust your husband to hold down a job.
It's not that I didn't trust him to hold down a job. He had a hard time holding down one after COVID.
Okay. And in those messages, you are constantly asking him about work, how much money he's making, and what he's doing to obtain employment.
Correct.
Okay. But this is the person you entrusted with a deadly weapon.
I did.
Why did you buy the Patriot defense rounds?
Where are that's the ammo? That was the ones my son told me to purchase. I didn't know anything about it. I'd asked him, and he told me to purchase them.
So you told the jury yesterday, I think you repeated it again today, that the gift was for target shooting only.
Correct.
Okay. Yet you bought 100 rounds of ammunition.
Correct.
And you only shot 50 while you were there.
Correct.
Okay. And those 50, at least according to some statements you made throughout the investigation, you put somewhere.
The box of them, yes, I did. I hid them.
Now, on November the 27th, when you came home, you posted pictures of the gun and targets to your Instagram account.
Correct.
And then, according to the location data, your location data, you left.
I think that's when we went. Well, I don't know. I must have, yeah.
Okay, well, you don't deny that.
I don't deny
Okay.
it.
And your husband James was gone all day, according to his location data.
I think so, yeah.
Okay. And you saw in the evidence that in the picture you posted, there's an ATF pamphlet on handgun safety for children.
Correct.
Did you read that?
I looked it over, correct.
Now, on Exhibit 74 here, I want to get back to this meeting for now. Exhibit 74, you don't deny that you could have left work for the day.
No, I don't deny that.
Okay. And you don't deny that you didn't tell the school officials, Mr. Hopkins and EJAC, about the gun purchase on the 26th?
No, we had stated that we went to the shooting range. I went to the shooting range with my son on Saturday.
You didn't tell them that you had gotten him that Christmas gift?
I didn't think it was relevant, no.
You acknowledge that you never told Mr. Hopkins and EJAC that it wasn't just a friend, but it was his only peer that you had ever met and left?
I had probably said his best friend.
You acknowledge that you didn't go home to look for that firearm after the meeting at the school?
We wouldn't have a reason to.
So that the answer is then you acknowledge that?
No, I acknowledge that.
Okay. And you acknowledge that you had already made plans for the night to go to the barn?
Yes, I do.
Okay. And you acknowledge that you had the time to stop at your house before you went back to work?
I would have, but I didn't have a reason to.
Now, you had told us that you had never taken your son to any sort of mental health professional.
No.
Okay. But you know how to obtain that help.
Correct.
In fact, you have prescriptions related to that.
I do.
So it's not that you didn't know who to call or how to call. You didn't.
Correct.
Correct. Okay. Yesterday you talked a little bit about how you express emotion.
Correct.
And in fact, and then counsel asked you about your nerves when you testified. But you're capable of emotion.
Yes, I am.
Right? Okay. And in fact, you had some explosive emotional fights with your husband.
What we did.
And that was in the home that you shared.
Correct.
Okay. And with your son.
Correct.
We saw pictures of that home.
Correct.
And you told us that your son was at an age where he wouldn't text you back, I love you.
It wasn't a text me back, I love you. It's like in passing, like, hey, Ethan, good night, I love you.
Well, yesterday you told us that your son was at the age where he wouldn't text you back, I love you. Those were your words yesterday.
Yeah, but more or less like just saying it in passing. He wouldn't say it back. I say good night, Ethan, love you, and he'd be good night.
Okay.
For him to text me that he loved me was abnormal.
Abnormal.
Correct.
Okay. But you didn't respond to that text until 44 minutes later?
No, I was in a meeting at work.
Okay. And if you go through your entire text message thread between you two, the word love pops up how many times do you think?
Between me and my son?
Yeah.
I have no idea.
Okay. 3.
Okay.
The first is in reference to the game chess about a year before.
Okay.
And the other 2 times are right before your son committed this act and after the shooting when you responded. Does that surprise you?
No.
Your Honor, I would just ask if there could be a foundation for the dates of those texts, because I feel like we got just a few texts.
Okay, well, I think he specified. Did you specify the date?
I did, Judge.
Two of the times were before and after the shooting, and the other time was when?
About a year prior. I could pull the date if counsel would like it.
And I'm also wondering if what the data he's relying on is coming from Jennifer's phone, where she deletes all her texts, or if it's coming from the shooter's phone. Because the prosecution's asking questions, I just want to know the foundation.
Oh, sure. Let me clear that one up. It's from your son's phone. So all the messages would be contained there. You don't deny that information would be accurate?
No, I don't deny it.
Okay. Now,
what time period?
You told us that...
Well, she said he asked if the chess one was a year earlier, and the other 2 were close in time to the shooting.
The day of the shooting.
Yeah, I know.
I'm asking,
those have been admitted in evidence.
do we know?
Wait, what's the question?
Okay, But he's asking about the texts overall, which have not been admitted into evidence, and I don't know that the text chain has all the texts. There is no foundation that what Mr. Heese is looking
Judge,
at.
in cross-examination,
He's asked is that wrong? Would you argue with that? That's what he's asking. I mean, there are people.
I know she just doesn't know what.
Hold on, counsel can't testify.
No, she can't testify. Well, there are people that end every conversation with all of you.
Yeah,
right?
I'm like that.
Okay, so and there are people who don't, right? So he is asking what's normal for them, and would she be surprised that how many times that appeared?
Yeah, I'm just asking. I get that, and I get that it's not common. I'm just asking.
Judge, this is argument. Counsel can argue whatever she wants to.
Period of text this is from.
You have redirect.
Okay, well, right. She doesn't know what he's even basing these questions on.
Okay, it isn't appropriate for counsel to suggest to the court what she or does not know.
She can say I don't know, okay. Or she can also say I don't understand the question. She can say that too. Mrs. Crumbley, if you don't understand the question, ask Mr. Peace to clarify it.
Okay.
All right, thank you, Judge. Now, yesterday, Mrs. Crumbley, you talked about going into planning mode.
Yes.
Okay. And that was in reference to counsel asking you about emotions and how you express emotions.
Correct.
All right. So, I want to talk to you about your planning mode and your priorities from the time that you were arrested.
Okay.
Now, your phone calls were recorded from the time that you were arrested until now. Do you know that? You know that, right?
I knew that.
You know that, okay. And your priority on your first phone call, December the 4th of 2021, was on your animals and the cash recovered from the art studio. Do you deny that?
I don't deny it.
No. Do you deny that it wasn't until 10 days later and 14 calls later that you even mentioned your son?
Do
you deny it or not?
I don't, but I was under the impression that I couldn't mention him because I could get flagged at the jail.
Well, you mentioned him in later conversations.
I did.
Okay. And in fact, in one, a year later, March 25th of 2023, you said he just needs to man up. Oh. Do you recall that?
I do not.
Okay. Do you deny that you said it?
It sounds like something I would say.
In December of 2021, your concern was about a GoFundMe. Do you remember that?
No, I do not.
Okay. I'm going to play this for you. Ms. Williams, can you have the volume up, please?
Is this submitted as an exhibit?
This is impeachment, Judge.
You're not asking for treatment.
Well, there's no, Jennifer, that's... I just know, he tells that for speaker base, but I know there's a lot of people that call the lawyer about the welfare of my horses. So, I mean, I'm throwing shit against the wall to see what's fixed. What's that? I'm just throwing shit against the wall to see what's fixed. I know.
Okay, that was between you and your dad?
Correct.
Okay. And you asked him to set up a GoFundMe to pay for the board of your horses?
I did, yes.
Okay. You were concerned about other things related to yourself around that time, weren't you? Is this still planning mode?
I believe so.
Okay. And you were arrested December the 4th. This is going to be December the 22nd.
Okay.
Oh, I got a project for Mom. Yeah, okay. Can you have her Google how many calories are in a bologna sandwich with white bread? How many calories in a bologna sandwich with white bread? Yeah, American cheese. With American cheese? Yeah. You get any mayonnaise on it? No, just mustard. No, there's not beef mustard. And then peanut butter and jelly on white bread. And peanut butter and jelly white bread. Okay, so he's looking up bologna right now. Is that what your lunch and dinner is? For the most part, yeah. There's the other stuff, my cereals, now some of them are actual cheese. American cheese, yeah, American cheese. And an apple and a banana. Because they really they're carb loading me, and I want to make sure I stay at like 1,000 to 1,200 calories. No, I know bananas 100 calories. And Yeah. So the sandwich is $140. Oh, 240. Okay, that's 300. So that is 60 calories a day. Can I peanut butter jelly and white bread?
Yeah. Still planning mode?
Well, I wasn't planning there, no.
Okay. Now we're talking about how you describe planning mode. You described that in context to statements you made to the police on November the 30th, 2021. Right? That's the context you use the words planning mode in relation to.
Correct.
Okay. So you told us that the last phone call on December 31st, that was still you in planning mode. I want to make sure we can accurate depiction of what that is. Now here's one from January 15th, 2022.
No, it's not an issue of that. It's an issue of, that bank seemed to be always, they had issues with their online stuff, and they had issues with, just all kinds of stuff. I don't see how can they make banks on these people, it's like, so. But,
this is that child deposit thing?
So what?
Am I still getting a deposit of $300? That child thing the government does?
I just got, because I lost access. For some reason, I don't know if I told you that. I had access basically to view only, and it's hard to see everything on there, but then also I lost access, and then it took me, I lost access like a couple days before Christmas.
Yeah.
Okay.
Okay. Is that still planning mode?
We were talking about filing my taxes if you played the whole thing.
You were asking about your child tax credit if you're still going to get that $300.
My dad was doing my income taxes for me.
Yeah, they got everything. Jeez.
Now, when we started, we confirmed that you understood the oath that you just took.
Correct.
And the same oath you took yesterday.
Correct.
Okay. And you don't deny that you had $6,000 in cash in your purse the night you were arrested?
No.
You don't deny that your purse with the cash and 4 cell phones were in a plastic tote?
Correct.
You don't deny that that plastic tote was contained in a different plastic tote?
Correct.
You don't deny that your backpack with clothing items was found in a different plastic tote in a different area of that studio?
Correct.
Okay. And you don't deny that you knew you had been charged with involuntary manslaughter?
Correct.
In fact, as early as December the 1st, 2021 at 6:10 p.m., you were talking about how you were being charged with involuntary manslaughter.
That was what I was being told by a family that was texting me. That's what the charges might be announced as, correct.
Okay, and one is to Mr. Malash. There's a text to your cousin about you are being charged with involuntary manslaughter. You don't deny receiving that?
No, I don't.
That's Wednesday, December the 1st.
Correct.
Right? And you sent your neighbor a message on Wednesday the 1st of 2021, 6:55 p.m., that you were reading, they may charge us.
Correct.
Okay? And December the 2nd, 2021, you wrote, they're saying involuntary manslaughter.
Correct.
You don't deny that?
No.
And of course, you looked at different news articles about that the next day.
Yeah.
And later on that day. And then you texted, after all of these messages and news articles, on December the 2nd, 2021 at 2 p.m., we're fucked. You wrote that to Mr. Malash.
Correct.
Okay. And then you wrote announcing charges at noon on December the 3rd, 2021 at 8:17 a.m.
Correct.
And you wrote that to Mr. Malash, you wrote that to Kira, you wrote that to your dad, right?
Correct.
Okay. So you don't deny any of that?
No.
Okay. Now you told us yesterday that you popped 4 Xanax?
I did.
Okay. And your husband popped 4 Xanax?
Correct.
You said you went to bed about 11 o'clock.
It was around that time.
Okay. And The evidence that we have admitted show that you set your alarm for 6:30 a.m. and 6:45 a.m.
I don't know if it was me who set it, but it was set for that time.
Okay. And from the evidence, it shows when it was set too.
Correct.
Okay. And it was set a little after 11 p.m.
Okay, correct.
Yes? Okay. So, yesterday you said, I want to say it was after 11 about going to bed. I want to say it was after 11, maybe around 11 o'clock when we finally went to bed. I prescribed Xanax for anxiety, and we each took 4 because we knew we were going to turn ourselves in the next day, and we hadn't slept in 4 days, and we just wanted to sleep. So the question was, okay, so you each took 4? Your answer, we did. And the next question was, okay, so the next thing, the next piece of evidence we saw that was coming in that art studio, do you recall that? Your answer? I recall my husband screaming, "There's people with guns against interface officers." Question, what were you doing prior to hearing your husband screaming? Answer, we were sleeping. Question, okay, were you aware that there was anything going on? Answer, I was not.
Correct.
That's your testimony?
Correct.
Okay. And you know when you say something that isn't true, that's called a lie.
Correct.
Okay.
It's people have 0.5, 0.25. Kristen, thank you so much for the super chat. I'm going to read it. I'm break.
No
Here you go.
judgment. Oh, thank you.
Judges of the court have a copy?
Is this today's?
Yes, Judge.
Okay.
Yeah, they're bringing up everything.
Any objection? Okay.
Mrs. Crumbley, you knew the police were there.
4:30 is admitted.
Thank you, Judge.
Not until I woke up, no.
Not until you woke up.
Correct.
Okay. Now, we heard testimony yesterday, or throughout the trial, that 911 was called at 10:43 p.m. You recall that?
Yeah, I saw in the video, correct.
Okay, and on the video, the first officers arrived before 11 p.m.
Correct.
Okay. And either you or your husband, we couldn't tell from the video, but you tell me, was it you or your husband out there smoking?
That was my husband.
Okay. So your husband walks in shortly after the 911 caller walks in the building to call 911.
Correct.
That was on the video.
Correct.
Okay. And officers arrived. And then we've heard testimony from Mr. Kirtley, who had a studio there. We heard testimony from Sergeant Hendrick, who was in the fugitive apprehension team, as well as Corporal Shaw with the Detroit Police SWAT team, about the amount of officers there.
Correct.
You recall that?
I do.
And you recall hearing the testimony that Corporal Shaw's team, their SWAT team, they actually used a 35-pound steel ram to bash in a door at the studio next to where you were at. You recall that testimony?
I do.
Okay. And your testimony was that you were asleep when the officers arrived.
Yes, I was.
Okay. But you had an alarm set for 6:30 in the morning on your phone, and that phone was found powered off, hidden in a tote, contained in a different tote, in a place away from the bed.
Correct.
You don't deny that?
No.
All right. And there are certain messages in 430. I'm going to go through them with you. This is actually to your attorneys. At the time, you had 2 attorneys. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. That's it. December the 3rd, 2021, 6:04 p.m. Did you recall that?
I don't, but I don't deny it.
Okay, you don't deny it.
No.
Okay. Your next message, the other phone broke. That's December the 3rd, 2021 at 6:04 p.m. The response was, when you can, we would like for you to call us. That was from either Ms. Smith or, at the time, co-counsel Marielle Lehman.
Correct.
Your response, I'm sorry, this is from Marielle. Thank you. Shannon is calling you both shortly. Okay. At the top it says to and from. I'll make sure I identify for the record. From Shannon, Marielle and I are going to come get you guys in the morning. We do not think it will help to make a statement that you're coming back now or that it will be tomorrow a.m. We can say that we told everyone you were coming back, and as of tomorrow a.m., you are back. That's Friday, December 3rd, 2021, 7:02 p.m.
Correct.
Right? Okay. So that's after James had already moved the car around and backed into the parking spot.
I believe so.
All right. From Shannon, we can show them that everything we said was going to happen did happen. That's Friday, December 3rd, 2021 at 7:02 p.m. Right?
Right.
Your response, okay, that's at 7:03 p.m. From Shannon, I'm going to drive home from my office right now and call you guys in about 40 to 45 minutes. so I can get all the bond factor information written down for Mariel and me. That's Friday, December 3rd at 7:36 p.m.
Correct.
Okay. Your response, okay, we'll be waiting, 7:37 p.m. Shannon, I'm going to call in 1 minute. That's at 8:54 p.m. that Friday night. Your response was okay. You recall?
I don't, but I don't deny it.
But you don't dispute the records?
Correct.
The next message you send was, think we might have found, don't know, just heads up, please check. December the 3rd, 2021, 11:14 p.m.
That was written, but I do not believe it was written by me.
Okay, you don't remember. Well, you told us you don't remember any of these text messages. You just
Right, I read through it, but
you don't deny that this was on your phone, what we refer to as the burner or track phone.
correct. We were both using that phone at the time because my husband's broke.
Okay. And then you wrote in quick succession, don't know, 11:16 p.m. We might have been found, 11:16 p.m. Laying low, 11:16 p.m. You don't deny that these are the records?
No, I don't.
Okay. Response from Shannon, oh shit. Friday, December 3rd, 2021, 11:16 p.m. Now, we know from all of the objective evidence, the testimony, the video, everything that the officers testified to, they were on scene before 11 p.m. You don't deny that?
No, I don't.
You don't deny that there were hundreds of officers on scene?
I don't know how many were on scene.
Okay. How many did you see when you got pulled out of the art studio?
Honestly, I don't know. It all happened so fast. I knew there was more. There was a few. There was more than a few, but not.
You saw the body
hundreds.
camera footage.
Right.
Okay. I do want to make a point so everyone's aware. This exhibit was just made admissible this morning.
Correct.
Okay. So we actually just received it this morning, and when you testified yesterday, you didn't know this exhibit was going to come into evidence.
Correct.
Okay. I want to talk to you now about the night before the shooting.
Okay.
November the 29th, 2021. You had testified that you got into a fight about grades with your son.
Correct.
Okay. Is that because you checked Power School?
Yes.
Okay. During that fight, did you lock your son out of the house?
We did not.
You don't deny that he was outside of the house?
He did walk out of the house. He was upset.
Okay. You told us that you took his phone.
We did.
That's not true, is it?
That is true.
On
we took
November the 29th, 2021, your son filmed a 19-minute video while he was outside describing what he was going to do the next day.
What time was that taken?
10 o'clock.
I don't know if he got it back. I know we took the shooting range away and we took his gun away, so I don't know if he got it back.
Okay. Now, all of the times that you were at the barn, there was nothing stopping you other than you told us he didn't want to go, right?
Correct.
There's nothing stopping you on November the 30th, 2021 from taking him home.
Correct.
Nothing stopping you. You know, actually, I want to go back to what you just said. You took his gun away.
We took the shooting range away.
You said you took his gun away.
No, I said we took the shooting range
I think
away.
you said gun to it, though.
Your son could have been with you those 3, 4, 5 times a week when you were at the bar.
He could have, yes.
Your son could have been with you on those times when you were with either Mr. Malash or somebody else.
No.
In the weeknights, he could have been with you after school, after work.
I wasn't with Mr. Malash at those times.
Okay, the other individuals then.
I wasn't with them either at those times.
According to the
I
friend finder,
might have messaged people at those times, but I was not with anybody at those times.
he could have been with you on the Halloween party.
He did not want to go. It was a bunch of little kids.
And on November the 30th of 2021 at 12:51 p.m., you could have been with him.
I could have, yes.
And you didn't.
Nope.
Nothing further.
Redirect.
Oh, that's it.
Thank you. Mrs. Crumbley, I just have two areas of questions for you. Mr. Keys played some recordings. Who were you on the phone with in those recordings?
And my dad.
Okay, so you asked a couple of questions about calories, and then what was the other one?
I guess a child tax credit.
Okay. How often did you speak with your dad?
During the summer, it was every day. They went back to work. It was just on the weekends. They're both teachers.
And how many hours a day do you spend with other people?
Sometimes it's none. Sometimes it's when they walk by my cell, I'll talk to them. But I'm locked down 23 hours a day. I get 1 hour out by myself. I talk to my clergy lady weekly, so I see her. Sometimes I talk to the church priest, or I'll talk to my attorney. But that's about the most human contact I get.
So I guess one of my questions is, when you do talk to people, you talk about, are there more conversations than just those?
Right, there are.
Okay. And then that night on December 3rd, going into the 4th, after 11, there was one phone being used, is that right?
Correct.
Whose phone was being used?
It was my burner phone.
Who was using the phone?
My husband was using the phone.
Okay, were you also using it?
No, I was using my other phone. So he started using my burner phone. I used the one with the regular phone number to do anything on.
Okay, so these messages are from the burner phone.
Correct.
To myself and Mario.
Correct.
So the ones after 11 o'clock, so at 11:17 or whenever these texts came in, what were you doing?
When I saw the video of my husband going to the car and having a cigarette, I knew I was probably sleeping at that time, because I did not like us not being together after what happened to us on the 30th when the police came to our house. So if he went out to have a cigarette, without me, it was most likely because I was asleep.
Okay, when guns were in your face and we saw that on the video, before that, had you been asleep?
Yes.
Are you absolutely sure about that?
I'm positive.
Okay, I have no further questions. Thank you.
I'm going to excuse you for about 10 minutes, and we'll see where we're headed. Okay?
All rise for the jury.
That's it? Damn. I thought
You may be seated.
the prosecution was going to come in more.
Okay, so tell me what's happening now.
Can I have just a moment with my client? Sure.
Can you rest our case? Yeah, I thought the prosecution was going to have more. I mean, he was going hard, right? But...
And Your Honor, at this time the defense rests for closings.
Great.
We are not at this point. We need at least a 30-minute.
Yeah, you ready?
Counsel said she had 2 other witnesses today, but we can be ready in 30 minutes.
It was Mrs. Crumbley's parents. Those were very short witnesses, so...
Well, that's fine, but...
I wouldn't know how long they are. I just... Okay. She said there were 2 more other witnesses.
I don't have an objection to them having 30 minutes. I'm just saying we're ready to go to closing, which is good news.
I'm not surprised she was planning on resting, but she didn't tell us that, which is fine. But her client just testified to some things that we really do want to incorporate into our closing. So.
Okay, well, that raises a couple of questions. One, okay, so you rest. Are you calling anyone in rebuttal?
That's what I want to speak with the prosecutor about.
One moment. Hold on.
Sorry.
Okay.
I'm so sorry. This is 11.
Okay, well, do you guys want to break to just...
If
yes,
we could.
Okay, so they have a right to rebuttal, so I'm going to...
Okay, things are changing a lot, sir.
Okay, so I'm going to allow them to have that discussion.
Okay.
But as I indicated yesterday, I think that we've been back and forth on jury instructions, and I submitted to, I don't know...
Carly says he proved she was a liar.
What I believe would be the final instructions after consultation with you, and there might be some fill-ins, there might be some things, so I need to know what those are. I make the attorneys sign in law that they agree on before closing, so...
Your Honor, just so I can make sure I have the absolutely most updated copy, Ashley, would you email it to me? Okay,
we gave it to you a week and a half ago, but
I just,
we
I have
have
so
it.
many files.
We
I
have
just
it.
want to make sure that I'm looking at the right one.
We-
And I think
we do have it.
I think we're actually good on those. So
I thought before we started we agreed upon the instructions. I recall that.
Oh, we
first
did,
day.
but sometimes.
I just need to double check. We pull out like defendant not testifying,
Right.
like the simple things.
Yeah, some small things can change. Okay, so you got it. Do you want to get back to me shortly and let me know if you're going to have rebuttal?
Yes.
Yes, Judge.
Okay, because that will determine what we do next.
Sounds good.
Thanks, Ron.
All right.
All right. Can you please be seated? You guys have the jury instructions, right?
Yes.
Oh, sorry. I thought you were doing it when I was talking to her.
Wow. Okay. Wow, mamma mia. Carly said that the prosecution proved that Jen was a liar. One of the things that Carly was saying was that, and the whole reason I guess for bringing up adult friend finder, they muted it now, was that she had said that she only had this like one affair, I guess, with this guy, the firefighter. And so they brought this, because people had said supposedly it was up to like 3 people that she was messing around with. The father, the husband, was cheating too, apparently, allegedly. But she was going on and having alleged excursions on adult friend finder. But she said she set up the meeting but didn't go, blah, blah, blah. You know, I guess they can't prove it. I don't know if they proved it. I mean, like I said, definitely negligent parents for sure. I mean, I didn't even hear when they said it earlier in the trial, but I heard it now during the cross where she literally bought the bullets that Ethan used, or the school shooter used, to kill those kids. They literally bought the gun. I also thought it was kind of funny when he was like, you gifted the gun, right? And she was like, oh, described gift. What does it mean, gift? As if we don't know what gifting means. And he was like, oh, the Instagram post you made saying it was like a Christmas gift. I mean, I don't know. But the prosecution's getting a little snippy too. They're a little bit kind of, even now where she was like that. It would have been interesting to see the parents testify. I guess they decided not to. I wonder why Jen's parents didn't testify. So you want to pull? So you guys want another pull? Let's do another pull. And the fact that the gun had the gun case had the default lock. I mean, I don't know. Is it enough? Is it enough? Now they got to do closing. So we're going to be done today, I guess. We'll probably be done today. Well, it depends how long the jury takes. This is good because the Montgomery trial starts next week. What will the verdict be? Let's do a poll. And while we wait, I'm going to do something else. Guilty, not guilty. It's a good day today, man. Hung jury. It's a good day. It's a good day. It's Friday. We're at the end of the trial. We made it in time. It's been fire. Kristen, thank you so much for the 50. Said I voted hung jury until now. Her testifying says it all. Hashtag free dag. Hashtag guilty. Oh my gosh. Let me see if this works. Hold on. I gotta watch this on my phone. Hey, it's Friday. Trial's over. Super chat. I gotta rewatch this on my phone. Oh. I don't know. Let's see. Let's see how the chat perceives it. Did it work? Let's see. Oh, snap. The pessimist in the chat says no. The one pessimist that's always nasty says no. Wow, it's mixed for the polls. It's very mixed. So 53% say guilty. Wow, okay, it's mixing up a little bit. 25% say not guilty, and 22% say hung jury. It's mixing up. Yeah, we got almost 3,000 in the chat. I think they're taking a 30-minute break, right? Let's see if we can find something in the meantime. Crumbley. Damn, 2 kids pronounced dead after being found in car on the side of 95. Oh, is that what? I heard 95 was shut down or something.
We begin this 9 a.m. hour with breaking news. We're learning details in a highway horror. An exit off of I-95 shut down after an incident involving 2 children.
Miami-Dade police have confirmed those children are dead. The woman they were with in the hospital is in critical condition. Let's turn to Leanne Motorholm live from the scene with more on these heartbreaking details. Do we have any updates, Leanne?
Well, they did provide a truly disturbing update a short time ago. That is, investigators with the Miami-Dade Police Department. All of this unfolding along the northbound lanes of I-95, specifically the ramp that heads to the turnpike. I want to take you to some video because this is the vehicle that police were focusing their attention on throughout the morning. They say 2 little kids were found inside that SUV. The female driver of that vehicle was injured on the train tracks below that overpass. Now, according to Miami-Dade police, they say that they began to receive calls for help from other drivers just before 2 o'clock this morning, reporting 2 children were unresponsive inside of a vehicle. When police arrived, they found a boy and girl around the ages of 3 or 4 years old inside of that vehicle. Now, police say that as soon as they arrived, a woman believed to be the driver of that SUV jumped from the overpass to the ground below. We also have video of that as Sky 10 flew over the scene once the sun rose, giving us a better idea.
As far as the jury, I had an article last week that described all the jury members. I don't know where it's at. I don't know if you can find it, BL. Let me put it on the top of the screen so people know it's a 30-minute break. I don't know when they're coming back. I'm excited, though. I'm happy that this is kind of coming to an end today. Also, we're going to have to figure out how long the jury takes. 828 Caroline, thanks so much for the gifting. There was an article that I had that had the whole breakdown of the, the I don't know if it was age, but gender, color, careers and stuff. jury. Let me see. Is it this one? I found it. Wait, did I find it? No, I didn't find it. I didn't find it. Damn it. Huh. Yeah, I don't know where it's at. Let's see, jurors. Try that. Yeah, I'm sure we'll do verdict watch, I guess. I don't think it should take long. I don't think it'll take hours. Hopefully not. Oh. Danilo Cavalcante. Had a court appearance.
Danilo Cavalcante will be in court today. He is the convicted murderer who escaped the Chester County prison last summer by scaling a wall and a fence, and then he was finally found after a 2-week-long manhunt. Chief investigative reporter Joe Holden is live outside the courtroom in Chester County. He's got the latest. Joe.
Hello, Natasha. Good morning to you. Here we are standing in a rear driveway of the Judicial Magistrate's office here in Chester County, Kennett Square, where we've just gotten word that Danilo Cavalcante running about 20 to 30 minutes behind schedule. You see the police officers and law enforcement behind me waiting to take him into court, where he will face a preliminary hearing. This has nothing to do with charges of murder. This speaks directly to the allegations, which we know are almost a foregone conclusion, that he did escape the Chester County prison and then went on an almost 2-week run, eluding law enforcement until his capture in a thick brush of woods in northern Chester County. Of course, many people on edge here for almost 14 days as this convicted killer ran amidst their neighborhoods and through their properties, and as police were following on his tail. What we expect to hear is argument from his attorney that somehow these charges should not be filed, and they are trying to have some of these charges dismissed. That is the whole point of a preliminary hearing. So we will wait and see what unfolds in this courtroom. Again, we are delayed a bit with Danilo Cavalcante not expected to appear for another 20 to 30 minutes. We'll have the latest.
I guess they didn't do it live. Let's see. I guess not. Is Nick still out there? Oh, he got off. Four charges for involuntary manslaughter. The poll so far says, okay, we were 53% guilty, 26% not guilty, and then 21% say hung jury. Anno Zoo, thank you for the membership. Chrissy, thank you for the super chat. Shannon versus Mark Beef, number 1. 9:48, 8 a.m. for over under. Zoomer Mom, thank you for the membership. Sleuth Investigate. Hey, I didn't even get to check. If you're in the chat, can you do it again? Tag me and type in the chat. Let's check it out. I forgot to look for it already. 828 Caroline, thank you for the membership. And Blue, thanks. Oh, 828 Caroline, thank you for gifting the membership. And Blue, thank you for gifting membership. Amazing. Adult friend finder. Oh. See if there's anything on Twitter. Crumbley. Jennifer.
Later in the thread, you say, don't do it. So when you hear there's an open shooter at the school, I want to know in your mind, what do you believe is happening?
Well, my husband had called me when I was still at work, and he said there's an active shooter at Oxford High School, and I can't get a hold of Ethan. And that's when I opened my phone and I saw the I love you text. And then I texted him, are you okay? In the process of it, I was getting my stuff and running out the door, letting my boss know that I had to go to my son's school. It was on 75 when I was trying to get to the exit that my husband called me and he asked me where I hid the bullets, and I told him, and then he said that the gun is missing. So instantly I'm like, oh my gosh, he's got the gun. I didn't actually think he was at the school shooting it. I thought maybe he walked home and got the gun and was in the field by the school. I didn't imagine my son actually going into a school and shooting. And then when we got more updates, I was like, oh my gosh, he's a school shooter. He's going to kill himself, because in my mind, that's what school shooters have done. They've killed themselves after. So I yelled in my talk to text, Ethan, don't do it, because I thought he was going to kill himself.
At that point, did you think Ethan had killed anyone?
No, I didn't even think he shot anyone at that point.
Oh, that was your explanation? A lot of people here in the Twitter feel sympathy for her. I said, I feel so sorry for her. Poor woman. Her son had targets on the wall with bottles of alcohol, holes in the ball. How is that a normal kid? That's like the kid in Toy Story movie who kept breaking things.
This morning, prosecutors unveiling a first look inside a police interview room with the Oxford High School shooter and his parents hours after the shooting.
Why? I love you. I love you. I love you.
His mother, Jennifer Crumbley, now on trial, facing 4 counts of involuntary manslaughter. Prosecutors say before asking her son why, she sat calmly with officers, often scrolling through her phone.
I really wish we would take your mom.
The parents had the opportunity to take their son home from school that morning. Counselor Sean Hopkins testifying he called the Crumbleys after finding disturbing drawings on the shooter's math worksheet with the words, "The thoughts won't stop, help me." Hopkins said a teacher reported the Crumbleys' son watching a video of a shooter firing at multiple people. Wow. And Hopkins said he was confused when the Crumbley parents didn't seem overly concerned with his mental health. From Crumbly's with the words the thoughts testifying he called the Crumbleys after finding disturbing drawings on the shooter's math worksheet with the words, "The thoughts won't stop, help me." Hopkins said a teacher reported the Crumbleys' son watching a video of a shooter firing at multiple people. And Hopkins said he was confused when the Crumbley parents didn't seem overly concerned with his mental health.
I'm confused about you too, counselor, whatever the hell you are. I'm concerned about you too.
Health.
She sat down in the chair, felt a
Bring him
little
to
bit
trial.
distant.
What do you mean by that?
More just kind of like, it felt like it was a little bit of an inconvenience to be there.
The unprecedented court case involving the mother of a convicted mass murderer in Michigan. Jennifer Crumbley is her name. She's charged with involuntary manslaughter for allegedly failing to stop her son Ethan from committing a deadly school shooting back in 2021. Her husband James Crumbley is also charged, and both have pleaded not guilty. Elaine Quijano was in court for the first day of Jennifer Crumbley's trial.
So it entered here and exited here.
In a Michigan courtroom yesterday, Molly Darnell described coming face to face with the shooter.
I realized he's raising a gun to me.
BL sent me a mini juror thing. There are 17 jurors, 5 of whom will be alternates, mostly a white jury made of 10 women and 7 men. 11 of the jurors are parents and 6 are not. Interesting. I wish I could find that article. Let's see, history. I could look in history. Type jury. How do you search this thing? Yeah, maybe I gotta give it up. Sure, it's in here though. Da-da-da-da-da. I think this is it. Bang! I got it, baby. All right. All right, let's check this out. Because this article breaks it down a bit. Even though they're not supposed to know the jury, somehow they got all the background on them. So, Jennifer Crumbley's jury includes several gun owners and mostly women. So you got to think about the jury, the people that are on there. Well, that maybe sway things. The jurors include, juror 1, white female, works in human resources, has 2 adult children. Her father was a hunter. I gave up watching all the news in all forms 6 years ago. I'm pretty uninformed regarding her father's guns. I know my dad's guns were always locked. It was not for the children. I guess during jury selection. So she could have a certain type of feeling about the gun was locked, but it was very, very careless to have the default code of the safe. I can't believe, too, when Jennifer took the stand and they were like, oh, do you have those defense bullets or whatever? She was like, what? What's that? I don't know what that is. What? You bought it for him. Oh, yeah. He just told me to buy it, so I just bought it. Okay. Juror 2, white 26-year-old married male, says he grew up in a strict Christian home. He works in sales for the mortgage industry. Can't talk. He took hunter safety classes when he was 16, but is not an avid hunter. His father has a gun and has a concealed carry permit. The juror said he doesn't have strong opinions on guns. He doesn't have cable TV, tries to stay away from social media, and despises TikTok. Yeah, this person locked in a box. Locked in a box. By the way, I have the trial thing unmuted going, so whenever they come back, we'll hear it. All right. Okay, so despises. I can't blame him with the TikTok thing. All right, juror 3, white female hairstylist. She says she's familiar with the case, has no issues with guns, and can be impartial. Juror 4, white female engineer. Husband is a lawyer. He's probably watching. She said she can be fair and impartial, and that it's not a good/bad parent decision. The jury will be making this case. Okay, it's not a good or bad parent decision. that the jury will be making on this case, stating that's not what we're here for. She did note, however, that she no longer goes to movie theaters or shopping malls following a mass shooting in Colorado that shook her sense of security. And people in the somebody in the chat earlier too was talking about. He was asking if I'm the perfect parent. I think Veronica, and I jokingly said yes because I thought that's kind of like, come on, right? We all know there's nobody. But to me, it's almost like the answer of like, there's nobody perfect. We know that. We're talking about a mass shooting. I think some people see this stuff and see Jennifer maybe getting judged, and maybe because of their own feelings about the way they parent or whatever, they feel like it's an attack on them or something. Some people, this is a serious situation. The child shot and killed 4 people, so I'm not sure why anybody would compare themselves, or maybe they just feel people are being judgmental to Jennifer. Maybe they're going too hard on her. Yeah, but I don't know. She's on trial. She went on the run. She bought a gun for the kid. You know, I guess these are the consequences. It's an unprecedented trial for sure. Okay, juror 5, white female, married, has guns in the house and says they are locked up. Okay, she has 2 grown children and recalls taking gun safety classes as a family when the kids were in elementary school. She works for a bank and her husband is in advertising. I feel like I can be fair. And a lot of people that are gun owners, like some people, there's people out there that are very, very responsible, and they're not anti like teaching your kid, I guess once they get old enough. I don't know when that would be. You know, everybody makes their own decision, but there's people that teach their kids how to the proper use. And of course, people lock it up. And probably if you had any inkling of your child seeing, hearing voices, I mean, that's stuff with that math paper or whatever paper that was in school that Ethan drew, bro, that should have been alarming enough, right? They didn't, so they showed that drawing to the parents before. People are freaked out because this case will set a precedence. Good. Some of your asses need to be locked up. Yeah, I don't know. I really don't know if she can be found guilty or not. I don't know. Like, have they proven beyond a reasonable doubt that she, like, literally knew he would go do this? For sure, she was negligent. For sure. The paper thing was before, right? I mean, that to me right there, even the school, I honestly feel like the school should be right there. They should be doing in a trial, a criminal trial. They should bring their asses in too. I don't know. Tough to say. I mean, the whole cheating thing, man, or whatever, you know, they were both cheating. You know, it's really not about that. It's about the manslaughter, but they're trying to point out, they say that she lied. They're trying to go at her credibility, I guess. She's being charged with involuntary manslaughter, 4 charges. I mean, this is like, you know, it's pretty much a life sentence if she gets charged. I don't know how much years they're going to give her. So, okay, juror 5, white female, married, has guns in the house and says they are locked up. She has 2 grown children and recalls taking gun safety classes as a family when the kids were in elementary school. She works for a bank and her husband is in advertising. I feel like I can be fair. No. You guys are messed up. I haven't seen that thing in Houston, though. You change your vote after the cross? Yeah, Courtney says the cheating is to prove she didn't take care of it. Yeah, that's what it was too. You're right. It wasn't because I guess you're right. If you're just looking at it this face value, then people are like, well, what does that have to do with anything? And they're just trying to tear her down. The prosecution really is just doing their job. I mean, like I said, this is like an opportunity, and so you got to jump on it. You're not just gonna like, oh well, let me just take it easy. But Courtney said they're trying to prove she didn't take care of her child and tend to his needs. And that's why I guess they kept bringing up how often she spent time with the horses, and well, she did spend a lot of time with them, you know. And then the other, I think was it the skiing thing, 10 hours a week or something like that. They were just trying to pull time away and to be like, you could have been, you could have been helping your son. But yeah, like the notion of like perfect parents, that's just like ridiculous. You know, you're gonna learn and make mistakes and whatever, and you know, but there's just some egregious shit out there. You know, I mean, we can't give everything a pass. God damn. Okay. So that's that. Juror 6, white female, married and retired compliance specialist. Her husband is a retired meat market, and you got to see it from my perspective. You don't have to see it from my perspective, but my perspective, my daughter's only 7, so there's people here with like teenagers and stuff or older kids. I haven't gone through the craziness yet. You know that people often tell you, well, wait till you see when they get older. You know, cherish these moments, whatever, which is what I do as much as I can. I think I'm a pretty decent parent. Like I've done. I mean, you don't know half of the story, but I've never been like, I don't know what the right word is. I think I'm a pretty good. All the shit that I've gone through, and I take really good care of my kid. But yeah, of course, I've made mistakes. I always think I could do better, even with YouTube and everything. Chronic Christie said Jennifer claimed she was a hyper vigilant parent, and the other thing though, but at this age too, I've seen kids that are wild as shit that you can tell. I don't know what these parents are doing. I don't know if the kid has some type of mental thing going on. I've seen some couple of years old, wild, ravenous kids. I don't know if that's just in them. I don't know if there's something going on at home, because I have seen some environments that these kids are being raised up in, and then you have to kind of look at the parent, but at the same time, I guess, what can you do? So some of those people, those same people too, that are raising their kids in some wild, crazy environment, are the same ones that want to be like, oh, well, how can you say that? Why? That's not right. Nobody's perfect. So they do all kinds of wild shit. Nobody's perfect. Okay. Amy, thank you for the 10 memberships. Appreciate that. Thank you so much, man. Amy at the top. Chronic Christie says Jennifer claims she was a hyper-vigilant parent on direct, so had many adult activities that made it impossible. It does go by so fast, right? I haven't experienced the teenage years. I remember my sister at one point when she was getting a little older. I remember those times when she'd just go lock herself. You know, teenage kids lock herself in the room. And she wanted to go stay with her dad for a little while too. So she went to stay at her dad's and stuff. Little tiny rebellion state. I haven't gone through that yet. So there's other parents that are looking at me like, wait till you get there. You know? So yeah, I have no idea what that's like. I mean, I know I wasn't crazy in my teens. I got crazy like in my 20s because I stayed so sheltered and whatever. And so I think after my father passed away, that's when I went kind of crazy. And yeah, my mother had no idea the shit that I was doing. That's another thing where people are like, you know, watch your kids. At a certain point, you know, you can't control everything. You can try maybe, but you can't control everything. I got 4 adults. They're not perfect, but none of this BS. I mean, and look at the Kansas City thing, right? The Kansas City thing, those guys are full grown adults, right? But there were some family members saying that like there's no way, like they don't do drugs or something like that. There were some that were like, yeah, it's possible, but they weren't into it like that, or not addicts. But you don't have to be an addict, and they had no idea what was going on with these 3 guys. And I'm sure these guys were just partying. They have family, whatever. You know, I'm sure they weren't bad people or anything like that. So You got no idea what they're doing. Chronic says, I get it. I have 3 teenagers. I check their phones regularly. And they still manage to, especially with the technology today, they still manage to get stuff by me. Yeah, they got all kinds of apps. You can hide stuff and disable things and multiple phones. Maybe somebody else buys them a phone. I forget what story it was. That it was one a long time ago. I don't remember. But some girl had like an extra phone. And so her parents didn't know she had an extra phone. And that's how she would communicate. I think there was even a movie or something that I watched like that. Was that? I don't remember. All right. So the next one. This is interesting, though, the jury makeup. So we got that one already. The recalls taking gun safety classes. I mean, I'm sure some of these gun people, they're not going to like the way this thing was stored with a default password. Juror 6, white, female, married, retired compliance specialist. Her husband is retired, a retired meat market owner, and her daughter is a special education teacher. She was on a jury many years ago, but remembers little to nothing about the case. Juror 7, white male doctor. Ooh. Doctor got called in, who said, I've seen a lot of gun violence, owns multiple guns that he stores in a safe. He calls himself a very strong proponent of the Second Amendment and goes to shooting ranges about once a month, maybe every 2 months. He has lost 2 loved ones by unaliving by a gun. So that's really interesting. That juror. So he's a very strong proponent of the Second Amendment and goes to shooting ranges, but he's also lost loved ones by unaliving with a gun. So I don't know. What do you guys think about that? Like, how do you think that juror would sway? Because I feel like you can be pro-gun, but also like very, very like you need to follow the proper, safety guidelines. Lock the thing up, especially with kids. Lock it up. Or if you knew there was a mental, that actually he could sway against Jen, because Ethan had some type of mental issue or mental health problems or crying for help, and his loved ones clearly had something going on, and they unalived themselves. So he might go against Jen. Feral kids, right? Honestly, with my daughter too, like I even try to keep her away from some kids. Some of these kids that I've seen, some of the conversations that they're having is like almost like borderline almost sexual or something. Like, I don't want my kid. I know they're gonna grow up and they're in school and stuff like that, but I'm surprised that at a young age. There was one friend of hers that I was thinking like, I don't think it's gonna happen anymore. I'm good. I'm good on that. And then even her mother told me there was another friend that she had that the girl was kind of very, and I mean, the girl's even younger than Maddie. I was like, nah. The kids really, really get influenced like crazy. I guess when they're in school, there's nothing you can do. Maybe the only thing you can kind of control is what school you put them in. And maybe if you can show up to some of the school trips. I used to, with the last school, I only show up to a PTA thing. I want to go, I signed up to the volunteer thing online. They have to do like a background check. And then once you get approved, you get to go. I want to go to one of her trips because sometimes I think it's kind of good too for the kids. You show up, not just for your own kid, but you show up to show the other kids, like, I'm here. I'm watching you. I'm keeping an eye. Maybe come back here. I want to do that again because I only did the PTA thing. And I've walked with her inside the school a couple of times and I've seen some of the kids and their parents, but I haven't gone like on a trip yet. The last school we did, I went to, it was really cool. They did swimming classes at the end of the summer or the end of whatever it was. The end of school, like right at the end, I did swimming stuff. And so like I drove to the school, we get on the cheese bus, I'd ride the cheese bus. I got to see her friends and talk with them a little bit and some of the other parents and stuff like that. A couple more kids, I'm already like, I'm at limit. Oakland now trying to intimidate the kids. They actually like me a lot. I'm actually really good with kids. So, I don't know. This is an interesting juror. I wonder if they'll keep him on or they're going to make him an alternate. I don't know if he's going to be an alternate or not. Juror 8, white male automotive engineer with twin teenagers. Okay, he has a collector's gun that belonged to a relative who served in a war. He remembers being a kid and learning how to shoot a shotgun, though he is not into guns as an adult beyond owning his collector's item. Interesting. This is a really... The gun thing doesn't surprise me because I guess there's a lot of like that in that area, right? That's what they were saying. They had the... I jokingly called it shoot your gun before going to school Wednesdays. Not really... I mean, that's literally what they did. It was a common thing for, I guess, I don't know if it was like a... I don't know what it was. It was a common thing for them on certain days to go before school, go somewhere, and they all go shooting or whatever. Not a great joke, but the context matters. That I don't know. I guess that's the culture out there. Some people don't get that. I guess it's not something over here. It's a cool thing that they do over here, but over there, I guess so. Okay. Juror 9, white female, first grade teacher, married with 2 grown children and 1 older teenager. I don't have guns, but I understand why it's legal. Okay. Juror 10, white male, works in vehicle logistics. He owns several guns and remembers tagging along with his dad. That's a common thing. I know I have some friends like that. That's not how I grew up. I remember one time my father showed me, which is kind of ironic the way he died, but when I was a kid, he had shown me how, like, I think it was like a 9mm, and like he let me hold it. And I just remember how like heavy it was. I was like, oh wow, I was kind of a little fascinated, and that was it. But in certain places, the country or whatever it is, certain types of culture in life, that's the way it is. It's probably how it was too back in the day. You got to learn how to shoot a gun. Remembers tagging along with his dad to gun ranges when he was 10. Well, he said he just tagged along. His best friend is a police officer in a jail, and his girlfriend is a personal trainer. Juror 11, single white female, no children. She has a gun for personal protection. Worked 16 years as a police officer for a university. Interesting. Now she handles parking tickets. Okay. Oh, the alternates are random. Okay. That would be so interesting if he gets picked. And that what Inzing Johnson said, or maybe that's a good question. Should kids have guns? Or I don't know, or teenagers? Luffy says, I used to pick up my little brother. It made my little brother feel like he had a bodyguard, but other parents and his friends would mingle with me. That's what happened with me too. I think it's actually a really, really good thing to kind of show up, co-mingle, have some conversations, let the kids see you and parents and teacher and all that stuff, you know? Okay. Okay, so juror 3rd. Okay, no, I'm skipping somebody. Let's do this. Delana says, with my father being LE, have been around guns my whole life. Wow. All right, they're still gone. It's been almost 30 minutes, but we'll keep going. Juror 12, black male, single, no children, works as a manager in sales. His father had a gun and taught him about gun safety. Juror 13, single white male who works with a powertrain engineer. He doesn't own any guns, but went to a shooting range with his girlfriend over the last year for fun. He grew up in Nebraska. He says his engineering brain makes him a good juror, as he will be able to carefully analyze evidence as he applies it to the charges. Ooh. Defense attorney Shannon Smith joked with him that we don't let engineers sit on juries because they typically see the world in black and white. But there's a lot of gray space in this case, Smith said. The juror said he understood and that he could be fair. Okay. Juror 14, white male parole officer who says he's fair to a fault. Oh. And he sees success stories in his work involving prisoners who've turned their lives around. Oh. He's married, has 2 older teenagers, has a gun at home, keeps them in a storage unit. His kids are not interested in guns. Before his 20-year career in law enforcement, he worked for the government's Medicaid and food stamp programs. Interesting. I wonder that whole thing, fair to a fault. That's such an interesting breakdown of the jurors. I don't know now. Could it go hung? Single juror 15, single white female who works as an account manager for rental properties, lives with her parents. Amazing. No information as if she has a gun or how she feels. Okay. Juror 16, with a white married female with an infant son, works in billing for university students. She is originally from Upper Peninsula and used to be a hunter. She remembers getting days off from school as a kid during hunting. Oh, that's what it was, hunting season. During hunting season, but no longer hunts. Her sister was a target of a school shooting that was stopped. Oh. Wow. Oh, she could feel some kind of way. Back in court? Not over here. Not over here. Let me check out law and crime real quick. Sleuthie, I keep missing your message. I'm sorry. Law and crime trial. No, they're not back yet. All right, we're almost right here at the end. Pam, thank you for the 5 months membership. Thank you all for your hard work during these trials. Thank you. The weirdest jury ever, right? I don't know. Okay. So yeah, this person has an infant son, works in billing, used to be a hunter, remembers getting days off during hunting season, no longer hunts, but her sister was a target of a school shooting that was stopped. So she really could feel like a personal feeling about this because it's affected her family, her sister. That's that's an interesting one for sure. Juror 17, white female, married with 2 school-age children and works in veterinary medicine. When I think about this case, I feel rage. She said of the Oxford shooting, she grew up with guns, her dad hunted, and her sister is a competitive shooter. Though she said her husband is very anti-guns and just doesn't want him in her house. So I wonder, do they have guns in the house? Or they don't keep guns in the house because whatever. My husband very anti. I wonder if that could work out. Somebody that's a pro-gun person and they're married to an anti-gun person. Could that work out? Crystal said, I'm about 15 minutes behind, but honestly, Mel, if you were on trial, they would say you spent too much time on YouTube, and now with your kid, there's the same thing. I don't really know how you could compare that to that's the same thing, because you could try to make that argument, but what I would argue with you is that most people have to work like an 8-hour job, right? So you could try to argue that, but this is my job, right? And so most of the time, like when we're not doing, first of all, I'm really blessed to do what I'm doing. Like I'm super thankful because I can take my daughter to school, which most people can. I can pick her up from school. Some people can't. They have to like send their kids on a bus and stuff like that. My daughter's sick. I can go pick her up. I have a lot more freedom than the average person. But then also, what am I not supposed to work? My 8 hours? Like most people do. Not only that, when I did have a job, right? When I did work, this is my job, but when I had like a regular, like 9 to 5 or whatever, it was really, really tough because I'm thankful I got a day job, right? Because I used to work the afternoon. That sucked. When I got the day job, I would get Maddie ready for school, rush to take her to school. I'd go to work. I'd work till 5 o'clock. Okay. The benefit of this is I can actually get up and leave now when I go to pick up Maddie from school. in the afternoon, Maddie would have to stay in daycare till 5. I didn't have anybody to watch her. That's the reality for a lot of parents, unless they have a grandparent or somebody else that they can pick them up from school, whatever. But Maddie was daycare. She had to stay there till like 5. Or actually after, because I would get out at 5. It would take me 30 minutes. By the time we get home and everything, it's 6 o'clock. So they could try to argue that with me. Maybe. I'm sure they'd find ways or reasons to try to throw me under the bus, which is the reality. You know, the reality of how if you're on trial, they're going to try to scrutinize everything you do. But I'm actually very thankful that I have and do what I can do. You know, but it's still tough. It's still tough. I mean, I still, sometimes wish. I mean, I don't know. I'm really grateful because I have her a lot of the time. Even during COVID, when they shut the schools down and Maddie was home, we got to spend a lot more time than we ever have. The reality is most parents aren't able to be with their kids the entire day. So, and even Jennifer, they're not scrutinizing her for going to work. I guess they're scrutinizing her for what they did after. Now, the YouTube stuff, it's a lot of work. Like, there's a lot of times behind the scenes, like right now, like my girlfriend comes and helps me out a lot, like after she gets out of work, because there's times too where I'm here editing after the trial is done, like those 2 videos that I posted yesterday, or sometimes researching, or sometimes whatever, it's a lot of like sacrifice. Whitney, thank you so much for the gifts. 5 memberships. Appreciate it. Wow, we're doing a lot of gifts today. And Amy, thank you for the gift. So I don't know. But the situation with Ethan is extremely, I think, vastly, even if you try to compare it to maybe other school shooting cases where, I don't know, the parents aren't held accountable. I just think that they're pointing at these parents for a lot of reasons. I don't know if they've proved beyond a reasonable doubt, to put murder involuntarily, well, not murder, I guess. The technical would be involuntary manslaughter. But like just the fact of like your kid being depressed and you don't like try to help out your kid, take him to a doctor's office. I don't think she got any treatment for him. Take him to a doctor, get some type of counseling, Let me see. No. Oh, wait. Wait, is that what she did? Amy did 69 memberships? Oh yeah, I used to work graveyard. That sucks. Shawnee says, Mel, I do not have to explain anything. I work midnights just so I can be home for my children during school hours, doctor's appointments. People need to get a clue. Yeah, it's really, really tough, man. I mean, the thing is too with these kids, especially when they're younger like that, time freaking flies. So yeah, sometimes I feel bad. Sometimes I'm like, damn, I wish we do a lot. That's why I make it a point sometimes too. Like you can check on my Instagram. I post a lot of stuff with Maddie. It's not everything, but like I sometimes post little things that we do or whatever. But to get where you want to go, you got to grind. You got to sacrifice. I mean, you don't get places just kicking back and just hoping and letting things happen. You got to, to provide and like to have. Maddie, bro, so spoiled. I wish I had the things that, she has so much more than I have had growing up. Like the freaking, all that stuff and all the things. My mother did good, but she has way more than I had, And then the thing with Jennifer, I'm breaking hearts. And the thing with Jennifer and the Xanax bars, I really think, unless she really took 4 2-milligram bars, because that's like, damn, okay. I think her attorney should have came on the cross and be like, hey, Jennifer, do you know what strength of Xanax you took? Because if it was the 0.25 milligrams and you're taking 4 to equal 1, then that's a regular dose. That's not something crazy. The prosecution was making it like really bad. You took 4 or whatever. her defense attorney could have just came and cleaned it up if they knew that it was less than what they're saying it is, which they didn't say how many it is, but it just sounds bad. And it's a good way to like maybe trick people into being like, holy crap. But if it's the 0.25s and it equals up, 4 of them will equal up to 1 milligram, that's not a lot. That's true, Daylan. I said that's how it should be. We always want to be better for our kids. I think one of my few, I don't know, flaws would be like balance. There is like no balance. It's really hard to balance YouTube and life. But yeah, if it hadn't been for this, like this YouTube stuff, man, I would be working till like 5 something. Maddie would be stuck somewhere, whether it's school or aftercare or whatever. When she got older, maybe she'd have to walk from school or something. And me as a paranoid parent, I'm glad that I can go pick her up. She can come home right in the afternoon and chill here and not have to be at some aftercare thing or whatever. They could try to bring it up in court, but I have a catalog. they're gonna have to. We'll counter that shit. Yeah, so Carly says, and we seen them in the police cruiser. They didn't look zombied out. Yeah, that was a good play by the prosecution. I just think Shannon could have came back and cleaned it up. She should have touched on that. Even at the end of the day, like maybe it doesn't matter at the end of the day. Maybe. But it was put out there, so she should have taken the opportunity, I think, to just come back and be like, this is, I don't know if, would they be able to say like this is not allowed, and then maybe I don't know if the defense would be like, oh, you're not an expert in medication or whatever. But I still think you should have cleaned it up. Because now you're making them look like drug addicts. Like you should have cleaned that up. You can't just let that go. Yara said, I worked with a girl once who took 2 milligrams. Well, the other thing too was Ethan on Xanax. Because I feel like I've heard that can have some really bad effects on people too. Or like it can make certain people aggressive, really aggressive and stuff. I don't know how when it's a downer, but I've heard for some people they can get violent. Yeah, I don't know what happened with the court. They said 30 minutes and it took longer. But to what the other person said, yeah, I think if anybody's on trial and you're having to defend yourself, they're gonna try to run you through the mud. But the focus really is, were they egregiously, like Lawyer said, I guess egregiously negligent. I don't know if they really, I mean, do you guys really think that they knew he was going to shoot up the school? I don't know. I can say that they knew he would do that, but the signs were there, I guess. Definitely the signs were there. I mean, a picture literally depicting asking for help. There's a gun and blood. I mean, how do you get over that? So even if you want to try to argue like, nobody's perfect, there's not a perfect parent, whatever, you get a paper like that about your kid, you're not gonna like, I don't know, start thinking things. Maybe we should put this fucking gun away. This kid, I would be thinking like this kid's gonna shoot me. This kid's gonna kill me. That's kind of tough. That's I don't know. And I guess what the prosecution is trying to say in his journal, which I haven't even seen, they said the journal is brutal. Did my super chat show up? Let me see. Let me check the other screen here. Oh, I didn't see that. I'm sorry. Actually, let me get these. Okay. Sandy, thank you for the super chat. Thank you for the 5. Joy Wilson, thank you for the 5. Says thanks for all you do. Appreciate that, Joy. Hope you're doing good. I know we got to talk. Courtney, thank you for the super chat. 7 says, can you do the same poll after? Yeah, for sure. Can you do the same poll after closing and judge giving instructions? I'm curious if opinions will change. Love from British Columbia. Amazing. Yeah, all right. So let me shut the poll down for now. 53% say guilty, 24% say not guilty, and 23% say hung jury. Ilana says, both of my kids are earning master degrees while working, and my son plays college ball and is on a full ride between academics and athletics. So I spoil them both when I can. Amazing kids. Amazing. Kay Newton says, I think they thought he was going to shoot himself and not anyone else. And that's the argument that Jen made with that text message. Yeah, today it's going to be closing arguments. We're still waiting for them to come back. They took an extended period of time. I'm almost wondering, to be honest with you, I'm almost thinking that maybe they sent the jury to lunch. Maybe they said, you know what, the food's probably here. It's already 12. Usually the lunch comes a little bit before 12. It's already lunchtime. So they probably took the whole thing and just said, you know what, we'll just take lunch and let them come back. Let the prosecution and defense work on their closing. That's true, Jacqueline. My mother didn't either. She did encourage. Well, that was when I was older, after my father passed, like therapy and stuff like that. Jacqueline says, my parents never asked about my mental health, but as a parent of this generation, I have to ask constantly. Times have changed. That's what I agree too. Times have changed. There's internet and stuff like that. Like back in the day when there wasn't that much. There was internet. I was on the computer a little bit, but there wasn't that much like there is now. Like I don't think there was Instagram and like Facebook really. I wasn't even into Facebook when it first came out. So it's just different, and I think there's just so much influence and all these. I don't know whether it's TikTok, kids, all this influences and all this sexuality stuff being pushed, and kids trying to find their place and identity, and there's constantly identity being pushed on them, and if you're confused or whatever, all kinds of shit now than there was back then. Let's check out News Nation. Let's see what kind of updates. There's a few things with the Kansas City stuff. I guess we can talk about it because we got to pass the time. Check out News Nation. Okay, this was 15 hours. Let me see here. And I also think with Jennifer's testimony, at first I thought she was kind of standoffish a little bit with the cross, but then I think she somewhat did okay with just kind of like trying, not really denying stuff, even though she was caught with the whole adult friend finder, somewhat, I guess, caught, but just kind of just, yep, that's true. Yep. Just own the shit or whatever. Don't argue. Remember this guy that beheaded his father? I'm a messiah. Dad's a traitor.
He's now facing a murder charge. This was his mugshot. I don't think he's aware at this point, really, how serious things are. Not in that mugshot, anyway.
He's kind of smiley, somewhat, or not smiley, but like somewhat of a grin, maybe.
He's facing murder. He's facing abuse of a corpse, among other charges, for what happened to his 68-year-old father. By the way, that father's name, Michael Moan. Everybody said he was a really nice guy. Like, really nice. My next guest was there last night, just as the officers were emerging from that repulsive murder scene. Tom Sofield is a reporter and publisher of the LevitttownNow.com.
He was so nice. I don't know what happened.
Tom, thanks again for coming back to the program. So take me to the scene
Smoke.
last night as
Yeah,
you were
Mom,
outside
smoke.
the house and you watched as these officers went in and then saw what they saw and then came out.
Sure. Thanks for having me on again, Ashley. In this case, definitely one of the worst I've ever covered or seen. And for me, it all started out just past 7 o'clock. I received a tip from a source, a trusted source, that there was a call of a possible beheading in the Levittown section of Middletown Township. Seemed a little off to me. In 13 years in journalism, I've never covered a beheading. I don't know if our county's seen one in the past 50 years. I waited a minute at the office, thinking maybe it was someone in a mental health crisis or a false police call. And then we started to hear that the detectives were called in and the command staff was being notified. And I arrived about 25 minutes after the initial dispatch. And at the scene, you could immediately tell it wasn't a normal crime scene. The police officers, all very somber, which they usually are in a homicide, but even more so this time. As things started to develop, more people showed up. You could see the look on their faces. They were shell-shocked. And later in some further reporting, we uncovered that the initial 911 call was for a bloody scene in the bathroom of the house on Upper Orchard Drive. And the wife of the victim, she ended up finding her husband's body in the blood. And then it was reported to a dispatcher that he was decapitated and didn't have a head. And I'm sure the toughest thing she'll ever see. And
Thank you for watching. Go.
Cut it off. Beheading. I wonder if Nancy came out with anything with regards to Crumbley. Ooh. Oh, we could do something later. I ain't gonna say it, but I like it. Okay. Let's see. Yeah, we can do that later. Yes. Yes, Queen. Kayla, thank you for the 5 gifts. Thank you so much. Damn, man, didn't expect that we're gonna have to kill 3 hours. Or not 3, but like an hour, hour, 2 hour and a half.
I'm kind of losing my mind on this one, Alex. You know, I fully expected we were going to hear something about drugs in the toxicology report. That was not a surprise to me. But at the same time, I didn't expect to hear from the victim's stepmom last night and hear that there were pill bottles inside a backpack that the police did not even bother to take. What are you hearing on the scene at this point?
Look, I can tell you that this was unexpected, not just for us, but also for the family members. Think about this. I've been knocking on doors, including the medical examiner's office, asking them, look, are you guys going to expedite this toxicology report? And basically, they told me point blank.
Ocean kind of made an interesting point. Mel, an important point here is Ethan was not psychotic. It was a premeditated attack in a huge journal. That's why at 15 he was tried as an adult and found guilty. Jennifer was a disengaged mom.
No, this case is no different than anyone else that comes across our desk, but something must have happened. Something must have changed. Maybe it was that meeting with the Platte County prosecutor, because now all of a sudden we are seeing an expedition of this case. All of a sudden, preliminary toxicology reports are coming into the families, and they now know at least a portion of the story, which is inside of the bloodstream of those 3 men was fentanyl, cocaine, and THC. We don't know the actual specifics, the levels that might have been in that bloodstream. Certainly it was enough to go beyond, well beyond the lethal dosage. But again, the actual toxicology reports are not in the hands of the families at this point. It's in the hands of the detectives, and they have not turned that over yet. But at least the Kansas City Police Department decided that we need to give these folks some answers at least, so that way they can get some closure. Right now, preliminary results, obviously we're asking for that toxicology report so we can get those details and we can report the official cause of death. But that still could take several more weeks.
Yeah, and you would think that the families, I mean, it's one thing to get a phone call from the detective, right, to tell you here's what we can, finally reveal. It's another thing to get your hand on the autopsies, and you and your lawyer can go over them and decide what the next step is, like maybe wrongful death lawsuits, like that's something entirely possible. I'm curious, Alex, I'm not going to suggest for a minute that you have been able to dig into the digital files of all of these people, the party guests, Jordan Willis, etc. That's likely something that is tightly held by the police.
Virgo, thank you for the 5. Virgo 22. Virgo says America would feel better about Jennifer and her husband were found guilty if this would take precedent only for parents of mass shooters, in my opinion. Yeah, I mean, I guess this could affect future cases. They could reference back to that's what they do a lot of times in the trial. They'll be like, all right, make your case, and they pull up other rulings and stuff like that in cases. What's the difference between a membership and a regular subscription? There's a bunch of benefits. Like, it comes with the emojis. It comes with the members only videos. There's member only videos. There's member only live streams. It's like a more private live stream type of stuff. There's no slow chat for the members. So you can, like, when we do slow chat, sometimes there's like a lot of people have to put slow chat. You guys bypass the slow chat. I don't know what else. And it's kind of cool too, the ranking and the month stuff. You can keep track of like how many months, and you also get a free chat every month, like a members chat. You see how, on the screen, like it pops up like a super chat. Members get a free chat thing that pops up on the screen every month too. So it kind of, it comes with it. Decapitated DJ. Cheeks. Decapitated DJ in Memphis. I think somebody told me about that. I didn't look into it. Let me see. Decapitated. Memphis. Popular Memphis DJ Slick Rick found decapitated. Oh, he was found by his brother. Oh, wow. I can't even imagine, finding your own family member like that. Almost like True Business, where the mother finds her son's head in a bucket, his son's head and phallus in a bucket. Wow. The front door was locked, but the back door was wide open. The iron door was open also. I walked in and I found him and I called 911. It was terrible. At first I thought his coat was up over his head because it was like he was cold or something. So I ran out and ran back in and realized it wasn't that. It was something worse. His head had been decapitated. And there were other weird aspects to the crime scene. What weird aspects? A lot of things were weird. He added, he had his keys still in his hand. His pants were pulled down to his feet. And the back door were open wide. So that's the weird stuff. The DJ's dog was also out in the yard, which is unusual. He last spoke to his brother about a week ago, had no idea what could have happened. We just are securing the property, making funeral arrangements, taking care of my mom. His family also plans to adopt his brother's dog. Wow, what in the heck? That's a weird one. I think they took a lunch break because of the timing. Ono says, I don't think that comment about Mel doing YouTube was personal about him. I think the person was insinuating how probably so. I think that person was insinuating how everyone would be scrutinized on trial for how they spend their day. Yeah, I agree. I agree with that. Heather K, thank you for the 13 months. We love your Mel, hands down, the best YouTube channel out there. Also, don't forget to like and subscribe, y'all. Yeah, no, for sure. I mean, that's their job. That's what they're gonna do. They're gonna try to pull and yank at you everywhere, I guess. You know. I guess I gotta change this, right? I'm pretty sure they took a lunch break. So let me change this to like court on lunch break. I really hope that they wrap this up today, which they should be able to, because now it's just closing when they get back. I don't know how much time. I'm wondering too how much time they're going to give them for closing. But they should definitely be doing the verdict today, and hopefully they come back with a verdict. I mean, the jury makeup is so interesting. I don't know. Oh, Heather, thank you for that. I can't believe it's been 13 months already. Thank you for the 13 months. Grumpy, thank you for the 11 months. Lickety lick, let's get this verdict quick. I like that. Thank you. Amy, thank you for the 10 months. Well, it's already been 10 months. Thanks for creating this fun community. Thank you. Appreciate that. Really? I've noticed that happens sometimes on my second account, crimes have consequences. So that YouTube has been weird. Some channels, nobody sees my comments, and maybe one, and then nothing. I don't know if we've ever had a case like this, though, where the parents literally bought their kid the gun. I'm not saying that they knew this kid was going to go shoot the school, but he had all these signs of mental health and all these issues. So where the parents literally buy the gun and the bullets, and then he uses that gun and bullets to go shoot a school. I mean, maybe there has been other cases. I don't know. Wow, several dead after small plane crash at the Florida mobile home park.
Several people are reported dead after a small plane crashed into a mobile home park. Xavier Walton has been tracking the very latest for us. So, Xavier, what are investigators saying caused this aircraft now to go down?
Well, they're still trying to figure it out, Kelly, but the plane crashed directly into a Clearwater, Florida mobile home Thursday night, catching it.
I've always had that thought in my head, like imagine an airplane crashing into the home. Or something falling from the sky that came out of an airplane, like hitting me or something. I've thought of crazy shit before.
And at least 3 other homes on fire. Right now, we are still working to figure out, how many people died in this fire. But just take a look at, some of these flames. You can see just how large they are. And then you can see that smoke as well after the impact. Responding fire crews worked through the night to put the multiple fires out. Fire officials sharing that the mobile home hit by the plane was basically demolished. As you take a look at the video, I mean, just adding that there were deaths, plural, in that mobile home and the plane, but did not, specify exactly how many. Now, according to the FAA, a Beechcraft Bonanza V-35 went down after the pilot reported engine failure. Now, the plane disappeared from radar 3 miles from the runway at St. Pete Clearwater International Airport, but it's unknown if that airport was actually the plane's destination. Now, the National Transportation Safety Board is investigating this crash, and we're going to have to wait to find out more later in the morning, Kelly.
Thanks for watching, everybody. Go to joinnn.com to find News Nation on your
Okay, BL sent me some stuff. Okay, let's take a look at this. Let's see. Okay, so on day one of the jury selection of this historic Oxford school shooting case, the judge stressed over and over again that Jennifer Crumbley's case isn't about the right to own guns. Yet the topic kept coming up. So maybe that's another thing. Maybe some people feel like this could be a thing for to come for the guns, take them away or whatever. So did parental responsibility, which is perhaps the strongest theme in the unprecedented case, as a prosecutor is seeking to do what no one else has ever done: hold the mom and dad accountable for a mass shooting. That is a big deal. That is a big deal. I mean, we're watching the trial. There's ups and downs. Part of it is, entertainment. We kind of laughs and whatever. Even in the courtroom, they're laughing sometimes, and even just the whole thing of this attorney saying, killing, herself. But it's very serious too, though. In this case, 4 children were shot and killed by the son of the mother on trial, Ethan. Then 15 carried out this crime using a gun that his parents had bought him as an early Christmas present, which is that's just crazy. The fact, all the issues he had. Everything about this case is extremely sad. The judge, Cheryl Matthews, told the jury, stressing repeatedly that the case must be decided only on the evidence presented at the trial. Not emotions, not opinions, not preconceived notions about what the jurors may think about this case is about. Matthews said noting jurors may have heard a lot of things about the shooter's case, but I don't think you have heard as much about this case. As the jury selection resumes, both sides try to weed out potentially biased and problematic jurors. Okay. The husband's trial is set to go on March. So in a month, James will be on trial, taking the stand. These are the victims: Hannah St. Juliana, 14 years old, Tate Meyer, 16, Madison Baldwin, 17, and Justin Schilling, 17. One man, a gun owner who hunts, said, who was a juror, "I believe that some of the adults in our society aren't taking responsibility for their kids' actions." He remains on the panel of potential jurors. Interesting. So here's some more commentary that I don't think we've heard. We heard this rage one. "I believe that some adults in our society aren't taking responsibility for their kids' actions." Oof. One mother of a 10-year-old said, when I think about this case, I feel rage." She's still on the panel. Another man said, "It could have been avoided." While a woman said, "I highly oppose guns. It is legal. Unfortunately," both were dismissed. Okay. I was like, damn, let everybody get on. Oh, we got a Mohan update 35 minutes ago. Oh, okay. Let me see. Did you send it to me? Mo, perfect. Oh, perfect. We got a little update. Okay, so after this article, they did a presser. Damn, we could have even done a live on that. Okay, so after this article, we'll check it out then. Oh, that would have been a good live. Follow up on. Okay, we'll see. We'll see how much time we got. So another man said it could have been avoided. Oh, I just read that. That's huge. Oh, but they were both dismissed. Okay. On Wednesday, the goal for both sides will be to find out exactly how passionate the remaining folks are. Nearly 17 sitting in the jury box. Not here to decide how you should store a gun. Oh, really? So, okay. Oakland prosecutors Karen McDonald and addressed the 17 potential jurors seated so far on Wednesday and stressed to them that this case is about one thing: gross negligence. Okay. All right. That's what she has long argued. The Crumbleys engaged by ignoring a troubled son who needed help and bought him a gun instead. She didn't mention that to the jury pool, however. a dangerous precedent for parents everywhere. The topic of guns, however, dominated the jury selection process as the judge sought to find out how passionate jurors were about the subject, which elicited many opinions from several gun owners and non-gun owners alike. Several talked about the importance of securing a gun, which is a key issue in this case. That's as the Crumbleys are accused of not properly securing the gun that their son used in the shooting. That's gonna be a big thing. And I don't know if most, but a lot of gun owners are very adamant about safety. A dangerous precedent for parents everywhere. The Crumblies, however, maintain that the gun at issue was properly secured. Jennifer Crumbley's lawyer, Shannon Smith, who likely addressed the jury pool on Wednesday, has long argued that the parents had no way of knowing their son would commit a school shooting and that the prosecutor is overreaching in this case. She maintains this case, if it ends in a conviction, will set a dangerous precedent for parents everywhere whose kids get in trouble. I don't know if it's going to set a dangerous precedent for just kids getting in trouble. I mean, I think this thing of a school shooting, I don't know. I mean, it might set, I think, a dangerous precedent for parents that their kids end up shooting a school, depending on how much, knowledge or knowledge they did or didn't have. I don't think regular, parents are just whatever having a kid do something. I don't know. Maybe it could open the door. Would parents in this chat buy their kids or teens a gun? It already has. I always tell this story about a friend of mine. I've said this story many times, so the people that are watching, and then maybe watch the press conference after. Did you see anything on the press conference concerning the crazy guy? I haven't watched it yet. We're gonna watch it together, I guess. Yeah, the story I had I'm still friends with him. I haven't seen him in a long time, but he had like this really large gun cabinet of guns, full of guns, all types of shotguns, I think assault rifle, maybe all kinds of handguns, blah, blah. Anyway, one time I went over and he was telling me he has a Desert Eagle, and I was like, oh, I want to check it out, man. And so I was just he was holding it, but I was looking at it, and he's like, oh, you want to hold it? I said, okay, sure. I held it. And he's like, oh, shoot it. I'm like, nah, I'm good. I just wanted to hold it. I just wanted to feel the weight, how it feels in my hand. Like, oh, shoot it, man. No, come on, just shoot it. It's nothing in there. I checked. Nah, I'm good. Because just the common sense of me, and I just know that that's probably not a good idea. So I gave him back the gun, and then he checked, and he was like, oh, shit, there was a bullet in there. I was like, shook my head, man. Shook my head. All right, let's check out this press conference, I guess, since we got time. This is for the beheading. The guy that beheaded his father. This just came out about 40 minutes ago.
Sorry. Bear with us for a moment.
Oh, the other article? Okay.
Yep. Testing.
Turn it off.
Yep. Can you hear me? Good. All right. Bear with me for a second. All right. The individual standing behind me, to my left, is Chief Deputy District Attorney Matthew Linetti. To my right is Deputy District Attorney Ashley Toohey. They're the prosecution team assigned and detectives, and Jorman from the Middletown Township Police Department, and Pete Feeney, individuals, for the work they've done thus far. Tuesday, January 30th of 2024, at 6:59 p.m., the Middletown Township Police Department was dispatched to a death investigation at 145 Upper Orchard Drive in Levittown, Middletown Township. While en route, they received updated information that an elderly male had been found in the bathroom with a large amount of blood
and that his head had been decapitated. The head of this deceased individual was located in an adjacent room, wrapped in saran wrap and in a cooking pot.
Wow.
Denise Moan had arrived home and found her decapitated husband and ran to a neighbor's house where she asked that they call the police. Middletown Township Police arrived at 7:06 p.m. The victim has been identified as Michael Francis Moan, who was 68 years of age. He resided at that residence with his wife and his adult son. He was a federal employee with the Army Corps of Engineers. The victim's white Toyota Corolla and his adult son, Justin Daniel Moan, were missing from the residence. Justin Daniel is 32 years of age. Police started a homicide investigation and the vehicle was entered into NCIC. Police were advised of a YouTube video depicting Justin Moan holding the severed head of his father, Michael Moan. Multiple calls were received by 911. Details of the video are as follows. The video is a 14-minute and 34-second video of Justin Moan, where it is titled Moan's Militia. It's a call to arms for American patriots. The video appears to be taken in the same bedroom of the home where bloody gloves were found. In the video, Justin Moan is holding a human head detached from the body that was wrapped in plastic. Justin Moan advised that the head is Mike Moan's head. During the video, Justin Moan advised that Mike Moan is in hell for being a traitor to his country. During the video, Justin Moan provides his identity and advises that he is the commander of America's National Network of Militia, also known as Moan's Militia. During the video, Justin Moan advises that he is giving the following order for all militia and patriots across the USA to kill federal employees. He also ordered that individuals from the FBI, IRS, and other federal law enforcement officers, and for those that work at the courthouse to be arrested, that all federal agents, U.S. Marshals, federal judges, and Border Patrol be captured and tortured for information, and then publicly executed. Justin divulges the home address of a federal judge and puts a bounty on his head and heads of high-ranking federal officials. He demands violence against all federal employees, but exempts state government, state governors, and state employees. The suspect's phone was pinged, and it was, again, an outstanding effort by law enforcement to work in such a expeditious fashion, pinging the defendant's phone and identifying his location. It was determined that the location was showing at Fort Indiantown Gap, a National Guard training center in Lebanon County, Pennsylvania. The suspect drove his vehicle to this location. He climbed a barbed wire fence. After he drove his vehicle past the barricades first, exited his vehicle, climbed a barbed wire fence, and entered the secured military installation.
What?
Fort Indiantown Gap Police Department were notified of the ping in their jurisdiction. Shortly thereafter, Fort Indiantown Gap Police Department and the Pennsylvania State Police located Justin Moan trespassing on governmental property. Justin Moan was taken into custody without incident. The defendant had a loaded Sig Sauer 9mm handgun on him, and it was loaded, as mentioned, missing one round. Justin Moan was taken into custody. The defendant stated he went to Fort Indiantown Gap in an effort to mobilize the PA National Guard to raise arms against the federal government. He also indicated that he wanted to speak to Governor Shapiro to join forces. The autopsy of Michael Moan was conducted on Thursday, February 2nd, by Dr. Ian Hood, forensic pathologist. It was determined that Michael Moan suffered a gunshot wound to his head and then was subsequently dismembered, and that the mechanism was the use of a knife to sever limbs and tendons, and then
So he shot him first and then did it.
Moan suffered a gunshot wound to his head and then was subsequently dismembered, and that the mechanism was the use of a knife to sever limbs and tendons, and then ultimately a machete to sever her spinal column. This investigation, again, I can't speak more highly of the work that was done by my colleagues and fellow members of law enforcement. They identified the fact that the defendant purchased a firearm the day before murdering his father. He purchased that firearm at Johnson's in Croydon, Bristol Township, Bucks County on January 29th. The defendant is a graduate from Neshaminy High School and Penn State main campus. He previously worked and lived in Colorado, working for a contractor for Microsoft Corp. He's currently unemployed. He has no history of diagnosed mental health issues, and there are presently no 302s or 201s in his history. I am going to turn it over to Chief Joseph Bardarillo, and then we'll be available to answer any questions you may have.
No mental health history?
So I want to start off just by saying that me and my entire police department, our hearts ache for the Moan family. I know we had a meeting with them last night at our police headquarters with victims advocacy, and I just want to let everyone know that we will be with them every step of the way through this incredible ordeal that they're going through. And also our Upper Orchard community, which is one of our small communities within our Levittown section of our town, cared about them. So the one thing I want to do is recognize all of the law enforcement agencies that played, such a huge role in discussing that if Justin hadn't been apprehended, can you imagine the manhunt that would have been underway, shortly thereafter, and how everything would have been focused on finding him and how the entire community would have been in a state of panic. At least where he was. Two of our detectives are here, our lead detectives on the case, Jake Gallagher and Kevin Platnecki, but all of our detectives were at the scene that night. And that was our first priority, getting to the scene, preserving the scene, but then locating Justin, who went quickly from a person of interest, obviously, to the suspect. And with that, police department that I'm learning more about every day, the Fort Indian Town Gap PD, who did an incredible job of rapidly responding when we called them and told them that we had a general idea of Justin's location based on cell phone tracking. They located, Fort Indian Town Gap Police Department located his car first, and then later on, based on continuous cell phone tracking, were able to locate and detain him without incident. I don't know the full circumstances as to where he was detained. I think he did climb over a fence and get into the fort. He might have been armed, but you have to ask their police department about it. I'm very grateful to the Fort Indian Town Gap PD for the outstanding work they did in getting that apprehension as quickly as they did. So given that, I do want to thank them, and also Pennsylvania State Police. And in addition to our police department, we're very blessed to work in a county where we have an outstanding relationship, and we do a lot of mutual aid and we assist each other. We're 39 small police departments, 43 law enforcement agencies, supported by what I think is the best district attorney's office in the state. So I want to thank District Attorney Shorn, Chief of County Detectives Martin McDonough, and his entire staff, and also our coroner's office as well, for their incredible support in helping us process the crime scene and being there to provide the additional resources that we needed in order to handle, what has become, a very significant event and case that's gaining, national, if not worldwide attention. So I just wanted to make sure that I thanked, everyone who supported us through this. So our detectives were on it from the start, and they're still working. We've been very busy, and we're going to continue to be busy, as we continue to work through investigating this case. It's not over just because an arrest was made. There's still a lot of information that has to be done to ensure, that we move through with a successful prosecution. So With that, I really don't have anything
Does he
else to
indicate
add.
to you-
Hang on one second.
Oh.
Second, I don't have anything else to add. So I want just defer to District Attorney Shorn first, if she wants to take questions before I do.
Thank you.
Okay.
Thank you, Chief Bartolome.
DA, does he indicate to you what sets him off to kill his father Tuesday night?
So I've shared the information that I'm able to share at this juncture. As you know, this is an ongoing investigation with the most talented members investigating this case. I can't speak to anything further beyond what I conveyed thus far about statements made.
Jen, is there any evidence he was a member of a militia?
Obviously,
Or had militia ties?
Obviously.
In his head. Yeah.
I think his online manifesto speaks for itself at this juncture. Again, this is going to be an ongoing investigation for months, and we'll continue to investigate this through the successful prosecution.
They should check it out, though. Yeah, who knows if he has like an online whatever.
With this team present.
Jen, how concerning is this to you and everyone out there that this was up online as long as, with the calls for violence that were out there, that it was up as long as it was?
That was incredibly concerning. I mean, obviously from an evidentiary value, that video is very important and we need to have possession of that. But it's quite horrifying how many views we understand it had before it was taken down. Obviously, we were able to capture and secure that video because it's pretty self-explanatory as to who's.
I forgot how many views that video had. I downloaded it on the computer because I knew it was going to be scrubbed. But I know it was up for like at least 5, maybe 6 hours. And I thought when I checked, I thought it had like 5,000 views, the original video. The only thing I could argue is when you have a channel that's that small, I don't think he even had any other videos on there. I don't think. So you have a video and somebody just randomly uploads a video going on a tirade and doesn't really have a following. It's going to take a while to catch time for people to catch. If I uploaded that on my channel, like a head, like an actual head, well, I'd like to think it would be taken down pretty quickly, but I don't know. YouTube sometimes takes a long time to act. It would probably come down faster than the other guy. It would have gotten more attention more quickly. But that's the only thing I can think of because I don't know how else an automated system would pick that up. Like a head, because it could be confused for so many things. You know, a regular person doing a video could be considered, maybe they think they're decapitated or something. I don't know. So.
Responsible, although these are allegations at this point. So that's very concerning. And I got to tell you, Jim, when to Chief Bartolome's point, the fear of what this could have been, I know that Chief McDonough and I were expressing that night. I know Chief Bartolome was living it that night, and it was thanks to this outstanding collaboration of the men and women in law enforcement. And also, I should mention, the U.S. Marshals assisted in making sure that individuals named were safe.
It would be interesting if the algorithm was pushing it, right? That would be pretty nuts.
But that was the reassurance that we all needed to know that we're safe and that this case will be prosecuted.
Do you know, was he a legal buyer of that gun that he buys the day before killing?
He was. There was nothing legally precluding him from purchasing that gun. In fact, our investigation has revealed that he surrendered his medical marijuana card so as to be eligible to legally possess a gun. That also shows you the clear state of mind that he was in, having planned what he ultimately carried out.
Has he had a mental health evaluation yet?
I'm sorry, I can't speak to that.
Did anyone have any interaction with YouTube, and what was that like in terms of a protocol to get that video down?
Are you referring to anyone present team here? 1 second, please. We believe the federal authorities conveyed that, but also ultimately after the number of views, the content obviously became, that's a flag, that's a shot over the bow that something's unusual in that short period of time. So it came down pretty quick once we knew about it, but it was, excuse me. We did take steps, obviously, to preserve it, and we had that video.
So do you know how many views it got and how long it was up for?
I'm sorry?
Do we know how many views it got and how long it was up for?
I know at some point when I was aware of it, there was over 5,000 views.
Okay.
Like 5,000. They're finally back, and it's not a lot of views. It's really not. I mean, it could be, like, it depends. It's subjective, but 5,000 really isn't a lot. I mean, it was graphic, so I don't know who knows who the 5,000 word, but like, I mean, it's kind of a drop in the bucket when it comes to social media. The problem is that video had been reproduced and like on Twitter, and I don't know if it was posted on YouTube. I did post the part without the head. That still got taken down. So I don't know. The reproduction of it could have been more views, you know. Finally back. Wow. An hour later. I'm gonna use the restroom. I'll be right back.
Your Honor, calling People versus Jennifer Crumbley, case number 22-279-990-FH.
Karen McDonald on behalf of the people.
Thank you, Marquise. We got the people.
Thank you. I'm Shannon Smith on behalf of Jennifer Crumbley.
All right. We previously drafted jury instructions, and there was briefing and comment on the jury instructions. And I think it was about 2 weeks ago that I emailed a set of final jury instructions that I believe both sides agreed to.
Yes.
But I just want to briefly go over the instructions that we're giving, find out if there's any fill-ins, and then we'll have a final set of jury instructions. I'll provide these to the jury. Okay. So we're going to give 3.1, 3.2. We're taking out 3.3.
Yes, sir.
All right. 3.5. 3.6, 3.7, 3.10, 4.1, 4.3, 4.4, 4.5. We don't need any fill-ins there, that's general.
Yes,
right?
sir.
Okay. 4.5, 4.7.
We have not read the stipulations to the jury. I don't know if we plan to. On the keeper of record stuff, do we need to?
The things that were the subject of stipulations have been admitted.
They've already been admitted, so I don't believe it's necessary, Judge.
Yeah.
I didn't know if the court wanted them on the record or...
It doesn't matter to me. Normally, it's advantageous for stipulations to be read into the record, for example, in civil cases with large amounts of exhibits, but if the exhibits that were the subject of the stipulation are admitted anyway, it's probably not necessary.
These are just keeper of records, chain of custody. I don't think we need to.
If there's anything that was not admitted as an exhibit, there's no stipulation that doesn't involve an unadmitted exhibit, right?
Correct. Let me
Actually,
confirm.
I'm not sure about that.
Okay, so anyway, 4.7, 5.2, 5.3. What about 5.8A?
I don't think that was...
No.
That was used
Out?
at all.
Out, right?
Out.
Yeah.
Thank you, Judge.
Okay, 5.8A is out.
5.10 needs to be amended.
Oh, okay.
Detective Wegrowski was an expert, but I don't believe there were any other experts admitted, were there?
No, the two medical examiners did not testify.
Sean and Brian, Pacris and Brian.
Yes, sir.
We stipulated to their autopsy reports.
So it's just Wegrowski, correct?
Yes, Judge.
All right. 5.11, 16.10. There's several of those. As to count 1, 16.10 as to count 2. That's involuntary manslaughter. Instruction 16.10 as to count 3. 16.10 as to count 4. There's a unanimity instruction that is based on and adapted from 20.30A non-standard civil jury instructions, and the parties agree to that instruction.
Yes, sir.
Correct?
Yes, sir.
Yes.
Okay. 16.13 involuntary manslaughter, failure to perform legal duty as to count 1. 16.13 as to count 2. 16.13 is to count 3.
I'm gonna walk the doggies. I'll be back. I'll be listening on my phone.
13 is to count 4. 16.15 as to count 16.15.
Just one instruction for 1615.
Say it again?
Just one instruction for
Yeah.
1615.
I was trying to see. I think there were some things added. There was a foreseeability excerpt.
Yes,
that was
Judge.
agreed upon.
Yes, Judge.
Yes.
Okay. Yep, yeah. That's non-standard, but agreed to by both sides. 16.18 gross negligence. There's an instruction about not using the shooter's name. Maybe I should get rid of that one. 3.11 deliberations and verdict.
Yes.
3.13, which is possible penalty. 3.14 communication with the court. 3.15 exhibits. 3.16 written or electronically recorded instructions in the jury room. 3.20 single defendant multiple counts, more than one wrongful act. 3.23 with regard to the verdict form, and then there's the verdict form that's standard, right?
Yes, Judge.
We have obtained a computer that would accommodate the thumb drives that's going to be in the jury room. Anything else you can think of?
I don't think so.
Your Honor, I don't have a thumb drive with mine. I just have mine. I just have a hard copy.
Oh, that's good. We'll send it all in. Okay.
Thanks.
Thank you. Anything else? We're going to make those minor amendments. Anything else at this time?
No, Judge.
I don't think so, Judge.
Okay, so we'll be back in about. Well, we're going to take her back down, aren't they? Okay. I'm going to take her back down, and I'm going to ask him to bring her right back up, right? It won't take long to do. Okay, yeah, the jury instructions are ready. I think I'm going to give you each copy of the jury instructions just to be sure that we've done it accurately, all right? And these will be the instructions that go in with the jury as well.
Thank you, Judge.
Okay. At the moment, after closings, I'm going to eventually instruct them. I am going to have all 17 come back Monday, right? Does that make sense to you?
I think we'll get through closings and they could start deliberating.
I'm concerned about that. Are you not concerned about that?
No, Judge.
You want to approach? Well, if you can. All right, do you want me to bring the jury in now?
Sure. Yes, please.
One moment, we're just having some
Just take 1 second to set things up, Judge.
Ms. Williams was going to print a copy of the jury instructions for you, just to be sure. Okay?
What's that?
We're going to print a set of the jury
Oh, sure.
instructions, and I can review those just to be sure that they're accurate before I send them in. 5.88 comes out. 3.2 comes out. Yeah. And then the expert witness is only one off the teaching out. Okay.
One moment, right?
All rise for the jury.
Ladies and gentlemen, you may be seated. Ms. Smith, am I correct that you rest?
Yes, thank you.
Prosecutor, any rebuttal?
No rebuttal.
Ladies and gentlemen, the evidence in this matter has been concluded, and now you're going to hear closings. I want to remind you that closing arguments are just that. They are, each side sees the evidence in the case. The closings themselves are not evidence. Because the prosecutor has a burden of proof, the prosecutor also has a right to rebuttal after the defendant's closing. All right? I think you're going to hear certain elements, again, of the crime charged, the crimes charged, and I'm going to be giving you written jury instructions that list those, just so you know. All right? Prosecutor, just 1 minute.
Yeah, it always seems like a good idea, but
This will forward pretty far.
Can you help me there?
Where would you like it?
Just that way.
You want it still facing this way?
I want it like almost in front of the witness box. Sorry about that. Okay.
Thank you. Good afternoon. We told you in jury selection it was going to be 3 weeks, and it's now been 2 weeks, so we're a little bit ahead of schedule. This is our time for our closing argument, and I'm going to spend some time going through the evidence, and I'm going to spend some time going through the elements of the crime. I want you to know that I have been watching you diligently, taking notes and listening. So what I'm not going to do is spend a lot of time repeating everything that was said from the witness stand, because I know that you all listened, and I also want you to know that I really appreciate that, and I know the court does too. I told you during jury selection that it wasn't going to be easy, and it was not easy. Listening and watching and thinking about 4 young kids being gunned down in their school is not easy. You listen to every witness, you examine the evidence, and I suspect that many of you feel the way that we do, that it's difficult. But we owe it to the victims and their families to say what really happened. And you've listened and you've done that. In our system of justice, we have different roles to play, and each role is different. There are people who think it's the prosecutor's job to convict people. I don't think that's the prosecutor's job. I think my job and our job is to present the evidence and the facts and tell you the truth. And telling the truth sometimes means showing you things none of us want to see, some of us don't agree with, some of us don't like. But I believe that that's my job. We don't pick or choose the very best things, because I believe that you should have the truth. And I believe that it's not my job, nor is it right, to sanitize what happened in that school that day. Because if we don't tell you exactly what happened, then you don't know all the facts, and you don't know what the truth is. My job here, our job, that I believe we have done, is to meet our burden to prove that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter. The burden is high. I told you that during jury selection, but we embrace it. And I believe that we have met that burden. It means that you had to sit and listen to a lot of very emotional things, a lot of emotional people who sometimes aren't emotional, but were emotional for this. Because what happened on that day, every single person in that building had never experienced anything like that in their entire lives. And I hope to God they never do again. So you did see a lot of people, including law enforcement, become overwhelmed with the emotion of it all. That's not a show. That's just how that was. That's how it felt that day and every day after. So I want you to know that there was no picking and choosing the very best evidence to give you. There was no filtering things out that didn't help our case. I showed you everything. And I called witnesses to the stand to say things I knew you probably wouldn't like. But my job is to give you all the facts. But my job is also to prove beyond a reasonable doubt that Jennifer Crumbley is guilty, and I believe we've done that. The defense also has an important job, to advocate and argue for their client, and they decide how they want to do that. And of course, the judge plays an important role. Her job is to call balls and strikes when 2 sides disagree to make a ruling, and then to tell you what the law is. And she's going to do that as soon as we conclude here. And then there's your job. Your job is to decide what the truth is, what really happened, what are the facts, and then take those facts and find the truth and apply the law. The judge is going to give you instructions about the law, but I want you to go over what you now know, and I want you to think about it. And we're going to go over some of the evidence. But I also want to remind you that you're allowed to use your own observations and your own insight. And if there's something that you notice from the witness stand that I didn't say, you should rely on that. We can't possibly tell you every single little thing. And sometimes, ladies and gentlemen, the most important things are the things that don't get said. The most important things are the way the victim or the witness spoke, the way they answered a question. And I encourage you to rely on your own perceptions of that. I want to start out by talking to you about the elements of the crime. Involuntary manslaughter. She is charged with. This case is based on 2 theories. You're going to have all this in their jury room, but hopefully I'm going to explain it so well you will have no questions. These are dependent on 2 specific theories. One is the gross negligence in the performance of a lawful act, and that gross negligence caused death, and in doing so, the act that caused death, defendant acted in a grossly negligent manner. The second is the gross negligence in failing to perform a legal duty. One, I have to prove that she had a legal duty to the victims. 2, she knew of the facts that gave rise to the duty. 3, she willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And then 4, the death of the victims was directly caused by defendant's failure to perform this duty. Causation. The judge is going to instruct you, maybe more than once, and I'm going to say it, that there may be more than one cause of death. And it's not enough that the defendant's acts made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's actions. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Muir, Hannah, and Justin. And as previously noted, there may be more than one cause of death. And defendant's acts or inactions need not be the sole cause of the harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting these 4 individuals was reasonably foreseeable. Now you look at that, all of that I have to prove. And it seems a lot. It seems like it's going to take a pretty strong case to prove that. It's going to take some pretty egregious facts. Some unique, egregious, incomprehensible facts. And that's what we have here. Gross negligence means more than just careless. It means willful disregard of the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you have to find the following 3 things. 1, that she knew of the danger to another. She knew there was a situation that required her to take ordinary care to avoid injuring others. And second, that she could have avoided injuring another by using ordinary care. Third, that she failed to use ordinary care to prevent injury, and to a reasonable person, it would have been apparent that the result was likely to be serious injury. I told you I have 2 theories. We're prosecuting and charging based on 2 theories. They're both based on a legal duty. What's a legal duty? In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, to prevent that child from intentionally harming others, or prevent that child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. We talked about there's 2 alternate theories. Both of those theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven, and as long as you all agree that we've proved at least one of those theories beyond a reasonable doubt, you can find her guilty. I want to take you through the testimony. I'm not going to get into every single detail of each of these witnesses' testimony because I know that you were listening and you were writing. You heard from Molly Darnell. Molly was a teacher in the school that day. She was in room 224. And she saw the firearm when it was raised, shoulder height, pointed directly at her. And what she noticed was there was no orange tip. You also heard her say that she locked eyes with Jennifer Crumbley's son as he was taking that stance. You heard her testify that she jumped to the right, thank God, just in time, because the shot in her shoulder that she sustained was only inches from her heart. The next witness you heard from was Christy Gibson Marshall, who's an assistant principal at Oxford High School. I don't think there's one of us that would disagree that Christy Gibson Marshall did the most dangerous thing she could do. And she did not follow the protocol. It's probably one of the most courageous things I've ever seen. She walked to the shooter. She saw a student on the floor. And then, when she finally came face to face with the person who had shot this student, she didn't move. She just stared at him. And he didn't shoot her. She testified that she knew him. She was his principal in middle school. And she just couldn't believe that he would do something like that because she knew him when he was in middle school. You saw the video of that day and what happened. And he just kept going. And even after he left and she had no idea where he was going, she didn't go hide anywhere. She didn't keep herself safe. She bent down to render aid and assistance to that student. And when she rolled him over, she realized it was Tate. We all know that she didn't and wasn't able to save Tate. We heard from Cammie Batt, who sold the Caltech and the Derringer to James in June of 2021. She also sold the 9mm Sig Sauer to James with the shooter present on November 26th, the day after Thanksgiving. She testified that James came in and pointed right at the Sig and said he's had his eye on it. She walked us through the process of purchasing a firearm. She talked about the trigger lock statement provided to James upon purchase and the cable lock provided with November 2021 on that gun purchase. Next, we heard from Special Agent Brett Brandon, who's sitting right here. You heard that when he was informed about the Oxford shooting, he left so quickly that when his partner came back, his chair was still spinning. And he raced and drove up there as fast as he possibly could because it was very much his own community. You heard he went right in and he found Lieutenant Willis and he said, "Do you know where the gun is and do you know where it came from and do you need help?" And so he was responsible for finding out where that gun came from, which he did. He was also responsible, because he chose to be, and watched the surveillance of the video and helped to prepare search warrants. And you heard him testify that as soon as he saw that surveillance video, the one thing that stuck with him is this is not an inexperienced shooter. This is a shooter that that is proficient with a firearm, knows what he's doing. Taking shots, a lot of people wouldn't. And what he did was start going to gun ranges and ask people to say, because what he was thinking was, who taught that kid to shoot? He must have been to a range, and he was right. And that's how the investigation led to where Jennifer Crumbley's son learn how to handle a firearm that eventually resulted in killing 4 students in Oxford High School. Can you go back to that? Special Agent Brandon also testified that and showed the purchase, and we showed you each one of those guns. He testified that there is a distinction between a Derringer, a Caltech, and then the 9mm. And what we really heard from him was that 9mm is a much more dangerous gun. It causes more damage to whatever it hits. The bullets are a larger caliber, and it's a very dangerous weapon. He showed you what comes with every gun purchase, which is the ATF pamphlet. He read to you about the warnings. There's a reason they put it in every single gun purchase. And its sole purpose is to protect kids from gun violence deaths. He talked to you about what a trigger lock is and the trigger lock statement. He showed you the Instagram post that's unforgettable. We don't have to really argue about whose gun that was. Jennifer Crumbley told us whose gun that was. She told us when she posted it on social media, it was his Christmas present, and she told you in this trial. That weapon is not just that weapon. It is the defendant's son's gun. It was gifted to him. And not only was it gifted to him, she bragged about it on social media before the shooting. Special Agent Brandon also introduced all of the surveillance and the videos of the shooting range. And you got to see with your very own eyes the training and the preparation that the shooter ultimately used to kill 4 of his classmates. We all saw that. We actually saw the last day he was practicing to kill 4 of his classmates. And there was only one person with him, ladies and gentlemen, and her name is Jennifer Crumbley. And I want you to remember that video. And I want you to remember the look on his face when that target comes back in and he looks at it and he's smiling. Special Agent Brandon also introduced the worksheet. You've seen the worksheet a lot. I bet you that worksheet's burned in your memory, and I wouldn't even have to show it to you. But what Special Agent Brandon testified to and showed you is that wasn't just a picture of any gun. It was a picture of his gun, which was the murder weapon. And he showed you the details, and we're going to talk about that later. And next we heard from Ed Wygrowski. We now just call him Ed because he works for the Secret Service. And he testified for an entire day, and he had a lot of information. But he also really couldn't help himself from becoming emotional. And I know that you're going to remember this, but what an extraordinary thing. That's just not seen very often. He sat right there, and he took you through every single action of the shooter and every single death from his memory. And he told you that he could do that because it's burned in his brain. These are seasoned law enforcement. This isn't an act. They hate showing emotion. He probably will never forgive me. Lieutenant Willis tells me all the time how much he really hates me for that.
I would object.
It's my opening. It's my closing.
To what a witness tells her all the time. That's not evidence.
Okay. I'll move on. Okay. Nobody likes doing that. Nobody likes doing that. But it tells you something about what it was like that day. And despite what anybody will tell you, it is about the shooting. There are 4 counts of involuntary manslaughter. It's very much about the shooting. because the shooter learned how to shoot and was given the murder weapon by his parents. And this parent is sitting here today on trial. Okay. You'll be able to review the evidence. It was a lot. But he talked to you about what cell phone extractions are. And because of the cell phone extractions, we have a mountain of evidence that you saw. And yes, it's a lot of data. But you know what else it is? It's telling you exactly where the defendant was, who she was talking to, what she did, what she didn't do. And you can't hide from that. She tried. There's a lot of deleted messages, which are not coincidental. I don't think any of you believe that, but I'm going to tell you why they're not coincidental. He also talked to us about and showed you the messages between Jennifer Crumbley and her son. The messages between her son and his only friend. He introduced the voicemail that Jennifer Crumbley received the night before the shooting about looking up bullets. True. Pam Fine didn't tell her to call back. That's true. And she didn't call back because she didn't ask for a call back. We all know what she did do with that information. What she did do with that information is she texted her son, searching bullets. And we all know the phrases that we'll never forget. Did you show him your gun? This is the day before the shooting. Did you show him your gun? And the shooter responds, no, my God. LOL, I'm not mad. You just have to learn not to get caught. Kira Pennant testified that she knew Jennifer Crumbley. She testified about the amount of time that Jennifer Crumbley and James Crumbley spent at the barn. She testified about all the money they spent at the barn. Why is this important, ladies and gentlemen? It's not to show you that somebody's a bad person for liking horses or spending a lot of money on horses. It isn't. And it's not to say that somebody should spend every waking hour that they're not at work at home with their teenager. That's not the purpose of this evidence. The purpose of this evidence is to show you what Jennifer Crumbley cared about the most and what she was doing and where she was when her son learned to be a killer. Kira will tell you that she referred to her son as an oopsie baby and said he was weird. She rarely saw him. And that even after the one friend was taken away abruptly with no notice, they still went to the barn, even at night, and left him by himself. Which is absolutely normal to leave teenagers at home by themselves. Unless that teenager is showing signs of mental crisis and that teenager has lost the only person in the world that he has. And then she told us that when she got the worksheet texted to her that day by Jennifer Crumbley, she was very concerned. She was alarmed. And in fact, she said, bring him to the barn. And you also saw from the text messages that Jennifer Crumbley said, he can't be alone. We know now that decision, that statement, she knew he couldn't be alone. She didn't decide to stay home with her son. That wasn't an option. She'd have to take him to the barn, where she herself testified he didn't want to go. You heard from two people who were at that meeting that day, Sean Hawkins and Nick Ejab. I'm going to tell you right now that this is not an argument, but this is about Jennifer Crumbley's actions. And any attempt to make it about what these two individuals did or didn't do, like it or not, who did not have any of the information that was so jarring, it's about what she knew and what she didn't say. Sean Hopkins testified that he was concerned enough that he called Jennifer Crumbley. And her first response is, can you call his dad? Eventually, he emails her both copies of the worksheet, the original worksheet and the worksheet that was scribbled on. And she eventually comes to the school. But before she comes to the school, she texts her husband, emergency. Emergency. Along with, I'm very concerned. And James texts back, WTF. They're concerned. For the first time she testified ever, they're called to the school in the middle of the day, and they have that worksheet. Sean Hopkins is going to tell you that calling parents in the middle of the day and asking them to get a kid help is a pretty drastic action. And that he did in fact do that, and he gave them the list of places to call. He testified that when they entered the room, Jennifer Crumbley didn't greet her son. Jennifer Crumbley didn't hug her son. Jennifer Crumbley didn't engage with her son at all in the entire 11 minutes she was there. And we know she wasn't going to be in that school very long because she'd already told her boss she'll be back by 12 or 12:30. Doesn't leave a lot of time for the meeting at the school. It's a 20-minute drive. Sean Hopkins will tell you that what he felt mostly in that room for the shooter was compassion. He didn't want him to be alone, and he felt really bad. And he also knew mom and dad decided, no, we can't take it. We have to go to work. They said that in front of their kid. He knows very well what they do. He knows his dad works for DoorDash. He knows his mom and her ability to work flexible hours. She worked at home. But they left. She did not hug him goodbye. She did not greet, touch, or even acknowledge him. And we know now from her testimony, we know why. She was mad. She was mad at him. She did not think that he should have done that, and she thought this was a discipline thing, and she was very angry. We heard from Nick Ejek. He's the dean of students. He also testified and corroborated what Sean Hopkins told you, which is that the meeting was called. They were concerned about a mental health issue. They told mom and dad he needs services. Here's a list of the services, and they defended Jennifer Crumbley seemed irritated by it. In fact, when she walks into the room, she doesn't sit next to her son. She goes back here and stands. And that meeting ended with her saying, "Are we done here?" They're consistent about that. Nick Ejek testified he didn't think there was any risk. I don't like what he said, and I knew he was going to say it. But it's not my job to put witnesses up here and only say things that I want them to say that helps my case. It's my job to present evidence that's the truth, because you have to know the truth. Sergeant Joseph Bryan is the first law enforcement that had contact with Jennifer Crumbley and her husband right after the shooting. And you saw the interview in the substation. And you saw the demeanor of the defendant. I want you to remember something. It wasn't even an hour. It was around an hour after the shooting took place. She's on her cell phone. She's looking to see if it's on the news, she said. We also know that there were deleted messages. We don't know when she deleted them, but we know there were messages deleted after the time of the shooting, from the time that the phones were seized later that night. He asked about the gun. and you heard what she said, what they both said. It was hidden. It was hidden. She read the text message. Oh, he said he loved me. And she reads the text message. And then she said, I texted him, I love you back. It was 49 minutes later that she texted, I love you back. And it was after she already knew that he was the shooter. She doesn't say what the text after that is. She leaves that out. The text after that is, Ethan, don't do it. She doesn't say, well, we were at the school, but he was also caught searching bullets that night, the night before. She doesn't say that, and I told him, don't worry about it, just don't get caught. She doesn't say that they had just purchased the weapon and it's not secure. What do they say? The very first time they are asked about what Jennifer Crumbley's asked, where was this gun? The very first time, what does she say? It was hidden. She does not say there was any locking mechanism at all, and neither does James. It was hidden. You're at the police station. Your son's in the next room. You know the murder weapon was the weapon you just purchased for him, and when you're asked where it was, you say it was hidden. We also heard from Andy Smith, who was Jennifer's boss. He testified she could have absolutely gone home. She works from home, and there's flexibility, that they have kids that come to work, that the meeting that she wanted to get to was not in any way mandatory, and he testified about some very bizarre communications. He testified that as soon as she left, he got a text saying, my son, the bullets are gone, the gun is gone, he must be the shooter. Oh my God. Those were deleted by Jennifer Crumbley. We don't know why. I think there's a lot of circumstantial evidence to suggest why, which is those are statements you don't want on your phone. And then, not 3 hours after her son shot and killed 4 people, and he's already in custody, and it's already clear that he is probably never, ever, ever going to be out of prison for the rest of his life. She's texting, don't judge me based on what he did. I need my job. Her explanation for that, she was in planning mode. The next witness is Amanda Holland, who testified that she came back to the work that day. She had the worksheet. Andy Smith also said she before the shooting occurred, she was down, she was sad. I feel like a failure as a parent. I feel like a failure as a parent. This is before the shooting. And she also tells Amanda about this, and she tells Amanda he can't be alone. So I'm just going to take him to the barn tonight. We can get to it a little bit later. I guess what's really hard to comprehend is how, before the shooting, just based on the meeting and what she knows and the drawing, she thinks she's a failure of a parent. But she sat right here and said, after all, she doesn't really think she was a failure as a parent. And that's after she knows everything that happened. Detective Adam Stoyak executed the search warrant at the defendant's home. I want to make it really clear. Jennifer Crumbley is not being charged with involuntary manslaughter because she has a dirty house. That's absurd. And you can see pictures so we can prove that she didn't have her house cleaned. I don't care if her house is clean or not, and I don't think you do either. Those pictures are shown to you because that is where the shooter lived and it's where she lived. And you saw his 2 bedrooms. There was barely a place for him to sleep. The testimony shows he had no person in his life after that friend left. He was not in a club. He was not in sports. He wasn't working. When I see those photos, what I think is, 2 rooms that were completely filthy, dusty, covered with clothes everywhere. But then I think, what? That is where he spent 99% of his time. It's where he ate Thanksgiving dinner, just days before the shooting. The search warrant photos were also shown to you so you could understand where these guns were stored. We have a pretty good idea that the Kel-Tec and the Derringer were in what's called the gun safe. The lock was 000, but we know that they were kept there. What do we know about the SIG, the Jennifer Crumbley's son's gun? We know that there was a box on the bed and the ammunition next to it. This is the box. This is the box. I'm sorry, this is the thing. He's going to show you in a minute. This is the box of the Kel-Tec, which was found with this cable lock inside of it. Where she kept the other guns? No.
I'm sorry, is that the box or the cave? Is that the box or the safe?
This is the box.
That's the box.
It was in the kitchen, in a cupboard, down in the cupboard.
But the empty box was in the kitchen, right?
I don't. What exhibit
Your
number
Honor,
is that?
this is my closing argument, and I would just like to finish, please.
Sure. Can you tell us what exhibit number it is?
Yes, it is 35.
Go ahead.
This was found in the kitchen. Inside is the cable lock. This was found on the end of the defendant's bed. Special Agent Brandon showed you what it's like to open this up and close it. You hear that clap? It's not an easy thing. So what this was laid out on the defendant's bed, and the bullets are right next, the box of the ammunition is right next to it, empty. The story, one of the stories that is told by Jennifer Crumbley is he must have come in there when they were sleeping, because she was in that bed all night long, and they left after her. Except that the ammunition was in the box. Taking it out and leaving the box while your parents are sleeping doesn't make a lot of sense. And it doesn't make a lot of sense that this was taken, the weapon was taken out of this case with no one hearing while they were sleeping. And you are allowed to use your own common sense. He also testified about the search warrant. He testified where this cable lock was found, and he testified where the case and the box was found. And he testified where the gun safe was found. It was not, unlike what Jennifer Crumbley alleged, stored separately from the ammunition. It was actually right next to the ammunition. In a gun safe, the other two guns with a combination 000. Sergeant Peschke arrives at the scene, doesn't know anything about the Crumbleys, doesn't know that they've already been to the substation, doesn't know that they were at the school that day. He's there and was ordered to be there to keep the house safe while they are waiting for the search warrant. And in doing so, he needs to keep the defendant out of the house. She goes in the back of the car, and you saw the video. She now tells Sergeant Peschke she actually never really looked closely at that worksheet. Now that she looks at it, it might be disturbing. We know that's not the truth. The question is, why is she lying? She says that the .45 caliber gun used at the school, and he asks if it was, and tells him no, it was a 9mm. The other is a .22, I think. She said that they had a fight the night before with her son over grades. And she says, so we told him, no gun range, no phone. Those are his trigger points. Ladies and gentlemen, that phone was never taken away from her son. We know that. We know that because he had it the night before, and he had it at the school. We know that because when Jennifer Crumbley was asked about it, and asked, when did you take this phone away? We know that he made that video in that shed about the school shooting with his phone at 10 o'clock. The phone was never taken away. Why is she saying that? I don't know. Then she says, my biggest fear was that he turned the gun on himself. And when he asked her, do you ever keep guns in your car? Here's what she did. Shook her head. It's not what she says here today. Next, we heard from Bob Patelis, who processed the scene. And you saw those pictures, and they were hard to see. He told you that there were 32 fired cartridge casings. He collected all that evidence, took all the photographs, and recovered the murder weapon. Lieutenant Marsban was also at the school that day, and he testified that he picked up the phone and saw the screen and saw that the last text was, Ethan, don't do it, from Mom. He executes search warrants for all of the devices and the home and sends a team, including Officer Peschke, to secure the house before the search warrant is executed, which is what they do. He testified that when he went into the house, he finally got there and he needed their phones. And he testified that Jennifer Crumbley said, no, I don't want to give you my phone. I'm not giving you my phone. She finally relents because her husband says they're going to get it either way. And then she doesn't want to give the passcode up. She doesn't want to give the phone up. But the most important thing that Lieutenant Marsman said is when he described how he had to identify the body of Hannah in Madison that day. Dave Hendrick is retired, but he's the former sergeant in charge of the fugitive apprehension team we call FAT. And his job, his only job, when he was doing that, is to find people who have felony warrants and haven't turned up. He has a lot of ways to figure that out. But he was asked to find Jennifer and James Crumbley to make sure they turn themselves in. But one of the other primary goals he has is that they turn themselves in safely. And she was given every opportunity to do that, and she did not. I want to talk to you about something. The judge is going to instruct you that you can consider flight. It's not an element to the crime. I don't have to prove that they fled. The reason we introduce this evidence is she's going to instruct you that you can use that as a sign of consciousness of guilt. What do you do if you know you've done something wrong? You can use that to show consciousness of guilt. And we're going to get to it, but I believe we have shown that beyond a reasonable doubt. He's going to tell you that the defendant, with her husband, immediately began to avoid detection because they're pulling cash out. They're pulling cash out of their son's bank account. They're pulling cash out of their bank account. Where's their son during this time? He's at Children's Village being arraigned with his court-appointed lawyer, where they had the opportunity to go see him, where they had the opportunity to go to that arraignment, and they did not. Because they never even went, they fled their house and went to a hotel, and then they ended up at an extended stay, and that is where they ultimately left one of the Kias, backed into a parking space. He's going to tell you that he eventually did apprehend the defendant. You've heard a lot about that. And he's going to tell you that there were hundreds of law enforcement officials on the scene when she was apprehended. Luke Kirtley, I know you will not forget him, coincidentally knew a lot about cars and coincidentally pulled into that parking lot right about the time and coincidentally had just seen the wanted poster, he called it, with a description of the cars and a photo of the defendant. And coincidentally thought, maybe that's the car. And you watch the video where he goes around and he sees the license plate and he plays it cool and slowly walks into the building and then makes the call to 911. He describes to you how within minutes, police officers arrived And then it had swarms of law enforcement arrived, SWAT, the marshals, ATF, the Sheriff's Department, Detroit PD, all sorts of law enforcement show up immediately. He also testified that the unit where Jennifer Crumbley was actually found was very close to his, and it faced the parking lot, and the whole wall was windows, and it was on the first floor. And he's going to tell you that the whole parking lot was lit up with law enforcement, lights, sirens, all kinds of things. Next, we heard from Corporal David Shaw, and he testified that once he got there, they took a 35-pound ram to breach the door, which was right outside the unit where the defendant was found. We heard from Brian Deloche. Also, didn't love a lot of things he has to say, but you deserve to know the truth. And the truth is, like it or not, this is who Jennifer Crumbley spent her time with, and she told him that morning, the gun's in my car, and I'm afraid my son's going to do something stupid. Before the shooting, the same day. You've also learned that although their Facebook thread in general was always deleted, after the shooting, it remained, except she deleted, not unsent. Rely on your own memory about what that testimony was. Those were not unsent messages, they were deleted, and you heard Ed Rogrowski tell you that. But these were the two that were deleted. On the run again, and we're fucked. William Freer testified what was found in the building and the art studio where Jennifer Crumbley was found. You saw the photographs. You learned that there was a little over $6,000 in cash. You learned where the phones were found, and the cash, and the purse, in the plastic tub, in another plastic tub with the lid on it, feet away from where the mattress was, and there are other things where you learned all those phones were off. He also testified what else was found. Booze, orange juice, ice, and avocado, bananas, socks, blankets, and that is the room where Jennifer Crumbley was ultimately apprehended. You heard from Lieutenant Willis, who was the officer in charge. He told you what it was like in the school that day. He described the autopsy protocols that were done and how each of those kids died and where they were shot. He told you that both Justin Schilling and Madison Baldwin were shot in a contact wound, which means the gun was either very close or actually touching their head. He showed you the video of the shooting. And again, this is not to incite emotion. The video of the shooting shows Jennifer Crumbley's son taking a stance he clearly knew how to take and was trained to take. And you watched his demeanor and the calculated, cold way he proceeded through those hallways looking for people to shoot. You saw the surveillance of how he ultimately surrendered. Walked out after executing Justin Schilling, laid the gun on a wastepaper basket, laid it safe, took the magazine out, and surrendered. He showed you and introduced the bank records that show you what they were doing after charges were either very soon coming and after they were announced. And he showed you an in-car video of Jennifer Crumbley and her husband, who just a few hours after the shooting embraced, kissed, whatever happens, I love you, don't say anything to the police. one of the elements we have to prove is what a person using ordinary care would have known about whether or not there was a situation that they needed to exercise ordinary care. So the defendant's knowledge about her son matters. But it's two different stories. It's what she knew before the shooting, and it's what she said she knew after. Before the shooting, she tells Kira, my son's weird. She always refers to him as an oopsie baby. She tells Amanda Holland he's lonely, he's hearing things around the house sometimes. She says, I'm a failure as a parent. The message to her son's friend's mother, he's kind of depressed in April. She texts that. And then the messages from her son. The messages in March about he's seeing things. Things are flying off the table. Now she wants to tell you that was just a joke, but I think you really need to consider whether a 15-year-old boy is going to text, could you at least answer me or reply to my text, as a joke. And we know there were no replies. There were missed calls. He called her. There were no replies. And she told us why. He was just messing around. But after the shooting, in the in-car, we hear her say, he's never been in trouble. He's never done anything. He's never done anything wrong. He's a good kid. Also in the in-car, I never even thought like he would have any mental issues. Like he never exerted any type of anger. He's never exerted anything. He's just like one of those mellow, laid-back kids. In the substation, he's never done anything. He's never done anything bad. After the shooting to Brian Maloche, he's never done anything wrong. Jennifer Crumbley has said a lot of things about that drawing and that meeting at the school. She sent the drawing to James and Kira and Andrew, as I said before, with the call now, emergency. She told Kira he couldn't be left alone. She tells Andy she needs to get him counseling, and she tells Amanda that the drawing was really scary. She agrees. After, this is what she says in the substation. Nobody didn't seem worried about it, and he said that my son's more than welcome to stay at the school, or he could go home. And I really wish we had taken him home. In the in-car, she said, I didn't even look at that closely. Now that I do, when I was at the substation, I looked at it closely, which we know is not true. I looked at them closely, and they're a little disturbing. Well, they're very disturbing, because look what he just fucking did. And then to Maloche, she says, the school was very nonchalant, but the paper they showed me had all of the things scratched out. That's just not true. It's just not true. And you don't have to believe me, because we have evidence it's not true, and you heard it. The statements about the gun are also numerous. She said, we've heard her testify the gun was in her car. We know that she's acknowledged that she drove to the gun range. There was no lock on the gun when she drove there. She returned with the gun. There was no lock on it, but she said James locked the gun when he got home. She didn't see him do it. She testifies at trial. James is responsible for the gun. In the substation, though, when asked where the gun was, hidden. In the in-car interview, James flew home and he's like, I had the gun hidden and I told him where I hid the bullets. He asked whether she kept the gun in her car. She shakes her head no. And she tells Maloche, after, the next day, we had the string lock on it it came with in the case. Everything was secured, not loaded, bullets stored separately. Oh my God, oh my God, oh my God. That is not what she says in the substation. Jennifer Crumbley begins distancing herself from her own responsibility about the gun. You heard her testify that they wanted to get the gun. It was my son and my husband. My son did a lot of research on the gun. I guess when I was shopping. She doesn't say she didn't know. She doesn't say that she didn't approve. She says it really interfered with going to get Christmas trees. That was what she was upset about. And she said it's James's responsibility. However, as I've shown over and over, at the substation and in the car, it's we. It's we take him to the range. Sitting here today, it's all James' fault. It's not hers. And then, of course, the statement that we don't really have to question whose weapon it was. Jennifer Crumbley posts, Ethan and James Crumbley both got handguns this week, testing them out at the range. That's in June. The evidence really shows that the shooter owned 2 guns. But for sure, she acknowledges Mom and Sunday testing out his new Christmas present. You heard evidence that was presented to you about the journal that was found in the bathroom by the shooter's backpack, right before the bathroom that he exited and started shooting. I have 0 help from my mental problems, and it's causing me to shoot up the fucking school. Next slide. First off, I got my gun. It's an SP 2022 Sig Sauer 9mm. The shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this. So yeah, I'm going to prison for the rest of my life, and many people have about 1 day to live. One of the things I want you to ask yourself when you go back in that room is why? Why, after hearing that there's an active shooter situation and knowing that your son is involved, you are taking the time to delete text messages and look at the messages that were deleted. We're on the run again. Helicopters, not sure where to. I'll message you, and we're fucked. Deletes, the gun is gone and so are the bullets. Oh my God, Andy, he's going to kill himself. He must be the shooter. Ethan did it. Those were deleted from her phone. She deletes all of the things she says about the drawing to Kira, including making sure that she still was going to get her lesson that night. This is the timeline from when in March, which you've heard a lot of testimony starting in about March, was where we first have evidence that he was struggling, he was hallucinating, he was seeing things, and he wanted her to text back and she didn't. We know that he had some incident, and he said that the mental breakdown in April. You saw text messages between James and Jennifer saying, did he say anything about last night? He woke up in our bed, he didn't know where he was. We don't know what that was about, but we certainly know that that is not evidence of somebody who is completely fine and stable. In fact, lots of messages from Jennifer Crumbley saying, I'm worried he's going to do something stupid. In April, she texts her friend that she thinks he's depressed. The Caltech and the Derringer was purchased in June. They go to the shooting range in June. They go to the shooting range in August. They go to the shooting range in September. And then in November, they buy the Sig Sauer. And we see the shooting range that Jennifer Crumbley went to with her son, testing out his new Christmas present. Here's what we learned Jennifer Crumbley did after the shooting. As soon as they took her phone, they bought burner phones in the pier at 8 o'clock the night of the shooting. They checked into a Holiday Inn Express that night in the pier. They then left and went to an extended stay in Auburn Hills, which Lieutenant Willis testified was almost across the street from the police department. Upon learning that charges were possibly coming, and the same day charges were announced, they leave that hotel and drive to Detroit. They withdrew $2,000 from a Flagstar bank on December 2nd. They drive to Owasso, an hour away, she says, because we just didn't want anyone to recognize us, to buy replacement phones. She texts that she's on the run again. Helicopters are not sure where, I'll message you to, at 7:31 a.m. on December 2nd. She texts on December 2nd, we're fucked, at 2 o'clock. On December 3rd, at 4:59 a.m., she texts, I'd rather die than go to jail. Then she withdraws $4,000 from another Flagstar on December 3rd. She checks out of the extended stay on the 3rd and drives down and arrives at Bellevue at 10:58 on December 3rd. You heard what happened. You heard her testimony. The facts do not support the story that Jennifer Crumbley told you. They just don't. There is no possible way, and Luke told you that, and so did Corporal Shaw, that you could be in that building with that many law enforcement and not know that somebody was there. And we don't even have to use that today's testimony, ladies and gentlemen, because she texted herself, I think we're caught, we're laying low. She texts that, we find out, and this is evidence we got this morning. She texts that after she's already said she took 4 Xanax and went to sleep. Now you saw that video. You saw that video. All those people, for over 2 hours, they're sleeping, and even when they come into the room, they still don't even act like they get up. It's just not true. And we know it's not true because they'd already taken steps. She had hidden the phones, powered them down, separate from all the other things they had, with the cash. Jennifer Crumbley wants you to believe that if only the school had done something different, we wouldn't be here. If only the school. Well, let's talk about what she knew that no school employee knew. She knew about the text messages in March that he was about a demon, throwing bowls, clothes flying off the shelf. She knew about the March 18th incident of waking up in his parents' bedroom and like he had way too much to drink and asking why he was in their room. She knew he had previously asked for help and to go to the doctor, and she laughed at him. She knew there were multiple guns in the home. She knew her son had been gifted a gun just a few days before the shooting. She had posted it on Instagram. But apparently, it's absolutely fine for all your Instagram friends to know that you got him a Christmas present with a 9mm handgun, but it's not okay or relevant to the people sitting in that room with that drum. She knew that that gun looked identical to the one in the drawing. She knew that the gun was accessible to him. She knew it wasn't stored properly. She knew that he was proficient with the gun. She knew he had access to ammunition. And she knew that her son was upset the night before. Now, that says he was locked out. She told Amanda Holland he got locked out. She doesn't acknowledge that. She does acknowledge that he did leave the house that night because he was upset. And we all know what he did. We all know what he did. He went to that shed and recorded that video.
I object. That video did not come into evidence.
Okay, it is in evidence.
Okay.
You're right.
That's true. Let's go back to the elements. Ordinary care. What ordinary care, the smallest, tragically smallest thing she could have done to prevent this? She could have stopped at home on the way back from the meeting. She goes right by her home to see where the gun was. She could have stopped on the way back to work. She could have searched the backpack. She could have asked her son where the gun was. She could have locked the ammunition. She could have locked the gun. She could have taken him home. She could have taken him to work. He could have gone with Dad. He was door dashing. She could have told the school that they just gifted him a gun. She could have embraced her son. She could have said, can we talk to him for a minute alone? She could have looked at him and said, I care about you, I love you. She could have at least acknowledged he was in the room. She could have told the school about her son being in crisis previously and asking for help. Ordinary care would have included all of those things. And the tragic part about it is none of it was hard. None of it. The smallest thing, just the smallest thing, could have saved Hannah and Tate and Justin and Madison. The smallest of things. I have to prove that there's reasonable foreseeability. And that worksheet right there that Jennifer Crumbley saw just hours before the shooting is reasonable foreseeability. And we're going to show you in the next slide. That's the picture of the gun. It's not just any gun, ladies and gentlemen. It's the gun that they just gave him. Blood everywhere. That's what he wrote with ammunition. I didn't show you the picture with the blood because I don't think you need to see it again. But we know what happened in that school and in that hallway. Here's a picture with 2 bullet holes and blood coming out of the figure's head. And look at that. That is where those shots went. Those are from the shooter's gun. The thoughts won't stop. Help me. These are all of the things that were texted to Jennifer Crumbley. This was in March. But he's writing it on a piece of paper and he's showing it to her. That is foreseeability. He's telling in that drawing, this is the gun that was purchased for me. Help me. Blood everywhere. The world is dead. I know you won't ever forget the video, but if you look at the defendant's son and see that there was no emotion, none. He was only concerned in a very calm manner for finding as many people as he could to kill, and he did. My life is useless. These statements from the defendant's son are just heartbreaking. I asked my dad to take me to the doctor yesterday, but he said, just give me some pills and told me to suck it up. Like, it's at the point that I'm asking to go to the doctor. My mom laughed when I told her, but I am having bad insomnia right now. I need help. I was thinking I could call 911 so I could go to the hospital, but then my parents would be really pissed. Like, I am mentally and physically dying. Let's talk about the cable lock. Jennifer Crumbley says that the weapon was used, but it was locked in a cable lock that came with the case. This cable lock that came is the cable lock that came in that case with the SIG. It's never been opened and it's never been used. This is the last picture that we have of that gun until we see it murder 4 kids on November 30th. And the person holding it is Jennifer Crumbley. She's the last person that we see with that gun. She's the person that said it was in her car, then she said it was in her house, it was her husband's responsibility. It wasn't hers. That's what she told you. She knew he was distraught the night before. He texted her, "I love you." She told you that's never happened before. She did think it was abnormal or odd. She knew he was looking up bullets in the school. She knew he was watching violent videos. She knew he was proficient with guns. She knew he was previously in crisis. She knew his only friend that he talked to was just gone. She knew all those things. And then her own statements, ladies and gentlemen, when she took the stand. She testified that when she's looking back, she still wouldn't do one thing different. Not one. Not any of those tragically small things. Even now, she told you she wouldn't do anything different.
Oh, that was big when she said that.
And then she also told you that we took his gun away. You heard her say it. And then she said she doesn't think of herself a victim, but she has lost everything. You're going to hear the instructions from the judge, and you're going to take the facts and the witnesses and the evidence and use what you promised to use, which is impartial, honest assessment, and find what you believe the facts are in this case. The flight, evidence of the flight and what they did after is not an element I have to prove. But what does it show? It shows the minute this shooting became public and ended up in the paper and the media, Jennifer Crumbley started telling a story, and then she ran. And she didn't run just because she was selfish, ladies and gentlemen. She ran, and she started deleting text messages, and she started telling a different story because she knew she had done something wrong. That's the only reason you start deleting text messages. It's the only reason that you start saying something that isn't true. It just isn't true. Jennifer Crumbley drove to Detroit with a bunch of cash and 6 cell phones powered off. You can consider that as consciousness of guilt. Everything she did from the time she found out that there was an active shooter and had a 10-minute call with her husband. They both say they went right, he called 911 right away. He did not. He talked to his wife for 10 minutes, over 10 minutes on the phone before he called 911. But the facts changed because it was the immediate attempt to misrepresent what actually happened. Why is a mother whose son just killed 4 people thinking about deleting her text messages? Why is she saying things that are not true about her son? Why does she care about her job? Why does she care about her horse lesson? Why does she care about any of these things? Because she knew she did something wrong. And she's deleting all of those things because she wants you to believe that she's somebody she's not. And you know what she's not? She is not somebody that used ordinary care to prevent what was foreseeable, reasonably foreseeable, that could have happened. Injury or death. And it did. It did. Those words on that paper helped me. She walked out of that school within 11 minutes, didn't so much even address her son. She did not give him the help that he wanted. And you can argue about the months before and the weeks before, but if you just even look at what happened that day, she walked out of that school and she knew She knew something bad might happen. What does she do when she gets back to work? She all of a sudden texts her son, "Are you okay? You can talk to us." These are the actions of somebody who was worried. She was worried and she was concerned and she was panicked until after. And then it's a different story. Why? Because she knew she had done something wrong. She walked out of that school when just the smallest of things could have saved, could have helped Hannah and Tate and Madison and Justin. Just the smallest of things. And not only did she not do it, she doesn't even regret it.
Hey.
We have proven beyond a reasonable doubt that she is guilty of 4 counts of involuntary manslaughter. It's a rare case. It takes some really egregious facts. It takes the unthinkable. And she has done the unthinkable. And because of that, 4 kids have died. So I'm asking you to go back when you hear the law, review the evidence, and find her guilty, because we have proven her guilty. Thank you.
Thank you.
Your Honor, I am ready to go, and I will, but I'm going to need to use the bathroom halfway through if I start now. Can I have like a 3-minute bathroom break, literally?
Do you guys want a break? Okay. So we're going to take about a 5-minute break, and then we'll do recess.
All aboard.
Okay.
All right, for the jury.
All aboard. What do you guys think, man? Here's what I think. Y'all tell me what you think. I missed some of it, but I was listening in and out on my phone. And I kind of started to question a little bit, like, do they have enough to, beyond a reasonable doubt to convict her? What do y'all think? Guilty, not guilty? Wait, what do you think? I don't know. I feel like the prosecution almost made me question it more a little bit. Guilty? Well, I guess we should do it. Let's do a poll now, and then we'll do a poll after the defense goes. Let's see. Let's do a poll. Yeah, it's mixed. It's very mixed. Oh my God, the chat's going crazy. Guilty, not guilty, and we'll give him out too. We always got to give him an out. I'm doing a poll right now, and then hung jury. Oops. Man, this is y'all better stop locking up your guns with a different code, or use that fingerprint shit too. They got the fingerprint ones. You can just put your finger. All right, so Shannon has to come in now. Shannon has to come in and do performance closing, but you got to remember they're going to get a rebuttal too, the prosecution, so they'll come back to have another chance. Okay, 57% say guilty. Not much has a little bit different than before. Not much. 25%. Ooh, same sentence as her son. Somebody's crimes and consequences said. Risa B, thank you for the 19 months, says guilty of a lot of things. Jamie, thank you for the 5, says breaking news. The whole family was weird. Guilty. GFAB with this sloppy ass closing. Oh! Welsh Dragon, thank you for the 13 months. Says check subscription, had to resub twice since Christmas. Oh, really? Yeah, check your sub. Make sure you guys are still subscribed. I heard some people sometimes get unsubbed. What are you doing, Ricky? Exploring the desk. So a little 5-minute bathroom break. Somewhat mixed. 56% say guilty, 26% say not guilty, 18% say hung jury. It's a really interesting jury that they have, too. We're reading it over the break. I felt for sure they were going to do guilty, like the jury, but then after hearing a little bit, I wish I would have listened to it all. I was questioning a little bit because even the state said it had like a high burden of proof. But the good thing is this could all be over today. You know, the whole I mean, I don't know about a verdict. I hope that they come back with a verdict today. I wonder if they'll keep them late. How long did the prosecution go for? 30 minutes? I feel like it's been longer than 30. 40 minutes, an hour? I really wonder how Shannon's going to do. It was that Toy White said, Shannon going to the bathroom to take 4 Xanax. Oh, wait. Sheriff Bear says, didn't they say no rebuttal? Really? Maybe not. I just figured standard is usually to do a rebuttal, but if they said no rebuttal, then that'd be interesting. I don't know if I'm saying not guilty. I felt pretty sure it was going to be guilty. Now I'm not so sure that the jury's going to do that. I mean, the thing is, there's several gun owners there, and I feel like they'll definitely come to the conclusion that this was reckless, the way they took care of this gun and Ethan and, you know, the code and the bullets and even the paper sheet from the school. Oh, no. Mohawk Mom says judge wants them to start deliberating Monday. Really? Ooh. Well, okay. That could be fine, I guess. I think the Adam Montgomery trial starts on the 6th. Well, jury selection. So we have time. If it runs over till Monday, I don't know what we'll do Monday. Maybe over the weekend I'll come up with some stuff we can talk about while we wait for the verdict watch. But Adam Montgomery jury selection, I think, is on the 6th. So we have time. I was worried about the overlap, but everything worked out. Thankfully, I knew not to. I figured just let things happen and figure it out when it happens, as it comes. What's for lunch? Lobster bisque? I don't know. This is so interesting that the jury is actually getting lunch sent to them, paid for, and they're getting catered to lunch every day. The judge said because she just doesn't want to take a chance of them running into people in the cafeteria. Kind of a concept. The running is so bad for Shizzle, for sure. I don't know why I said that. For sure, it's weird. It looks bad. The running, the damn zero code that he had access to all the guns all the time, begging for help, the math paper. I mean, even her saying that Malcolm recap the Montgomery case. Yeah, we could do that. That's a possibility. I mean, I could just sit and we could watch the video I did months ago that covers everything. We could do that. Covers everything you need to know, basically. Was the video he made the night before shown he was in court or anyone? Was the video he made the night before? The video, are you talking about the video where he's like like saying he's gonna be a school shooter and all that stuff? I think that was the day before. I thought he recorded it. If that's what you're talking about. Toy White says no, they did not say no rebuttal. Okay. They are doing rebuttal close. I figured they said no rebuttal in case. Wait, they said no rebuttal. They said no to rebuttal in case in chief there is rebuttal close. I don't know what that says. It just says no rebuttal, then there is rebuttal, then no rebuttal. What? They're doing rebuttal. I'm confused. Sorry. You might have to type it again. No rebuttal in case in chief. Not after arguments. Testimony, no rebuttal witness. I meant rebuttal closing. That's what I meant. Like sometimes prosecutor said no rebuttal. Okay, all right, cool. Fuck it. Even better. Maybe today will end early then if they're not even going to start deliberating. I'm surprised. Judge are so lax. Let's see the screen, Ricky. As they have the burden. Dang, so they really said they're not even going to start deliberating today? Oh, man. That's a... Does he shed hair? A little bit. I think so. It looks like a little bit. There is 100%. There will be 100%. There will 100% be rebuttal closing. Am I covering Dream's trial? I don't know. We'll have to see. I mean, the Harmony Montgomery, I think, will be done by then. I don't know if the James trial is just going to be a repeat of everything we saw already. I don't know if it's going to be like, it's going to drag out having to sit and watch everything again. It might be different stuff, but I don't know if it's going to be just a copycat trial. I'm sure there'll be some variations, but they're back. We'll see. It depends if you guys want it or not. I don't know if there's any other trials going on. I don't know if we want to do this again. Yeah. She's endearing in a strange way.
Oh, thank you.
She's been in jail all this
Your Honor,
time.
calling People vs. Jennifer Crumbley, case number 222799990, F8.
Sorry, one thing I wanted to tell you, I've been using up all my brownie points for the captain who has told me that we can stay later than we need to, if that's what you want to do. I'm concerned about sequestration and all that. When we pick 5 alternates, I'm going to put 5 alternates in another jury room, and they're going to remain sequestered in the same way that the 12 are. So 5 are going to sit in another jury room. If we come back Monday, I'm still bringing the 5 sequestered jurors back here.
If we come back Monday.
Right?
I think that's smart.
Yeah, well. Okay.
I know it's awful for them, but if one of them goes down.
Okay, yeah, no, I'm concerned about that, so that's what we're gonna do, right? I just wanna let you know, because when they go out to the jury room before I pick the 5, I'm gonna have them bring their personal things out here, because then they'll be separated, right? Okay. All right, so I'm gonna bring that.
Thank you, guys.
may be seated. You're not going to hear the defense, please. Ms. Smith?
Yes, thank you. As the prosecutor finished, she said, "This is shocking, unthinkable." I believe there were other words used throughout trial. Unbelievable. Obviously, unbelievable, unthinkable, unfathomable. And the reason that's the case is because it was unforeseeable. No one expected this. No one could have expected this, including Mrs. Crumbley. Now, the first thing I want to do very quickly is talk to you about the burden of proof. In the state of Michigan, there are different burden of proofs depending on what kind of a case it is. When people sue for money and say, "I've been injured," or "I was failed by the school even," there will be civil lawsuits, and the burden of proof is a preponderance of evidence. That means it's about a 50-50 standard. And if you have 50% of the evidence, that's the burden of proof for civil. When the state thinks it's important to take away a person's children, the burden goes up, and the burden has to prove more evidence, and that specifically is clear and convincing evidence that it's correct for the state to be taking away a person's children. Now, the highest burden in this country is in a criminal case, and that is beyond a reasonable doubt. And the reason I'm telling you about the differences in the burdens is because in a criminal case, if you have just one reasonable doubt about the case, you must vote not guilty. And so this is my poster just showing beyond a reasonable doubt is guilty, but there's many, many other options. If you think it's likely, probable, possible, not likely, those are all not guilty. If you think it's likely, probable, possible, not likely, those are all not guilties. You have to be sure beyond a reasonable doubt. And later, as I go through my closing, I am going to tell you the reasonable doubts that the defense believes exist in this case for you to look at. The other thing I have to ask you to keep in mind is that in the jury instructions, and I think you've been told this throughout trial, the defense does not have to prove or do anything. Like Judge Matthews said, we could sit at the table and play chess the whole time, call no witnesses, cross-examine no witnesses, provide no evidence, because we have no burden to prove a thing. However, in this case, you obviously saw the defense present Mrs. Crumbley, who took the stand, so that she could give you some context beyond parts of the evidence that were confusing when the prosecutor was introducing in bits and pieces. And the problem in this case is that we can all agree everything can be seen different in two ways. First of all, when you look back in hindsight with 20/20 vision, when you look back in hindsight, it is easy to say, this could have been different, that could have been different, this would have changed. And the other circumstance, the second one that makes a huge difference, is when you get full context around the evidence that is being used. And in this case, the prosecutor has cherry-picked little bits of evidence out of mountains of evidence to put in front of you with no context to explain what they're doing. And when you get cherry-picked bits of evidence, it's easy to reach wrong conclusions. Now, during jury selection, it felt like the prosecutor was asking you questions and giving more of a campaign speech than a jury selection proceeding. And I would suggest to you that at the end of the day, the only judge, although Ms. McDonald mentioned she's been a judge and was a judge several times during her jury selection, the only judge in this courtroom that matters is Judge Matthews. And the only other people whose judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Ms. McDonald's doesn't matter. The opinions of everyone in this audience doesn't matter.
And the family?
The media and all of the people who think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown.
She's talking to everybody, all of us, you, me, everybody. Shut up.
So during this case, it's obvious real life is messy and complicated. And during this trial, I will openly admit that I'm a lawyer who messes up. I get thrown off when I'm surprised by something. I feel like I get overwhelmed when information is coming at me quickly. I say I'm sorry a lot. Evidently, there's a TikTok channel of me saying I'm sorry through this whole trial. And all I'm saying is that I'm human.
Oh my God, I can't stand people like
and
that.
And so is Mrs. Crumbley.
I'm only human.
And that's what this case is about. She's not a perfect person or a perfect parent. I'm certainly not a perfect person or a perfect parent. And I'm certainly, beyond a reasonable doubt, bad with technology, which is why you're not going to see me touch that laptop.
Lord Almighty.
So during this trial, I have stood before you and shown you all my flaws, and I embrace them, and they are a part of what makes me human. And so has Jennifer Crumbley. She got on the stand and talked about every nook and cranny of her life, things no one else in the world knew, in her family, among her friends. And she wanted you to see the whole truth, the entire truth, and nothing but the truth on everything, where she had to show you that she has made immoral decisions to have an affair, that she has made decisions you might not make to have another person involved in the affair. Now, we didn't get too far into the details, but it was enough for you to know that Mrs. Crumbley got up there and literally stripped off her armor, let the prosecution cross-examine her, and show you what happened in her messy life. And I say that with all kindness because I'm a mess too. I saw a meme about a week ago that said, I'm trying to be a mom, trying to get exercised, stay hydrated, get enough sleep, text everyone back, and not lose my shit. And I've got to be honest, as a mom, a working mom, on most days, I'm lucky if I'm fit for human contact. I'm lucky if I've taken a true shower and didn't just grab a handful of wipes and scrub off the best I can on my way running out the door, putting on my makeup as I drive to court in my car. Because my life is not perfect, and no one's is.
Oh, hell no.
And during this trial, you may have concluded that you don't like me, that you hate me. That's fine. I am just asking that your opinions about me as a person, and if you're one of the people who plans to make a TikTok about me, that you won't hold those opinions against Jennifer Crumbley and will judge Jennifer Crumbley's case based on the evidence about her and her family. And if you hate her or don't like her or agree with things she's done, that's okay too. You don't have to like her. You are not expected to go hang out with her when this is all over. After trial, you don't have to decide if you want to go to her house. You don't have to have Thanksgiving with her. But when you're looking at the evidence in this case, it's important to set aside your opinions of her or take your opinions of me and supplant them on Mrs. Crumbley. Now, when I took on this case pretty early on, I realized I am Jennifer Crumbley and I could be here accused and sitting in her spot very easily. Now, in my house, we don't have guns. I don't have guns, but I do have children. And actually, I have an oopsie baby, my fourth one. I did not want 4 in 4 years, but that's what I was blessed with. I say I'm abundantly blessed. And I have kids that seem to have no issues. And at the end of the day, they're good kids. They go to school. We have no discipline problems. We have arguments here and there, just like every family does. I have a son that wants to hang out with me very rarely, but I have no belief that any of my 4 children would ever harm anyone else. And while I don't have a gun, I have a large butcher block on my counter with big knives that I use when I cook, and I enjoy cooking. And at the end of the day, my kids could just as easily grab a knife without me knowing it and without me having it on my radar and walk out the door of my house and go play with their kids, the other kids on my block. Granted, they live farther down my block because I'm in the middle of nowhere. And my son could kill somebody with my butcher block knife that I would have never expected to happen. And if you saw the text messages that my husband and I exchanged on a daily basis throughout this past year and even years before, it would be so easy for me to be in her seat.
Over here worried about TikTok. Wow.
With my kids, I don't monitor assignments. I don't look at their phones. I have no reason to. My son plays a lot of video games. My son's online talking to a bunch of people as he's playing a lot of video games. Even though he has a cell phone, I don't go through it and look at his messages every day. And as he gets older, I do know he's interested in girls. If he starts receiving nude pictures of a girl on the cell phone I own but let him use and gave him for his birthday when he turned 11, should I be held accountable for receiving child pornography if a girl sexts him over some inappropriate pictures? If my son decides he's going to send some pictures back and takes a nude picture of his bits and pieces, that's a 20-year felony. Am I then responsible because he sent a picture of his penis over to some girl?
Let's go.
So not only taking the picture, a 20-year felony, but then we've got a 7-year felony for sending it over. Can every parent really be responsible for everything their children do? Especially when it's not foreseeable. And this clearly was not foreseeable to Mrs. Crumbley, because there's no one in the world, including Mrs. Crumbley, who would have let a school shooting happen and let what happened on November 30th take place. Not only ruining the lives of so many families and victims and taking the lives of 4 young people, but also ruining her own son's life and ripping his life right from her as well. She would be the first person on the planet who would have never let that happen in a million years. So this case is a very dangerous one for parents out there. It just is. And it is one of the first of its kind. Luckily, however, this is a case where the prosecution cannot meet its burden of proof. And thankfully, it's a case where truly Mrs. Crumbley does have a defense. And this isn't just one of those stretched cases where a parent is liable for what their child has done. Now, the judge is going to tell you that you have to, if you find reasonable doubt in this case, you must find the defendant not guilty. And the law says you must have a reasonable doubt not 3 reasonable doubts, not 5 reasonable doubts, not 10. If you have a single reasonable doubt, you must vote not guilty for Mrs. Crumbley. And when it comes to reasonable doubt, each of you can have a separate reason to have doubt in this case. You don't have to agree on what the doubt is. And for that reason, what I am going to do is show you all of the doubts that the defense believes exist in this matter. Some of them may speak to one juror, some of them may speak to another, but at the end of the day, if you have just one, your vote in this case must be not guilty. So the first place the defense finds reasonable doubt is in the fact that the prosecution is so desperate to prosecute this case that they admitted a mountain of evidence that, quite frankly, was unnecessary. Now, they say to you they needed to show you, they needed to prove the manner of death. We stipulated that 4 people died. We stipulated that it was the most horrific set of facts you could ever imagine. We stipulated that what happened to Molly Darnell and Christy Gibson Marshall was horrible. But this prosecution, putting that evidence on, was designed to inflame you and make you emotional, strike your sympathy, and get you to hate Mrs. Crumbley, which, by the way, has been very effective for most of the media, most of the public, and for anyone who has seen information put out by this prosecutor in this case. A second reasonable doubt comes from the fact that we know, and the evidence in this case showed, context is key. And that was clear when Detective Wagrowski took the stand and said, you get better decisions when you have more evidence, and testified that in a former hearing, he messed up because he didn't have the video from before the one he saw. So he believed the parents arrived at the school together, and subsequently, when given more context, showing more video from further beforehand, he could see they actually arrived in different cars, met, and walked in the building together. And at the end of the day, the more context you have, the more accurate you can be. When Brian Maloche testified, another example came about where the prosecution had him testify that Mrs. Crumbley said to delete his messages, clear your cache. And I'm so thankful that the rest of the world sent me emails that I don't know how to pronounce cache, because now I do. And when Brian ended up seeing the messages before clear your cache and after clear your cache, he realized, oh, she wasn't asking me to delete messages. She wanted me to refresh my web browser to see if the Facebook had actually deactivated. And so that was proof again that when you have more context, you're more accurate. And the problem the prosecutor has in this case is they have very little context for the very little evidence they've submitted. There's also no context around some of this little bits and pieces of useless evidence, like Jennifer Crumbley saying that her son was an oopsie baby. I call my son that, so what? Does that mean I hate my son? Does that mean I would be okay if he went and killed a bunch of people and or if he committed suicide? No! Calling your child an oopsie baby was designed to try to make her look bad with no context. Having Amanda Holland come in, a coworker who's not a friend to Jennifer Crumbley and has been interviewed by law enforcement to tell you her advice on she should go have a mother-son day with her teenager, so irrelevant when she's faced with raising toddlers every day. When I heard her advice, I thought, yeah, right. I have 3 teenagers. I almost have a 4th. And personally, not only would they rather do anything else than spend a day with me, I'd rather do anything else. And we do spend time together, but that's not their first priority when they get to pick what they're going to be doing. It does not mean she loved her son any less. If she ever told a witness, my son is weird. And part of what made me realize I could be in Mrs. Crumbley's shoes is I've sent texts to my husband saying, our daughter is a psycho today. On the way to school last week, she's crying. She doesn't have people to sit with at lunch. I texted him, she's a nutcase. I don't know what to do.
She nuts? Maybe she just
I don't know
needs
how to
friends.
handle this. I don't have
Sitting
time
by herself
for
at
this.
lunch.
My other daughter is complaining about her lights flickering in her room. I texted my husband, this sounds like a case. The start of a case.
Feels like you need an
My
electrician.
husband works for my office. He's actually my office manager, so he knows about the case. He went in her room and figured out in 5 minutes it's because when she flips her blow dryer on, one of our plugs makes the lights flicker. So this ghost that you read about in my text messages, which by the way I did not respond to despite the fact that it's on our 6-person group chat, would be taken out of context and make me look like I don't really care that my daughter is crazy. I also got text one day, we have no food in our house. I am absolutely starving. You are the worst mother ever. And you know what I did? I ignored it. She was mad we didn't have the right kind of chicken ramen. When we have 85, I like the number 85. When we have 4 other flavors of ramen.
Be Frankie, chill
and
out.
there's
Slow
about
down.
100 other things she can eat. And I knew she's not going to starve to death, but taken out of context, it makes me look like a neglectful mother. But if you know all the circumstances and you know the relationship I have with my daughter, I knew it was an overdramatic, stupid point. So when you see messages from Mrs. Crumbley's son saying, will you at least call back? Those are so out of context. And when I'm driving home from court every day, I'm getting messages, will you at least call back? And I don't, because I know what they want is for me to run through the McDonald's drive-thru and bring everyone a Coke. I do stop and get myself a Coke, but I am not getting a round of drinks every day for everyone. And I've realized it's easier to not answer the phone. So you can find reasonable doubt from the context that the defense did actually provide. And when Mrs. Crumbley got on the stand and explained to you her understanding of ghosts and dishes flying and laundry flying, that is evidence, and that is something that can create reasonable doubt to hear what was really going on. Even if you believe the prosecution's dates about what was going on, it's not strong evidence, it's very misleading, and I'm going to go through what it does show. There are 3 sets of dates involving Mrs. Crumbley, all from March of 2021. The first time is March 8th and 9th. They introduced exhibits, including text messages on the 8th, where Mrs. Crumbley starts off asking, is he home yet? Is he home yet? I don't want him to do anything stupid. I'm sure you all remember those. Then they introduced evidence on March 9th that she went to the barn that day with her husband on the 9th. Then they introduced evidence, and I will give them credit, they put together quite a case, although it's really not important, that there was a picture of the horse taken at the barn that day, that the data supports there was a picture of the horse taken at the barn that day, and that there was GPS tracking information supporting that she was at the barn that day. Okay, fine. So on March 8th and 9th, there's concern that the shooter, Mrs. Crumbley's son, is making weird comments, and on the 9th, she goes to the barn and she takes some horse pictures. That's all that shows. Pretty minimal. Next, they went to March 16th through 19th, which was broken up into 1 million exhibits that, quite frankly, were out of order, threw me off my game, helped create these beautiful TikToks, and I'm going to tell you what they show. Now, these ended up all being admitted as exhibits, but I'm going to go in order of what they show. There was a text thread in Exhibit 85, which if you want to look at it, you can, where Jennifer Crumbley said, "I'm going to get drunk and ride my horse." This was on March 17th, St. Patrick's Day. A lot of people have a cocktail on St. Patrick's Day. That does not make her a mother that would be negligent or grossly negligent to her child. There's text messages from the day before where Mrs. Crumbley's son is saying some things about, now the house is haunted. Some weird shit just happened, now I'm scared. I got some videos, a picture of a demon. It's throwing bowls. I'm not joking, it fucked up the kitchen. I'm going outside for a while. Can you at least text back? On that day, Mrs. Crumbley didn't text back, but their own exhibit, okay, which is Exhibit 83, so the numbers do bounce around, so we go from 85 to 86 to 83, show that within an hour of the shooter making these ghost comments, she did call him. Specifically, she called him back at 7:24, and they had a 19-second phone call. If it was 19 seconds, it most likely was, I'm on my way home, we'll talk when I get home. So then the state, in order to make it seem like they've really, really got some proof here, they admitted exhibits 87, which show on the 17th on St. Patrick's Day, James was on a horse. They showed People's Exhibit 88, confirming the metadata that James was on a horse. They showed a picture, 89, of Jennifer on a horse that day. Metadata to prove she's on the horse that day. Another picture, number 91, of James on the horse, a different picture. The metadata to prove James is on the horse. A picture of Jennifer with her horse in Exhibit 93. And again, the metadata to support the picture was taken out at the barn and sent, and that these people talked about these horses. Okay, so fine. That's on the 17th of March. You're going to have access to all this evidence if you want to see it. Then they introduced exhibit number 86, which is where their son says the house is haunted. This is on the 17th. This is the day where he says, can you text back? This is the day where I already showed you the exhibit. She called him. She didn't text back, but she called him. And then they show a couple texts from a few days later on the 19th, where it's obvious from the messages the Crumbleys had had an argument with their son the night before. He was upset to have his phone and things taken away. That Jennifer Crumbley gave him a melatonin to go to sleep. She should have only given him a half. It's in the messages, but she gave him the whole thing.
Not a big deal.
And it knocked him out, and he slept in their bed that night. And when he woke up the next morning, James described him in the text messages as he woke up looking like he had way too much to drink last night, complaining about a headache. Jennifer says, well, he was really worked up and out of control, so I can see why, talking about his behavior during the fight. All I know, Jennifer says, he needs to eat, go to work hard, not complain, and he can get his stuff back. She testified that getting his stuff taken away is his trigger. It's what makes him get upset. She says, you respond and I didn't get it. James says, Jesus, yes. He said, let me ask you a question. Why am I in your room? That's when they talk about the melatonin. She says, oh my God. James says, I really thought you were giving him a Xanax last night. Jennifer says, does he seem better? No, melatonin.
No,
James says, I know. So obviously he's joking.
I don't know about
Jennifer
that.
writes, but he hasn't had one before, so I should have only given him half. James writes, well, he's doing his school, says his head's hurt, so he took Tylenol. Jennifer asks, is he okay to work? James says, yeah. Does he remember what he did? James finally says, dude, I'm working. I'm on a demo right now. I haven't talked to him. He's doing school. And that's really the extent of the conversation. So fine. So one day they get in an argument. And I'll tell you what, those kind of arguments in a heartbeat could have me sitting in her chair. The final date that the state claims Mrs. Crumbley had knowledge about back from March of 2021 are exhibits 96 through 100. And 96 starts off with their son saying, I'm picking up the room. I cleaned until the clothes started flying off the wall. This stuff only happens when I'm home alone. I pick the clothes back up, though. And that's the important part of those texts on the 20th. We know on that date, because the people proved it, no pun intended, but they beat a dead horse, that at 97, it's a picture of Jennifer at the barn. We've got the metadata showing Jennifer was at the barn. We've got another picture on 99 showing Jennifer was at the barn. And exhibit 100, Jennifer was at the barn. Big deal. Jennifer's at the barn. Their son is saying goofy stuff. Jennifer gave you the context. They had an Ouija board for a couple months after Christmas of 2020. He and his friend are playing with the Ouija board. They ultimately lost interest. They stopped doing it. Jennifer admitted to you one day to mess with them. She turned the power off in the house, turned the circuit off to mess with them. She mentioned a time where James pretended he was getting electrocuted. She didn't know what to do. She's screaming, trying to kick him, see if he's electrocuted. Ethan is laughing, taking a video of the whole thing. This family played together. They had fun. They did what families do. The prosecution just had zero context because they had tunnel vision that she was doing something wrong and was grossly negligent, and they were hell-bent on convincing you that was the case. So the other thing that you can find as a reasonable doubt in the case is the lack of evidence in the case as a whole. The prosecution has made very serious claims. And when you really look at it, they have very little evidence. So what they've shown to you, and I have it in these folders, are these dates in March 2021, which, by the way, are 10 months before the shooting even took place. They're before it would have... it's unreasonable to expect that things that happened in March of 2021 are an indicator that 10 months later their son's going to do something. It would be very different if every week there's something going on up until the shooting, but there's not. Because if there was, the prosecution would have brought that in and showed you every horrible thing that was happening to show you their son was being ignored, and they don't have the evidence. So what they did provide and what was admitted, this is exhibit, I believe, 423. These are all the Facebook messages between James and Jennifer.
Oh.
So when you look at those Facebook messages and consider, and this includes the photographs and the GPS
I like that.
stuff,
I like that.
that they're using this much compared to this much over the period between January 2021 and the shooting. This is a very little bits in time compared to the grand scheme of things. And while the officer testified and played games with me that he's not sure this is the best evidence against Mother, you better believe if they had better evidence, they'd be up here showing stronger and better evidence. This is it, ladies and gentlemen. It's obvious from the evidence in trial, and you may find it to be a reasonable doubt, that the Crumbley son was a skilled manipulator, and they didn't realize it.
Throw him under the bus.
He's not sick. He doesn't have a mental illness.
Hail Mary.
He's had no history of hallucinations. He has never shown his parents signs of mental illness. He certainly never showed signs of mental illness wanting to get a gun. No parent would purchase a weapon if they believed their child had mental illnesses. And these are people that had 2 other guns in the house for months where nothing ever happened with those guns. They had no reason to believe that somehow this 3rd gun was the thing that was going to make the difference. The texts that the prosecution admitted as Exhibit 101 were texts between the shooter and his friend that we have not named. The extent of these text messages saying goofy things like, I told my dad to take me to the doctor, he gave me pills to suck it up, it's at the point I'm asking to go to the doctor, I'm having insomnia and paranoia, I'm calling 911, I thought about calling 911, but my parents would be pissed. I don't disagree with the prosecution that these are alarming messages, but clearly the shooter's friend isn't that alarmed because he's not texting back. The shooter's friend knows there must be more going on because he doesn't tell Mrs. Crumbley, who is like, and he's like a second child to her. And we have no other context about these messages, and if anything, the evidence does not show that Mrs. Crumbley ever saw these messages. Now, when she sees them now, she thinks, that's crazy. She'd like to know more context. But you also have to know, and another reasonable doubt you may find in this case, is created when you compare these text messages that were sent that have alarming things between Ethan and his friend to all of the messages between them, which are over 20,000. And what you would have to believe, and what I would believe, is that if the state had stronger evidence, they would have paraded it up and we would have been seeing a lot more of these. But instead, they were admitted, and you haven't heard the friend testify, you haven't heard any context about these, and all you can see, and really all the evidence shows, is that there's no reason to believe Mrs. Crumbley ever saw that.
Drop the stack now.
I don't want to have another
please.
pizza situation, so move this down.
I'm watching.
What's that? I've taken your advice. Now, the other evidence the state has shown are little bits and pieces from the shooter's journal that are quite alarming and disturbing. But again, Mrs. Crumbley says the information in there about my parents won't listen to me for help is not true. And there is no evidence to show she ever saw that 22-page handwritten document. She never saw the little bits of evidence that the prosecution admitted. To evaluate this case, you have to look at it from the perspective of what she knew. So the journal information and the small amount of text compared to all the text with his friend are things she didn't know about. There's also 2 times where the state says that they have proof that Mrs. Crumbley's son was showing signs of depression or being sad or lonely. All right, those come from April 29th, 2001. This is when Jennifer Crumbley emails the friend, his mother, and all she says is that her son has been acting kind of depressed. She doesn't know what's going on. She's trying to find out what's going on, but he won't really tell her much. She's trying to find out if there's an issue between the 2 boys she should be aware of. She's trying to get down to the bottom of it. If anything, she's doing what a good mom does to try to figure it out. But the worst of what she says is that he's stressed by school. I don't want to get this wrong. He's been acting kind of depressed. And she's happy to hear it's not an issue between them. Then they go on to make plans for their son. This was admitted as Exhibit 104. If you put my texts up there and showed every time I told my mom that one of my kids was acting depressed or weird, I guess my favorite word is moody these days, it would look like my kids were complete lunatics. I'm actually shocked Jennifer Crumbley doesn't have more texts about her son acting like a typical teenager. And Jennifer Crumbley testified that although she said that, she didn't think it was anything she needed to run to a doctor about or anything she needed to do anything more with. And this moment passed, because if it didn't, the prosecution would have brought in all the texts that went beyond this, and there would be more evidence. They also brought in texts with the same parent of the friend from Exhibit 105, the friend's mother. When Jennifer Crumbley reaches out to her saying she had no clue what they were going through with their son, and she felt really bad about it, and asked how they're all doing and that they're thinking about them, that family, a lot. And ultimately, the worst that Jennifer Crumbley says about her son is, I know my son misses him, and if you need anything at all, don't hesitate to ask. That's it. It doesn't go on with wild depressions or hallucinations or mental health issues. That's it. That's it. I'm actually shocked there's not more instances of depression or moodiness or my kid is acting weird. The fact that there's this little evidence is shocking to me. However, it's a lack of evidence on the state's part.
Oh. All right. It's a little unhinged with the TikTok and the
There's
keyboard
also
warriors.
a lack of evidence in Mrs. Crumbley saying he's depressed to really anyone else. Even after the shooting, when she's talking to her friend Kira, to other people, to Brian, all she keeps saying over and over is, I wish there had been signs. I wish there had been something. He's a normal kid. There's a complete lack of evidence of mental health concerns specifically. If you want to really spend some time digging into this, you can read all the messages between James and Jennifer Crumbley, all of them, and you will find that there are not texts that go on that their son was exhibiting anything close to a mental health concern. And again, my text would read worse because I say things like, I think my daughter's psychotic.
She's trying to say she'd be found guilty. But then she says,
Mrs. Crumbley did have to evaluate what's going on with her son, and there was something alarming happening. She relied on people who spend day in and day out with kids, people she considers to have more expertise in kids than she does, including Pam Fine, who left her a very nonchalant voicemail that you've heard, that was Exhibit 115 if you want to hear it again, saying Ethan was looking up bullets in school today. It's not illegal, it's not wrong, he's not in any trouble. It's just like how teachers can't look up hops for beer. You don't need to call me back. She was relying on the representations by the school counselor, Sean Hopkins, who took the stand and has had a lot of training, hundreds of hours of training, and made it very clear this was just an issue where he needed some kind of therapy and didn't think it was necessary to suggest to the Crumbleys, go to Common Ground today, or serious enough that he called 911. And she relied on the assistant dean, who also has an abundance of experience Mrs. Crumbley doesn't have. And quite frankly, my kids didn't come with a handbook, and my guess is her son didn't either. And the assistant dean said the same thing. in the meeting with Mr. Hopkins that Ethan Crumbley that the son could remain in school that day, that he would probably be better off, according to Mr. Hopkins, around peers versus being alone, and that as long as they got him an appointment within 48 hours for some kind of counseling or therapist, that was sufficient. So it's absolutely not credible when a witness from the school, like Mr. Hopkins or Mr. Ejak, gets up on the stand and says, even if a kid is very sick, we cannot force them to go home. That is not true. And as parents with common sense, you should know that's not true. Because when my kids are puking, my kids' school will not let them be there. And when they have a temperature, not only can they not be there, but my children's school is always nice enough to remind me they can't be there for the next 24 hours, which means they can't be there the next day either. So reasonable doubt can be found in the fact that trained professionals told Mrs. Crumbley her son was not a risk, and Mrs. Crumbley relied upon it. This school also failed to even really look at the situation and tell her about things from the year before. They made it very clear that he was not in any kind of discipline issue, which is shocking to me and was shocking to Mrs. Crumbley, considering he's off topic looking at bullets in school. He's looking at a video in school of some kind of violent pictures, and then he draws a gun on his math paper instead of doing the math paper. So when school officials say, okay, this is really not a big deal, all we want is a counselor within 48 hours, Mrs. Crumbley took that as a very strong sign that things were fine. And reasonable doubt can come from the fact that those 3 people at the school, Fine, Ejak, and Hopkins, are mandatory reporters by CPS who would have reported if they thought Mrs. Crumbley or Mr. Crumbley were neglecting their son. Mrs. Crumbley even commented to others about the nonchalance that was at that meeting, that it was only 12 minutes long, which surprised her, that she was disappointed they didn't take it more seriously, that she was surprised there was no disciplinary action, and she left the school actually feeling better that maybe she had overreacted when she flew over to the school. Now, the people who are trained in these areas, they didn't just say, we're not trained in these areas. They gave specific examples. They said that kids who are really a threat, they would show nervous behavior. They would show anxiety about somebody else handling their belongings. In this case, the shooter was cool as a cucumber as Mr. Ejak went down, got his backpack with the gun in it, and brought it to him. And Mr. Hopkins and Ejak said they hoped they could get him into counseling today, but ultimately said he can stay at school and we'll give you 48 hours to get it situated. All right, so the prosecution keeps harping on the fact that Mrs. Crumbley knew they had bought a gun and that the people at the school didn't. This is Oxford Community Schools. These professionals testified about how common guns are at the school.
They did.
So common, and this kind of blew me away, although I live out there, that students are known to go to the gun ranges often.
On Wednesdays.
That girls on homecoming wearing their short little party dresses they wear to the dance take photos before the dance holding their guns. That kids go hunting on late start Wednesday before they go to school, and the school has to give reminders to parents for people to leave their guns at home. So this school that obviously has a strong gun culture going on, that sees a student looking at bullets, looking at a video game type thing with violence and seeing a gun drawn on a paper, that these school officials, knowing that community, that they didn't ask if he had a gun when they carried the backpack down and did make a comment about how heavy it was, although the comment evidently was made to a different teacher, and I misunderstood and thought it had been made to the shooter. So yeah, Mr. and Mrs. Crumbley, they didn't mention the gun, but they did mention that they had been at the shooting range with their son. And this is a community that is so into guns. I can't even believe that these girls, I always look at those pictures on Facebook and think, oh my God, how short are those dresses? And these are girls showing their dresses with their guns in their hand. They know this is a gun community. Reasonable doubt can be found from the fact that the biggest concern at the time was suicide and not homicide. The worst case scenario that was presented would lead a reasonable person to believe there was a possibility of suicide, not homicide. The prosecution seemed to also carry on about the amount of money and time that Mrs. Crumbley spent on horses.
Horsegate.
Just because she spends money and time on horses doesn't mean she doesn't love her son. And the fact that they have to stretch so much can create reasonable doubt. And if you actually look at the exhibits the defense submitted, you'll see that Mrs. Crumbley said she has to get a second job to pay for the braces, which are very expensive to put on her child's teeth. She paid for her son to be a part of a bowling team. She paid for him to do other sports. She cared about her son. Just because she cared about horses and bought medication from them and had a horse hobby, that's not any different than a dad who likes golf and buys new golf clubs and has a membership to a country club and spends time there and spends money at the bar there on days they go golfing. It's not any different. To try to suggest that it shows the priorities were on horses and not their son is just garbage. This is a son who had everything he needed and all kinds of opportunities in life. A son they take camping and on vacation to Cedar Point. Not only do they take him, they take a friend with them. These are parents that clearly love their child. They're sitting there playing board games with him, spending time doing that. That's all in the Facebook pictures that were admitted. Those are submitted to you as exhibits, and you can take a look at them if you want to. Brian's testimony in this case absolutely creates reasonable doubt. When Brian Meloche testified, there's no question he was inconsistent. And I would submit to you that there was no reason law enforcement needed to interview him for 2 hours, 1 hour, and then 3 hours. But over time, the police certainly caught on to the fact that the more you ask Brian the same question over and over and he realizes he's not giving the answer you like, he changes it. And while the prosecution tries to make it sound like, well, he didn't want his affair outed, from the very beginning, he told them he was having the affair with Mrs. Crumbley. That was not something that ever changed. It wasn't until the third interview when they started talking about his pension, talking about his job, that he felt pressure. He agreed with the word pressure, and he agreed with the word veiled threats, although he did take it back later, that the police wanted him to say something bad about Mrs. Crumbley. And I would submit to you that they probably did that to all of the witnesses in the case. But Brian Meloche was the one who admitted to it. And when Mr. Keast got back up there and asked him more questions, Brian got right back in line like he was supposed to and told them exactly what he knew they wanted to hear. Brian is a terrible witness. He said he had memory problems. And quite frankly, when he's testifying that he knows that the gun was in the car that day of the shooting. We all know no one thinks that's true.
About an Alzheimer's
Mrs.
patient.
Crumbley testified and explained the day the gun was in the car. Brian's just wrong. And when Brian testified that Brady was gone and he believed Brady died or committed suicide, I would submit to the jury that Brian is just an idiot and has no clue.
Oh,
and that the truth
I love it. Damn.
He didn't know the details about where the shooter's friend went. He just knew he went away. Wherever he got that suicide idea from, who knows? The prosecution didn't show any texts or anything to support that. But it's clear that Brian Maloche has been put on a mission, which is, you're coming into court, you've got some things hanging over your head, and we want you to take a position against Mrs. Crumbley. And I would submit to you that if you read the 77-page exhibit that I got yesterday and went through in painstaking detail with you, you can see that Brian Maloche did not think of Mrs. Crumbley that way when he knew her and when he dealt with her. And he testified the only places he got new information about her that made him think differently about his answers were from law enforcement and were from the media. The media that we have talked about in this case repeatedly as being inaccurate. Brian admitted that when the prosecution asked him, and we've already talked about this, to delete his messages, when I went through the part about clear the cache, Jennifer telling him clear the cache, showed him the stuff before and after, he realized it was just to refresh the page to see if Facebook had deactivated. So giving him little bits of information is particularly dangerous because he's not the sharpest. And that's what the prosecution did. They used him to their advantage to try to make it sound like they have this case and all these horrible statements against Mrs. Crumbley. And by the way, when they presented evidence that Mrs. Crumbley is deleting texts and keep making it sound like she selects different texts here and there, it actually sounds like Mrs. Crumbley deletes all her texts, as she testified, that when people start flooding her with text, she deletes entire threads at a time. Who knows what she's deleting? We saw her on her phone flipping through them super fast. And the texts ultimately that she deleted, the prosecution did point out two of them in their closing. They pointed out the texts about "we're fucked" and "we're on the run again," but they didn't mention that she deleted two texts that are actually very exculpatory and helpful to her. Why would she delete some of the most helpful and exculpatory things she said? Those two texts are on page 42 and 44 if you want to see them in the 77-page exhibit. And those two texts confirm, she calls it the string lock was on the gun. She means the cable lock, but she doesn't know enough about guns to say cable lock. The string lock was on the gun. And the other deleted text that the prosecution didn't mention was when she said that the weapon had been locked, the ammunition had been stored separately, and that everything was not loaded. There's no reason she would delete two messages that are that helpful to her. She's just a person who deletes all of her messages, as she testified to. You can find reasonable doubt that Mrs. Crumbley's state of mind is very obvious in statements she made after the shooting. Right away, she's talking about how she had no signs to believe anything would happen. At the substation interview, it's on recording, we watched it. She tells the interviewer, I had no signs, there were no signs. Then, when they have her in the car, the squad car, and she's in the back, she says to them again, I had no signs. In her text message with Kira, which was admitted, she says there were no signs. Kira says there probably were, you just missed them. With Brian Maloche, Mrs. Crumbley says again, there were no signs. I would submit to you, this is not some master plan where Mrs. Crumbley decides she's going to suddenly say there's no signs. First of all, there's no evidence of signs Mrs. Crumbley knew about. And second, all of her immediate fast statements in a time of stress, right after she's had guns held to her face, walking out the front door of her house, she's saying there were no signs. You might find, and I know the prosecution takes issue with this one, that Mrs. Crumbley was actually, in fact, a hypervigilant mother. She's the kind of mother who is going to the friend's mom to chase down why he's having a moody and kind of depressed day. She's on Power Schools on the app multiple times a day checking for missing assignments. She's emailing teachers about grades. Christy Gibson Marshall, the assistant principal, who did do one of the bravest things I've ever seen, she testified she saw the shooter's face and couldn't believe it was him. And the reason she couldn't believe it was him is because it was so unforeseeable. Mrs. Crumbley's hypervigilance also comes when you look at how she takes him for medical appointments. They're at the urgent care because some little mole on his back changed colors when she's applying sunscreen. I think of myself as a hypervigilant mother, and I've never noticed any moles on my kid's back, and I must need to go home and look. Because when I look at the actions of Mrs. Crumbley, she actually pays far more attention to that kind of thing and other things than I do. I could easily be sitting in her chair. When her son's experiencing headaches and medical issues, she's at the doctor or doing virtual visits. There's no reason to believe that's not true. With the headaches, they go through a whole process. She gets a whole x-ray done of his head. She takes him to the eye doctor to see if that's causing the issue. Ultimately, she pays and puts braces on his teeth. Then, he's a bad brusher, so she's going to the extent of getting the braces off his teeth so he can get the cavities fixed, 13 cavities. I would go crazy on my kid. And she's just doing each thing she needs to do as a hypervigilant mother. And yes, a hypervigilant mother can have a drink once in a while.
Oh, no.
I'm a hypervigilant mother, and I not only have a drink once in a while, but
I
sometimes
drink all the
I've
time.
been known to have 2.
When you come to
or
court,
3,
drink it too.
or maybe a bottle.
Oh, shit. Let's go, Shannon.
Reasonable doubt can be found from the fact that Jennifer Crumbley did her best as a mother. While going to the shooting range is not her thing, she's trying to find a way to bond with her son, who has just had his best friend move away. She took him camping, took him on trips, brought the second son along like I've already talked about. She let him have pets. He has the cutest little kitten you've ever seen in these Facebook pictures.
Aww.
Board game nights with him. She's not neglecting him in any way. And if anything, she's going to the gun range for him, not because she enjoys it. You can tell how much she loves it when she gets up there, shoots a couple shots, and then just stands there letting him enjoy the activity he likes. And I do the same thing for my kid. He likes to go to skate parks. I would rather do anything but go to the skate park. But I sit there and watch and say, oh, that was amazing. And all I hear is, Mom, watch this. Mom, watch this. Mom, watch this. And I would rather do anything else. But Mrs. Crumbley on that day is trying her best to bond with her child and have a relationship. Showing the pictures of the messy house was just not necessary. And the prosecution explained to you they weren't trying to prove she had a messy house, but much of it was just so unnecessary that I would suggest they are trying to make her look bad. They do kind of make her look a little bit like a hoarder. But if you saw pictures of my house right now, like a snapshot in time, you'd be just as horrified. I've been so busy getting ready for this trial, ready for all the fun we've had in the court and through these last few weeks. I still have my Christmas trees up. I was complaining to my husband the other day, oh my God, we still have our Christmas trees up. This is embarrassing. And he said, hey, Shannon, we still have ceramic pumpkins up. And I realized, oh yeah, all of our fall decorations are out too. And right now, I have piles of laundry all over. My kids over Christmas break put together stacks of stuff I need to take to the Salvation Army. I have donations of my own that need to go. My house right now, if they did a search warrant today, would look just as bad as Mrs. Crumbley's, and it says nothing about me parenting my child.
Wine and liquor everywhere.
If anything, when I come home from work, I make a deliberate decision. All right, listen, I can run around this house for 3 hours and try to get as much as I can done, or I can sit on my couch and watch old episodes of the Kardashians with my daughter. And I believe my time is better spent hanging out with her watching trashy TV than cleaning up my house because I get a chance to spend time with her.
Aww.
And Mrs. Crumbley was the same kind of mom. She was waiting until the holidays to have more time. She said she was going to clean her son's room. I would be screaming that I would make my son clean his room, but regardless, the project coming up was going to be to get those rooms in order. But at that point in the year when the holidays are coming up and you're getting ready for all of it and going through Thanksgiving, it does get to a point where you do have boxes piling up and you're just trying to get through those last days of school to get to Christmas break. There's reasonable doubt when you look at what Mrs. Crumbley thought after the meeting with Mr. Hopkins and Mr. Ejak. The state of mind she was in and her thoughts and what she was thinking come in through her statements. She thought everything was way less of a big deal when she left that meeting. She thought leaving him in school with his friends was the better decision based on Hopkins saying peer support is a good thing. She thought making him an appointment was sufficient. An appointment within 48 hours was sufficient. That doesn't even mean the appointment was going to be within 48 hours.
Just growing on you?
Reasonable doubt can be seen in the video when Mrs. Crumbley first sees her son at the substation. Her reaction to seeing him in this complete state of disbelief as to what's going on is to look at him and say, why? Why? She doesn't look at him and say, I knew you were going to do this. She doesn't look at him and say, see, I knew we shouldn't have bought that gun. She says, why? Why? And when he says, take care of Dexter, she cannot believe that's her son and goes back into the other room with her husband and says, what the fuck? He didn't even care. And while the prosecution asked questions about, well, she's not sobbing and we hear sobbing, and that's clearly James. James is sobbing. When you look at the video, if you decide you need to see it, Mrs. Crumbley is dabbing her eyes and wiping her eyes. And fine, she's not the crier some other people are. Reasonable doubts can come from the statements in the heat of the moment at the substation when Jennifer Crumbley is in a state of shock trying to answer their questions. She says, he's never done anything bad. This is after she already has somebody saying you really should have a lawyer there. She's still just talking about what the truth is. He's never done anything bad. One of the parents says he's a perfect kid. Jennifer Crumbley tells them the most of an issue he ever has is anxiety over tests. Jennifer Crumbley tells them everything was fine this morning. In the statements Jennifer Crumbley made when she was in the car and doesn't even know yet if there has been fatalities, she says he's never done anything. She acknowledges he ruined lives today. She says, it's the first time I've ever seen him do anything. She says, he's a good kid. He's never angry. He's mellow. He's not what he looks like. He's not a monster. And she's not a monster either. She explains to them in detail when they ask, he's never had mental issues. In those moments, she can't even think straight about life around her. She's worrying about a horse and her job and all kinds of random stuff. And ladies and gentlemen, when Emergencies happen. Life doesn't just stop. So the fact that she's able to function and think, I still need a job, I need some money, I need a phone that works, that doesn't mean she thought her son would terrorize and kill people and shoot people at a school. Her reaction when she finds out there are fatalities was genuine and honest, and she broke down crying, although she does continue to keep answering their questions. She explains why she feels like fatalities are different. She explained that on the stand. If he had shot people and injured them, it was something they could at least deal with. But a fatality is a fatality and can never be changed. The prosecution's attempt to misconstrue Jennifer's entire demeanor is a reasonable doubt in this case to show they don't have a strong case. They keep saying she's not sad. Jennifer explained she went into what can I do mode. She did show sadness if you read the texts between her and Mr. Milosh. She showed sadness in the way that she shows sadness. And for these officers to get up on the stand and say she didn't behave like the mother of a school shooter should behave is nonsense. None of them have ever dealt with the mother of a teenager who has just killed people and shot many others. There isn't a right way in any handbook to say how you should or should not behave. Trying to make her look selfish and callous goes right with that same thing. How she reacts is how she reacts. You see it on the screen. It's really hard to pass judgment, although these police officers did, on how a person should react when for the first time in their lives they walk out of their house and are surrounded with guns in their face. Or how a person would react to be woken up in the middle of the night on a mattress with police around them and above them with guns in her face. So not only has anyone not been in the shoes of a school shooter and dealing with the kind of emotions that would come with that, they also don't know, and there isn't a standard reaction for how you behave when you're surrounded with guns in your face. Jennifer's own statement provides reasonable doubt that she didn't think he would hurt other people. She typed to him, "Ethan, don't do it." She didn't say, "Don't shoot people." She didn't say, "Don't hurt anyone." She thought the only thing on her radar that could be possible at that point, knowing there's an open shooter and he has a weapon, was that he would kill himself. Reasonable doubt can be found in Jennifer's testimony. Jennifer's testimony is evidence, and at the end of the day, whether you believe, like, hate, however you feel about her testimony, the defense didn't have to prove anything. You still have to evaluate the prosecution's case for what it was. However, Jennifer Crumbley did take the stand, and that was not easy for her, to give you additional context about what was going on in the shreds of evidence the prosecution cherry-picked and put before you. The only person who's actually been consistent in this case, and you can find reasonable doubt from this, is Jennifer. She's consistent in what she says to police, what she says to her husband about things, and what she says to other witnesses who testified. You can find reasonable doubt in the fact that the police officers are very, very biased in this case. There is no doubt this is one of the most awful situations any one of them have ever been involved in. But it's also very clear they have a narrative that Jennifer Crumbley is responsible, and when they came in here and took that witness stand, they were going to mess with me on questions that were so stupid Like this ATF agent telling me he doesn't know if teenagers could lie. Everyone in the room knows a teenager could lie. That was a low ball. Just answer the question. When you have an ATF agent that can't even get on the stand and answer a question that's common sense, that should speak volumes. That there's a narrative they've been directed to get out and they have an agenda. And that agenda, ladies and gentlemen, is not positive for Jennifer Crumbley. Making this big deal about money and cash that Mrs. Crumbley took out is another reasonable doubt in this case. Mrs. Crumbley explained her dad had accounts frozen. She didn't want her accounts to be frozen. Her dad put money in that day so she could take it out. Getting money out of the account that had her son's name on it wasn't done in any way to steal money from her son or show she doesn't care about him. She's the one that contributes every week from her paycheck into that account. And at the end of the day, she wants cash because everyone in the world absolutely hates her. She can't walk in places and hand them a credit card. Hey, Jennifer Crumbley's on that credit card. The only option she had was cash. She can't go in and start showing identification and things to get hotel rooms, and the more cash she can use, the better. The less she has to risk that people are going to figure out who she is.
Need a better story for this one.
The world was essentially showing its colors against her as she was receiving threatening messages in the days that followed that shooting. On Facebook, from other people, in her emails, in her Instagram, everywhere. They're so threatening, her employer is making her shut down accounts. Her friends, people that have been her people for years, don't want anything to do with her and don't want to be by her because she's that dangerous at that point in time. So for her to want to have cash makes absolute perfect sense. That's not a sign she's trying to flee. And also, if you're trying to flee, you don't go around local Oakland County and areas surrounding it and carry around a syringe of horse medicine. If you're going to flee, you abort mission on the horses. At that point, you're fleeing. It's very obvious Jennifer Crumbley, her intent was not to flee. Her intent is to stay safe. Her intent is to avoid threats. Her intent is to get this horse medicine to this horse, which obviously can't happen if she flees.
Can't leave the horse behind.
It's clear when she's at the art studio that she's not hidden very well. She's outside smoking. Her husband's outside smoking. We saw the evidence of the cigarette butts in the snow. There's commercial buildings around and businesses within that studio. She's walking around taking a tour of the studio with her friend who owns it. And there's cameras all over the building. Obviously, she's not trying to hide if she's going into a building where you can see security cameras right on the outside that would document everything that's happening that we ultimately got to see in this trial. It's clear she's trying to stay the night in Detroit on November 3rd and didn't know where to go. It's clear from the video she's dead asleep at 1 o'clock in the morning when they're ultimately found and woken up to guns in their face. She testified she took 4 Xanax and so did her husband. We also saw evidence there was a liquor bottle in the garbage and presumably she had a drink. After 4 days of no sleep and not really eating, one can only imagine how hard 4 Xanax and a cocktail might hit you.
Actually really unsafe.
So they make this big deal that there's text messages after 11 o'clock saying we might have been found. Well, earlier in those text messages that were admitted by the prosecution as Exhibit 430, the first text says, Marielle, this is Jennifer's phone. And Marielle was the other attorney at the time. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. Next message. The other phone broke. And then there's a message to the Crumbleys, when you can, we'd like for you to call us. That's at 6:19. Then at 6:21, thank you, Shannon's calling you both shortly. Then at 7:02, I text, Marielle and I are going to come get you in the morning. We do not think it will help to make a statement that you're coming in or that it will be tomorrow morning. All we can say, as we've told everyone, is that you're coming back, and as of tomorrow, you'll be back. My next message says, we can show them that everything we've said was going to happen did happen. Because the Crumbleys weren't running. They just wanted to turn themselves in to a court. And law enforcement got on the stand and told you that's something people commonly do. It just didn't happen in this case. At 7:03, the Crumbleys write back, and we don't know if it's Jennifer or James because they're sharing his phone. Okay. Text to the lawyers that say Marielle Shannon lawyers. Who knows why they sent that? I text, I am going to drive home from my office right now. I'll give you a call in about 45 minutes so I can get all of the bond factor information written down for you for Marielle and me. I'm asking for bond information so we can go to the court in the morning.
Your Honor, I'm going to object. There's a prior ruling. She cannot be a witness. That was already dealt with.
Sorry, I thought I was arguing off the evidence they admitted.
Well, you can argue off the evidence.
Okay. So they say at 7:37, okay, we'll be waiting. I'm going to call in 1 minute, okay. Then at 11:14 on the phone that both of them have been using, a text is sent to the lawyers. Think we might have been found, don't know, just a heads up, please check. It's not for a couple hours that they're actually found, but Mrs. Crumbley testified she didn't send that text and she was already asleep. Now, after those text messages, there's 2 more pages that are included in that exhibit. So if you do end up taking a closer look at 4:30, which is totally fine, just be aware that there's another thread that starts that's a repeat, and I don't know why that is. I just want to let you know that, and I'm not sure why that exhibit is like that. That was a new one we got, obviously, all today. In the days after Mrs. Crumbley and Mr. Crumbley are planning to turn themselves in, we know they're planning to turn themselves in because Exhibit A was admitted, which showed they were trying to find a hotel in Auburn Hills on Priceline for December 4th and 5th, in case they needed it for the weekend. There's no doubts, and I don't need to go on and on about this, they were getting threats. That was so clear at trial. They were afraid to go turn themselves into a police station. A police station where if they went, there would likely be other inmates or bad people there, and their faces would be up on a TV because it was all over the state at that point. They were terrified. They wanted to go in through a lawyer. Reasonable doubt can be inferred from the fact that they set an alarm clock, which was admitted by the prosecution, showing that on Saturday they were getting up at 6:30 or 6:45, completely consistent with their plan to go to Novi for an 8:30 hearing. This is also not James's trial. I am not standing here suggesting that James is guilty of involuntary manslaughter in any way, but it is important to point out that James was the parent responsible for all of the storage of the guns. Jennifer Crumbley barely knew a thing about them. She didn't object to them being in the house. She didn't object to buying the gun that James and Ethan were interested in. She didn't object to calling it Ethan's Christmas gift. She was not responsible at all for the storage of the weapon. It is misleading to suggest by the prosecution that that 6-hour case was open on the bed and that it sat open like that all day with the ammunition box next to it. It's very clear that when James and Jennifer Crumbley were on the phone during that 7-minute phone call, Mr. Crumbley was looking for the gun, found the gun was missing, asked Jennifer Crumbley, where's the ammunition, pulled it out, and set it on the bed. It's not like that gun box, that case, was just sitting out there open at all times. When law enforcement did get there, find it on the bed, even they moved it around to the kitchen counter and other places. While this is not James's case, it is fair that Jennifer Crumbley would expect that he would have more flexibility in going to handle an issue at the school. That is not unreasonable and does not make her a bad mom. He's out in the Oxford, Lake Orion, Rochester area door dashing. She's the one with the professional career supporting the family and paying all their bills and trying to keep her job, which they may need to add the family on for insurance in this open enrollment period. She shouldn't be diminished as a mother because she was going to let father go to the school and handle whatever issue there was. Now, ultimately, they went together, but he's a DoorDash driver. She's trying to pay the bills. She's the breadwinner. At that time, he's in between jobs. She shouldn't be dinged for that.
Throw him under the bus and DoorDash.
It's misleading for the prosecution to suggest there's been evidence in this case. She keeps guns in the car. She didn't say she keeps guns in the car. When she was interviewed, and if you really want to watch the interview, you can, Jennifer told law enforcement there was one time that gun was in the back of her car. That one time was when James put it in the back of the car, and she drove the car to the range. Her son and her had a experience at the range, and she drove the car back home, left the car locked with the gun in it, so that when her husband got home, he could put it away. It is not true that she was driving around keeping guns in the car. That is not what she said to police. As far as Mrs. Crumbley knew, there was a cable lock on the gun at all times. She called it a string lock. She testified that the key was kept in a separate place in one of the many beer steins they had. She testified that she did know where the ammunition was. She hid it in her drawer of jeans. And she testified that things were locked and hidden separately, and that Mr. Crumbley was responsible for hiding the weapon. If you are upset with how the weapon was hidden, that's not your issue to decide. That's a future jury that will look at the case of James Crumbley. You're here to look at the case of Jennifer Crumbley and consider what she knew. She is not the person responsible for storing this weapon. I'm not trying to suggest she didn't know it was in the house, but she is not the person putting the cable lock on and off or doing anything with the gun. We saw her gun abilities when she went to the range and had to have her son show her everything about it. It's a gross overstatement to keep saying that the gun was his gift. It's very clear it was something bought for him to use at the shooting range, something that may one day ultimately be truly just his. But it's just like any of us giving our kids a laptop to use, a cell phone to use, a car to use, a jet ski. I have a friend that has kids, they have snowmobiles. Nothing different. It doesn't really mean the kids just have free access to all of that stuff. It comes with conditions, rules, and parameters. Unfortunately, this is a case where the prosecution made a charging decision way too fast. It was motivated by obvious reasons for political gain and media attention. And we know that because on 11/1, when the shooter was arraigned, the shooter was on Zoom, and so were the parents, and the media was aware. And when Mr. and Mrs. Crumbley were charged, and there was a swear-to at the court, the media was all there, but guess who wasn't? Mr. or Mrs. Crumbley. Mrs. Crumbley testified she didn't even know there was going to be an arraignment, but the media knew. And then the prosecution came out with a big press conference announcing it.
Tell it.
I would submit that the plan was never to let the Crumbleys turn themselves in, but to turn them into a big charade of looking like they're trying to flee when they absolutely weren't. The prosecution and law enforcement have approached this case with tunnel vision from day one. Brian Maloche called it a witch hunt. I would submit to you it was. And once they charged these parents and the ATF, Sheriff's Department, Border Patrol, Secret Service, all U.S. Marshals, not Secret Service, when all these agencies have gathered around and hundreds of people are looking for the Crumbleys, it's really hard to say, we made a charging decision a little too fast. And in this case, you heard evidence that much of the evidence in the case didn't roll in until after the parents were charged, arrested, and in jail.
You got a lot of cards still to go through.
To try to suggest having multiple
too.
phones as a sign of fleeing is just garbage. I think everyone here clearly understands why they bought burner phones and why they went and bought replacement phones with their phone numbers so they could use two-factor authentication to get into their accounts. Jennifer Crumbley is seen in the police interview at the substation handing her phone to law enforcement when they're asking questions. When the police tell her they want to take her phone for a search warrant, she doesn't want to hand it over right away, but it's not because she's trying to hide things. It's because it's her only line of communication. She doesn't really understand how a search warrant works until her husband explains it. All of her contacts are in the phone. She doesn't carry around a little diary of all the numbers, although police do let her get the numbers out. And it's the only way people can get a hold of her, and she's been in touch with them nonstop, as we can see when she's in the police vehicles. And again, although she's on her phone, and there's a substantial amount of time where she's looking things up, communicating with people, trying to get things done, that doesn't mean she believed her son was a school shooter and had no emotions over what was happening. The prosecution has painted her out to be a person who lacks remorse, and I would submit to you that she would change everything if she could. And when she looks back and says there's not a thing that she feels she could have changed that would have changed something, you have to keep in mind that the suggestions by the prosecution are just ridiculous. Giving him a hug that day in the counseling office was going to stop a mass shooting? That's just ridiculous. There is nothing to prove that anything could have stopped a mass shooting when you're dealing with someone who is so manipulative and is a criminal and was a shooter in cold blood and pled guilty and took responsibility as an adult for his crimes. Finally, my last reasonable doubt card is blank, because I've tried my hardest to come up with all the reasonable doubts the defense sees in this case. And like I said, each of you need only one to vote Mrs. Crumbley not guilty. But a lot of times jurors think of a reasonable doubt I miss because there's so much evidence. And we've already established, and I've admitted I'm not a perfect person and not a perfect lawyer. So I put a blank card before you so that if you have a doubt I've missed, you know you're not limited to what I've suggested or the defense has suggested. You're welcome to come up with your own doubts on your own. And if you decide you want to dive in and read the truth between Mr. and Mrs. Crumbley and everything they talk about, you're totally more than welcome to. Those exhibits are all going back with you. And what I'll tell you is that you're going to find a lot of instances where Mrs. Crumbley is anxious, asking where her son is, where her husband is. You're going to see a lot of horse talk. You're going to see arguments between a married couple. When I read them, they read just like my husband and myself, yelling and swearing at each other at times. And then the next message says, hey, what do you want for dinner? And then we just move on, and that's just how life is.
Okay.
You'll see messages in here that will certainly make you blush when you read what Mr. and Mrs. Crumbley intend to do in bed that night.
Oh.
You will read a variety of messages that show real life and real life between two married people that have a child. And it should make no difference that they may use their horse's name more often than their son's.
Damn.
And I'd also submit that every time you see them talk about when is he going to be home and what are we going to eat for dinner, even if they don't use the words spelled E-T-H-A-N, that's who they're talking about. Because there are only 3 of them in that house. At this point in the trial, I am asking that you find Jennifer Crumbley not guilty, not just for Jennifer Crumbley, but for every mother who's out there doing the best they can, who could easily be in her shoes, for every parent doing the best they can, who could easily be in their shoes, for every parent that has snippets of text messages that could be read and make them look like horrible monsters, for every parent that has fights with their kid on text message that also could make them look like terrible parents.
It's appealing to everybody.
For every parent that's ever had a hobby and has not spent 24/7 with their child. That should not be held against parents. For any parent that's ever had an affair or spent time communicating on an affair, that says nothing about how much you care about your child or your expectation of whether or not they would commit a school shooting. Most people who have affairs would still not expect their child would do this. I do wish more than anything this case could bring justice to the victims of the shooting, the victims of the terrorism that took place that day, and the victims of their families. I wish more than anything it really could be a result that would be a Band-Aid to make everyone feel better, but it can't be. First of all, it brings back nothing for the people who have lost. It certainly doesn't bring back any lives. And if anything, this is not justice. This is not how justice works. This case does nothing for the people who have already lost everything. Many of the people sitting in this courtroom. And it does nothing to bring back the tragedy and the tragedy that unfolded on November 30th. At this point in time, the prosecution cannot prove that Mrs. Crumbley avoided exercising ordinary care that would have saved lives. The prosecution cannot prove that Mrs. Crumbley was aware there was a danger that existed by her son that required her to exercise reasonable care. They cannot prove that she was grossly negligent and that there was any way she could foresee that this would happen, as awful as it is, and we all stipulate it is. At this point in trial, I always have to sit down. This is how the court rules work. Prosecution gives a closing, I give a closing, they have an opportunity for rebuttal, and then I don't get to say anything else. And I'm sure you can see from my demeanor in trial, when the prosecution says something that I know I have an argument against, I get anxious, you can see a reaction, and I'm not going to do that. But I am going to tell you that as they argue, I will have many things that I wish I could get up and say, that's not true, and argue against. So what I would ask is that when you go back in the jury room and begin to deliberate, you think about and ask yourselves, what would Shannon Smith have said in response to the rebuttal where they get the last word? I would just ask that you consider that in your deliberations, because I guarantee you I'll have a very hard time sitting here knowing that the prosecution gets the last word when I know the defense would disagree with it. And I am asking each of you to vote that Mrs. Crumbley is not guilty, because she is not guilty. and because a not guilty verdict is the only fair and just result in this case.
Thank you.
Woo!
Yes.
Fuego caliente. Fuego.
The last word.
Oh, she said I do get the last word?
The people do. Because it's our burden.
Oh, ooh, she started
And
too. Which is slick.
That's why we get the last word. And it's a burden I embrace. It's
a
a
little fire.
burden to prove beyond a reasonable doubt that Jennifer Crumbley is guilty of
support her.
involuntary manslaughter. It's not a burden that I have to prove every single fact about the case beyond a reasonable doubt. That's not the law.
You mad?
That's what she told you the law was. It's not the law. The law is I have to prove every element beyond a reasonable doubt. Beyond a reasonable doubt. Not any doubt. Beyond a reasonable doubt. The defense gets to decide how they present their case. They get to decide that. She gets to stand up and say what she said. But your job is to listen to the facts of the case. Your job is to listen to what the judge tells you the law is. Your job is to tell you to look at the evidence, the people sitting here, not what somebody else wants to have said that they said, but what they actually said. Your job is to consider not what lawyers say about their own life and their own circumstances and their opinion. Your job is to consider the facts and the evidence in this case. I have to address a couple things, and I'm going to be quick. There was absolutely no evidence at all presented to you that anybody at that meeting told Jennifer Crumbley it was no big deal. There was no evidence of that. There was no evidence at all that Jennifer Crumbley was very surprised by how long the meeting lasted. Jennifer Crumbley didn't say that. That's not into evidence. I don't have to prove, the people do not have to prove that Jennifer Crumbley knew that there was going to be a homicide or a school shooting. As Lieutenant Willis pointed out correctly, if she knew exactly what was going to happen, she'd be charged with murder, ladies and gentlemen. She is not. She is charged with involuntary manslaughter. And the elements, you'll get them. I read them to you. The standard and what I have to prove is not that she knew that her son would go shoot up the school and kill 4 kids. I have to prove that she had a legal duty. She negligently performed that legal duty. She negligently did not take steps to take care and protect the other children in that school when there was a reasonable foreseeability that ordinary care was required. The smallest of things. The smallest of things. I apologize to the law enforcement in this room and any listening that I have to stand here and to defend their integrity. But I do. Because if you believe that Special Agent Brandon and Lieutenant Willis and the other law enforcement that took the stand here, including
What objection?
I'm objecting because I'm allowed to argue based on what's in evidence, and Miss McDonald is trying to make me sound like I've done something wrong. And I didn't. My argument was proper.
She's arguing. It's my rebuttal.
Yeah. Overruled. You commented.
Can't let her get the last word. It's hard for her to let anybody get the last word.
These statements of the police officer, she gets to argue about the statements.
The exact quote was, "They probably did that to all the witnesses in the case." If you believe that, then you believe that the sheriff's office, Lieutenant Willis, Special Agent Brandon, the ATF, the federal marshals, the Detroit Police Department, anyone who the evidence tech, they were all in some sort of conspiracy. That's what you have to believe, and I know that that's not what you're going to find. Look at the evidence, apply the law, and decide what the truth is. That's all I've ever asked you to do. That's all the judge is going to ask you to do. Nothing here was designed. Nothing here was made up. And I don't have to convince you of that, because I know that you're going to use your hearts and your minds and your sense of reason, and you're going to look at the evidence. first statement Jennifer Crumbley makes about this gun, her son's gun, was at the substation after the shooting, and this is what she said. It was hidden. It was hidden. That's what she said. It was hidden, ammunition separately. It was hidden in a dresser. It was hidden. That's all she said about it. The school's actions or inactions do not excuse the culpable behavior by defendant. Ladies and gentlemen, he literally drew a picture of what he was going to do. He drew a picture. It says, "Help me." It has the drawing of the gun that she bought him, posted, and bragged about. Blood everywhere. The thoughts won't stop. The world is dead. He drew her a picture. Pretty egregious and unique circumstances. And in fact, it is absolutely not true that we have to worry that we'll all be sitting here. We agree on one thing. Her testimony is evidence. Jennifer Crumbley's testimony is evidence, and you should consider it. And when you consider it, I'm confident that you will agree it is not consistent at all. It wasn't even consistent from her direct examination to her cross-examination. She acknowledged, sitting here, when Mr. Keys asked her about, "Where's his phone? You said you took the phone." You heard what she said. We took his gun away. We took his gun away. I don't have to prove flight beyond a reasonable doubt. I already told you that. You can infer consciousness of mind. And what does that mean? You run, you delete text messages, and you lie because you know she knew she did something wrong. The question about why Jennifer Crumbley didn't take one of these small actions, secure the gun, find out where the gun is, it looms large in this courtroom. There is no one it looms larger for than the victims and the family members of those kids who were killed on that day. We don't have to prove why. But remember what she said. I wouldn't change a thing. Just hours ago, she said, I wouldn't change a thing.
She did say that.
This prosecution is about nothing else except the facts of this case and what Jennifer Crumbley did and what she didn't do. If only I could look at the faces of these parents who are dealing with unspeakable darkness and grief. If only I could make that better. I could appease them, as defense counsel suggests, by charging Jennifer Crumbley. These are the parents of Hannah St. Juliana. These are the parents of Madison Baldwin. These are the parents of Tate Meir. These are the parents of Justin Schilling. And not just their parents. They are mothers and they are fathers and they are sisters and their brothers. And do not think for 1 second that this prosecution takes any of that pain away, because it doesn't. This isn't an effort to appease anybody. Your verdict means one thing. It means Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter beyond a reasonable doubt. And I am not going to stand here and tell you that that's going to take away this pain that these families feel, because it will not. I won't stand here and say that the pain will be gone for Molly Darnell, or Christy Gibson Marshall, or Special Agent Brandon, who ran out of that office so quickly that his chair was spinning, or Ed Rogrowski, who viewed the surveillance video to identify the path of the shooter, and it was burned in his brain forever. Or for Lieutenant Tim Willis, who answered the call to lead, and maybe the biggest ask of his entire career, but one he did not back away from. Don't render this verdict for the hundreds of kids in that school. It will not appease them. Nothing will. But you are now called upon. You are called upon. You are called upon to do your part as jurors, to keep the oath that you took to be fair, to be honest, to be impartial. You are the ultimate fact finder. But what happened that day? You are the ultimate fact finder of the truth. We have met our burden. We have proven beyond a reasonable doubt that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter for failing to exercise ordinary care when the smallest, tragically simple thing could have prevented it. It could have saved Hannah. It could have saved Madison. It could have saved Tate. And it could have saved Justin. And she sat here and she said she wouldn't do one thing different. And lastly, I'm going to address the question I know that on the minds of a lot of people in this courtroom and a lot of people listening. I'm going to say what I know they're all asking and they want to say. When she took the stand and she testified about her own loss, and she was asked the question, "You lost everything?" She said yes. She hasn't lost everything, ladies and gentlemen. Her son is still alive. Find her guilty of 4 counts of involuntary manslaughter. Thank you.
Thank you. I have to have you come back Monday. But you know that, right? You knew that before I said it. You guys have been so terrific. You've been on time. I have not heard, I still have 5 alternates, right? Because no one, as far as I know, has violated any rule, has read a newspaper, has posted anything on Facebook, has talked to anyone who talked to someone else who repeated it to the court. We appreciate that. You know how hard it is. I'm going to ask you to come back Monday.
They're probably like,
But I want to instruct you that during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth. The lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media. Do not post on Facebook. Do not read Facebook. Do not do research. Do not discuss the case with anyone. I'm going to ask you to come back on Monday. You'll all come into the courtroom. Can you come back at 9 o'clock on Monday? I'm going to give you instructions. After I give you the instructions, 5 of you will be drawn by lot, but you will still be sequestered in a separate jury room. So you'll still be required to be here. All right, do you have any questions about the schedule? Did you all order lunch for Monday? All right. No questions about the schedule. We have come this far. Please follow my instructions. It's very important to both sides. We appreciate you. Have a good weekend and stay healthy. All right?
All rise for the jury.
well, I am a little disappointed they didn't wrap this up today. It didn't take them 2 hours to start. They probably would have gotten done today, but that's what it is. It sucks that we have to wait the whole
I'm gonna let the jury
weekend.
go. Okay, you can be seated. I'm gonna let the jury go, so we'll wait. I think I said this before. I'm going to have all the jurors come back on Monday morning. The captain graciously volunteered to have deputies here late into the evening, but it is late enough that would be very difficult. So at 9 o'clock on Monday morning, I'm going to instruct the jury. I'm going to have the 12 jurors deliberate, but I'm also going to sequester the 5 alternates. All right, any questions about that?
No, thank you, Judge.
No, Judge.
Thank you. So can you wait till the jury's gone?
Wait till I hear something.
Okay. All right, yeah. I'm gonna check, so thank you. Have a good weekend.
Thanks, Shannon.
So I guess Monday's jury instructions and then deliberations. I guess we'll start at 9, I guess? Or do we start at 10? I don't know. I don't know what to do. We start at 9 or 10. Shannon, let me tell you something. I think she was putting on an act throughout this trial. I think that lawyer was right in some of the parts that I heard him talk about, where she's putting on like acting out or having all these mistakes or whatever, and then apologizing. Which nothing wrong with apologizing. You can make a mistake, but like she's doing this to put on like she's this regular person, just. But then you see how she did the closing. She did a good job with the closing, maybe minus attacking or worried about the TikTokers and the internet couch people. She addressed them like a few times. You could tell that TikTok shit bothered her. We gotta take up the TikTok video. I thought that was a little kind of like, come on, girl, like worried about this TikTok shit. But she had to fight. She had to snap back, and she did it publicly on TV or publicly televised, so everybody can see snapping back at the TikTokers. So I don't know if the TikTokers are gonna fight back. They might snap back too. Let me see the TikTok video. I can't. It has. I think it has copyright music, but I'll just mute it. I don't think. All right, let's see what's happening here. Oh, I muted it. There we go. Oh God. I posted the wrong one to Twitter. I thought it was. An infamous essential oil bath in a courtroom aired on national broadcast. And that's when the guy was still there. I don't know what happened to this guy. They deep sixed him. Somebody got rid of him. He tossed his ass. Let me see if I think BL might have sent me. Oh, BL sent me the compilation. Oh yeah, OG.
It's awful. It's the prosecution that's parading all of this up here and putting
parading
the best I can. And I have to
Hold on, what the hell is taking so long?
And I've been here for 8 hours a day this whole week.
Whoa, no. Jesus, what's wrong with you?
The whole stroke is mine.
I'll get the TikTok. 1 second. Trying to shut this whole stream down.
The green strip is mine.
It's awful.
There it is. Shannon Smith compilation. I love it. Jen. I think Shannon Smith did good. I think she was put on an act throughout the trial. Now all of a sudden she's top lawyer performing and stuff. She was just trying to relate to the jury. I'm a mom. I'm normal and blah blah blah. You know. Let me see your text messages. See what they say about you. She didn't do bad at all. I think she did better than prosecution, honestly. I don't know. It's still enough though for not guilty. I'm gonna get the super chats too in a second here. Just want to see them walk her out the court. Y'all want to do a poll? Let's do a poll. Guilty, not guilty, or hung jury. Oh, all right. Let's check this out. Compilation.
It's the
prosecution that's parading all of this up here and parading the best I can, and I have to sleep at night, and I've been here for 8 hours a day this whole week.
As if nobody else has been there 8 hours the entire, like, we've all been here. I mean, I get she's the lawyer and she's actually doing the work and stuff, but all those other people, the attorneys and everything. But she's right though. I mean, the state has like 12, 15 people or something. Is the doing the hair, throwing it back, sprunking around. Oh wow, she even did the herbal essence thing. Wow, she did. That's when she's shopping.
I'm not positive
The audio was not on, right?
The audio? I can turn it off.
Sorry.
He had
it off. Clear your cache. I don't know how to say that. Clear your cache. Correct? By clear your cache, I'm going to say cache because I don't really know how you say it. She says.
Could you disassemble the Leaning Tower of Pisa?
Oh, sure.
Honestly, it looked like it was. I would hate you to have to reconstruct that. It just looked like it was gonna.
Imagine if that thing fell in court. The one thing this guy did, and not even that, he was like, I think she rebuffed him.
Tip and
get off my shit! Don't touch it. Back out of here.
Put it together, and that would take.
Yo, you never saw this guy again. I don't know what happened to him.
I'm hoping you're going to be.
To be fair though, I mean he's dealing with her. So.
If a person has a Facebook account that they deactivate, okay, let's. I'm gonna go even slower. When someone has a Facebook account, other people in the world have the ability to see that account. Correct?
If it's public or your friends or whatever other security you're setting, but yes.
However you have it set up,
yes.
You allow who can see the account and who can't, correct?
That's correct.
If you do have an account and you don't want the world to see it, if you deactivate the account doesn't appear when people look for you on Facebook. On my way to court today,
oh God, Taylor Swift.
I blasted Taylor Swift to warm up my voice and calm my nerves.
Oh!
And there was a line in one of her songs that summarized what this case is about. Band-Aids don't stop bullet holes.
All my eye makeup's still on. I checked my camera.
I'm not having.
I need to run to the bathroom. I need a break.
Okay.
I don't know if it's an act or not. Well, all of a sudden she's well put together and she was firing off in that closing. Part of me thinks some of it was like an act. I don't think she's dumb. I think it was a part like an act. Now all of a sudden she's top attorney, firing shit up in the courtroom. Let me get the super chats. Courtney says, Gismel, you should cover every trial. Female rapper Elite, thank you for the super chat. Carolina Bella, thank you for the 5. The first super chat on the stream. Thank you, Carolina. Thank you. Female rapper Elite. Now I want to search TikTok because she promoted. I want to find that sorry compilation. Somebody find the sorry compilation. Female rapper Elite, thank you for the super chat. Says the hearsay is irrelevant. Welsh Dragon, thank you for the 5. Still can't believe didn't search bag after shooting video. I know. Bullet search and drawing nuts. How they're not going to search the bag? The school or the parents? Either or. Amy, thank you for the 11 months. Can we find other videos of Shannon in court? Not this stream, but we can do it at some point. We can. She represented that guy, Lazar, or whatever his name is, that allegedly, I don't know if they found, I think they found him guilty. Did a bunch of stuff to her kids or adults. I think it was, I don't know, some coach, gymnast. Eliza, thank you for the 10. Gracias, Mama 4 Rose. Thank you for the 5. Thank you for Mel and Mods. Brit Focus says, cash me outside. Shannon, thanks, Mel. Thank you. Jennifer Park, thank you for the membership. Boots and Cats, thank you for gifting a membership. And Energy M, thank you for gifting a membership. Stacy B, thank you for the 5. Says, anyone else worried for Shannon's kids? Oh, man. I know what she was trying to get across. Some people, again, I don't have teenage kids and stuff, but I've had friends. Some of the way they talk. Well, friends of friends, some of the way they talk to their kids or about their kids, it's kind of not specifically what I would do, but I understand some people got a bunch of kids. It's wild, and so some people are like, I want to kill my kid. Some people are like, oh, I can't stand the motherfucker. Shit like that. Right, and then they actually do it or something, and you're like, oh shit. But some people are kind of like that. They talk about, they're kind of, oh, this little shithead. She's like, I drink too. I have a drink or two or a bottle. I was like, oh shit, okay, Shannon. Shannon was lit. All she was to me is like relating to the jury. But I feel like they're gonna see through some of that. I think the TikTok stuff, I mean, for entertainment, cool, but I don't know if that's the best look, shooting back at the TikTokers and the keyboard warriors. But hey, she did it on a public, who knows how many platforms that was on, right? Who knows, dozens, more than that. She snapped. Little keyboard warriors. I was like, oh shit, you better watch out too. These people are crazy. Oh yeah, I'll show you keyboard. That TikToker's gonna be mad. This is all free advertising for her, true. That is true. That is true. That is true. Let me see what this is. Oh, thank you. This is from, I got a PayPal. The 20. Veronica, thank you so much. Thanks, Bill. You're hilarious. Love this community. Thank you. Gracias, gracias. I just want to lay down now. I think we might come back tonight, actually, though. We'll see. I'm thinking the Kansas City. I think we maybe come back. I'll see if I find enough stuff. If the stuff develops, I come back for a little bit. I actually predict we will. I got to get my mother her mouse. I think I'm gonna go to Best Buy and go get a mouse and bring one over. Lawsuit's been filed over talking ish about people online. Yeah. Wednesday's Child, thank you. Bernie Heaven, thank you for the 5. Thank you, Mel. I'm watching from the UK. Cool. Thank you, Mel. Will the school trial be streamed? School trial? What school trial? You talking about the lawsuit? I don't know if the lawsuit will. That'd be interesting. Mustard Mama Sleuth Investigate. Did I get your super chat? I feel like I didn't read it. I didn't read your super chat. How did I miss that, right? Did I read it? I'm losing my mind. Oh, it disappeared. Oh, no. Wait. I don't know why it disappeared from my fan funding, even though I see you on the chat box. So Sleuths Investigates. Thank you for the 50. Appreciate that. Gracias. It says, wait. They only need one no from a jury. Did I hear that right? Thank you in advance for clarity. Thank you, Mel, for covering this trial. Next trial will be, yes, Harmony Montgomery next week. So Monday we'll come back for the deliberations and stuff. Tuesday, I think, is jury selection for Harmony Montgomery, Adam Montgomery. We're not going to be here just for jury or a selection, but once they start the first day, we will be here. And so she says, wait, so they only need one no from the jury? I think she said, as far as reasonable doubt. Right? One reasonable doubt, I thought she was saying. I thought that's what she said. That's what she meant. If that's what you're talking about. We might do we could do like a members thing, Ricky and Fred. Maddie's playing with them right now. Thank you, RD. It's Friday. We made it. So we'll see what happens later. I'm a little tired. Oh, make sure you subscribe to the second channel. I think I'm going to go take like a shower, like a cold shower, reset. Subscribe to Ick and Mel CC because I'm posting videos on there as well. Okay, you type in ICKEDMEL space CC on YouTube, or you can click the link in the chat. It'll pop me up because I'm posted on there, but I don't have any notifications. I'm posting on there. I think this week I want to go to the beach, take baby to the beach, the dog beach. I want to take him out this week. Take him. I don't think they've ever been to the beach. I gotta check. I don't think I haven't. I think that'd be fun. The only thing is I don't know how they're gonna be like with other dogs there. I might have to keep them on the leash. Naked Mel CC. But I'll come some point over the weekend for do a members live, especially with all the new members. Really appreciate you guys being with me on this journey. If it hasn't been that long, I guess this trial, I guess. Oh, did BL find it? Oh snap, BL.
Your Honor, on Friday, I think it was very clear beyond a reasonable doubt I have difficulty and cannot use technology. In my frustration, I made a comment that was offensive. Yeah. I am apologizing for that comment. I want to apologize to the jurors, to the audience. Well, it doesn't want to have started deleting like my photos after a year and flipped out. I'm going to fix it because I take photos of my kids.
Yeah, I think it's an act, man. Girlfriend, they're my girlfriend's dogs. Attorney Shannon Smith has unprofessional behavior and makes some inappropriate comments. I agree with Laura, Yeah, I agree. I totally agree with him. And I'm almost thinking part of this was an act. And now all of a sudden she's got a sober mind. That's that she wasn't sober, but like a clear mind. Before she was barely keeping things together and like all over the place, a mess. All of a sudden she got everything ready to go. And in sync for the closing. So, but all right, guys, I'll hit you up. We'll probably be back later at some point. I'm going to schedule the stream probably Sunday evening or whatever for Monday. And yeah, we'll see what the weekend brings. But for sure, I think later we'll come back to have a chill stream on a certain topic. Maybe like in, I don't know, a couple hours. It'll be nice if we get a chase, but I'm definitely not holding my breath. Okay, I'm not holding my breath because they've been slacking. The criminals. And that's the second channel right there. Almost at 13K. Look at that. We're about to be at 13K. How cool would it be to get to 100K on a second channel? That'd be dope as hell. All right, so check it out there. When I don't have notifications and just extra videos and content, I'll be posting on the second channel. All right. Naked Mel CC. Boom. Adios. Love you guys. Thank you so much for today. Bloop, bloop. Oh, what? Did I do the vote? Oh, the vote. 989 votes. 50% say guilty. 31% say not guilty. 19% say hung jury. So the other votes have increased a little bit. A little bit.